Good afternoon, all. This is Richard Hackett from Community Planning and Permitting staff. We are recording. You may begin.
Thanks, Rick. This is Commissioner Bloomfield. This August 17th, 2022 meeting of the Boulder County Planning Commission will now come to order. Due to COVID-19 concerns, this meeting is being held virtually. Information on how to participate in the virtual meeting has been posted on the Planning Commission webpage at www.evoco.org/PC. There will be an opportunity to remotely provide public comment on the dockets listed on the agenda during the respective virtual public hearing portions for each item. I'll provide instructions about that when we get to each docket on the agenda. We'll start with roll call. So answer here, if you would. Mark Bloomfield here. Sam Fitch.
Here.
And joining us later, Gavin McMillan.
Here.
Connor Kennedy.
Here.
Chris Whitney.
Here.
Okay. Reminder to the commissioners, please identify yourself before speaking and speak slowly and clearly. All votes will be roll call votes. Please keep your video on when possible during the hearing. Please remain on mute until you are ready to speak. When you begin speaking, please identify yourself as a planning commissioner, such as this is planning commissioner. It may help to keep your participant list open in Zoom so you can see who is speaking as the person speaking will be told. First agenda item is to approve the minutes. Are there any corrections to the minutes? We have a motion and a second to approve minutes.
Commissioner Chris Whitney, motion to approve the meeting minutes.
This is Commissioner Kennedy. I'll second.
Okay, so we'll do a roll call. Mark Bloomfield, aye. Sam Fitch.
Aye.
Gavin McMillan.
Aye.
Connor Kennedy.
Aye.
And Chris Whitney.
Aye.
Okay. So that's approved. Staff, are there any staff updates?
Kim Sanchez from Community Planning and Permitting. No staff updates today. Thanks.
Okay, we have 4 items scheduled for today's Planning Commission meeting. At this time, I'll take the opportunity to explain the public hearing process. There will be an opportunity to provide public comment remotely on the subject items for which we have specified. We will take public testimony during public hearing portions for each item. The order of presentation will be to hear from staff first, next to the applicant, and then we'll move to accepting public comment from any individuals who wish to speak. Some people may have signed up in advance and we will call on you first. If you did not sign up for public comment, you may sign up in the chat. Please direct your comments to the board. The chair will direct any questions that arise during the hearing to the appropriate party. Once we have heard all testimony, the public hearing will be closed. The Planning Commission will then discuss the application and vote to take action. All members of the public will have a chance to speak, even if you didn't sign up from the PC homepage beforehand. Once those who signed up in advance have spoken, I will call for any additional members of the public to speak. If you join by computer, you can sign up by submitting the first name, last name, address, and the docket number in the chat box to the right. Each person who is joined by computer and signed up to speak is unmuted. Zoom will adjust your participant status so that you can speak and be seen via video. Once you are finished speaking, Zoom will place you back in the room as an attendee. If you dialed into the meeting via phone, please raise your hand by pressing *9. We will unmute you when we call on you to provide, and we will call on you to provide comment. When it is your turn, the system will request that you unmute yourself with *6. Once you are unmuted, please state your name and address for the record before providing comment. Each speaker will be allotted 3 minutes to speak. A timer will beep at the end of your speaking time. You can also pool time at 3 minutes per person for a maximum of 10 minutes. You'll need to provide the names and addresses of the other people, and they will need to be in attendance. Please do not submit comments or questions in the chat box during the meeting. The chat box is for speaker sign up only. Please remain on mute when possible. The moderators will mute you if we see that your connection is the source of background noise. Members of the public will be unable to share their screens during public comment. Applicants, please have your presentations pulled up and ready to go. I will announce when we are ready for you to present, and at that time you can share your screen. Okay, so we'll start with public hearing for docket SU-22-0005, the Drogsvold vacation. We'll now hear from Ian Brighton. Will you please present the staff report?
Good afternoon, everyone. My name's Ian Brighton. I'm a planner for community planning and permitting at Boulder County. Give me a moment to share my screen and we'll jump right in. Can everyone see my screen? Oh, actually, sorry, I always forget to hit that last button. Now can everyone see my screen? All right, fantastic. So we're going to be reviewing SU 22-0005 Drogsvold vacation rental at 46877 Peak to Peak Highway. So the applicant owner are Bruce and Susanna Drogsvold. This is in a forestry zoning area on a 2.83 acre lot. It's a blot, and existing is a 1,859 square foot residence. The proposal is special use review request for vacation rental of 244 days for up to 4 guests with a minimum stay of 2 nights. So this is just the vacation rental definition. Vacation rentals cannot be the primary residence of the owner, and vacation rentals must be applied for if the unit is rented for more than 60 days per year, which is the case here. It's permitted in forestry districts under special review if it's under 5 acres, which is also the case here. Parking requirements is 1 space per sleeping room in addition to 1 space for the local manager, and all parking must be on site on the property. So we have 3 sleeping rooms in this particular residence, plus the manager equals 4. So we'll be looking for 4 parking spaces. Additional provisions for all vacation rentals are that they must maintain a valid Boulder County vacation rental license. Vacation rental may not be marketed or used for weddings, receptions, or similar private or public events. And that accessory dwellings are also not eligible for this use. This is the vicinity map showing the location of the subject parcel, which is just south of Overland Road and north of Ward. This is the subdivision map. It is not within a subdivision, but it is adjacent to one. Here's an aerial view. The south of the property borders the South Sambring Creek, which crosses under the highways, the Peak to Peak Highway, just to the east over there. You can see the home up here, up on a little cliffs overlooking that river. Here's the comp plan map. Few resources here to note. It is within an archaeologically sensitive travel route. It is within a wildlife migration corridor, at least adjacent to one. There's certainly riparian areas, wetlands, and riparian habitat connectors associated with the river. And it's also along the Peak to Peak Scenic Corridor, which is our most, in the way that we measure it, the most valued scenic corridor that we tried to protect. Public lands, there is some U.S. Forest Service land around, private conservation easements nearby, and the county conservation easement across the road there, so technically adjacent. Here's the topo map. You can see that cliff a little easier here on this map. So essentially the residence sits on a cliff. It slopes to the north, down to the north from that residence. And their access drive kind of comes up that flatter area there next to State Highway 72 Peak to Peak. Geological hazards. Looks like there's a little bit of debris flow susceptibility areas within the parcel, but nothing too major. The floodway, so a portion of the property is within the floodway and the 500-year floodplain. However, there's no construction proposed as a part of this request, and the existing residence is out of both of those areas. So here's the narrative provided by the applicant. They've owned the property for over 30 years. It's an old homestead rock home on a cliff above the South St. Vrain. They are Wildfire Partner certified, Septic Smart certified, and they use the Energy Smart program. For 25 years, they did long-term rentals. However, 5 years ago, they switched to Airbnb, which works better for them because they can now access the property and they feel the guests respect the property. Here's a floor plan. So a pretty funky floor plan here. You can see there's a second story upper level sleeping room. Beneath that is a living room, primary bedroom, and a dining room. There's a kitchen and a couple more sleeping rooms and a study. And also included is a garage and a shed. Here is the parking plan they've provided showing 6 spaces. Yeah, so the spaces are located just to the west of the existing house and studio. You can also see to the west of that is the garage shed. This was the OWTS site plan they provided. We wanted to see this to make sure that the parking didn't cross over any of the septic components. So they do show the septic tank and leach field to the southwest of the existing house studio. So here are the site photos. You can see the main residence, the main portion of the house here with that connected studio. This is all connected as one continuous building. Here's the backside kind of showing how it's stepped down and all kind of connected. Looks like several log cabins mashed together. Here's looking on their back porch that looks over the South St. Vrain. I love this kind of old rustic rock construction combined with the wood cabin look. It's a very picturesque cabin. Here's looking from the side. This is their garage, which is located to the west of the main building. Another picture of the garage. This is looking to the northwest. This is just a sort of a dugout I saw on the property, so I took a photo of that in case it had any historical significance. I somewhat doubt that, given that wood likely wouldn't last that long, but I wanted to document that. So here are a couple fire pits we found on the site as well. So these will need to get mitigated. I have been in conversation with the applicant about ways to mitigate these so that they're unusable to guests. You know, there is a historic component to these as well, being part of this old cabin. So we're looking into ways to adaptively reuse these either through partial removal or turning them into garden beds, flower beds, those types of things. Here's a photo of the parking areas identified. I do believe they have a sufficient space for those parking areas. We will need to ensure that those parking areas stay off of any OWTS components. Here's some other additional parking areas that they have for overflow and potentially where, for instance, the manager could park if needed. Referrals, building staff, our building inspection staff noted that a building inspection will be required as part of this. Our wildfire staff mentioned that they must maintain a wildfire partner certificate and that owners must display wildfire prevention and evacuation information for guests. Outdoor fires are prohibited. Public health, OWTS is sized for a maximum of 6 people. A commercial OWTS use permit is going to be required if the home is not occupied by the owners. They also recommended supplying information to renters about the proper operation of an OWTS system and that the renters must not park on or over OWTS components by marking the areas. Access and engineering noted that 3 parking spaces are required for 2 sleeping rooms. An emergency pullout is required for driveways exceeding 400 linear feet. Drainage along steeper sections of drive, along the steeper section of drive must be addressed. We did see a little bit of drainage issues out there, and an access permit must be obtained. We did receive 2 comments. Both were in opposition. The concerns were about visitors not being invested in the area, increased traffic impacts, fire concerns, trash, and impacts to wildlife. There's no construction proposed, so floodplain. It didn't have any issues. No concerns or no conflict also from Boulder County Conservation Easement Program, CPMP, Historic Review, Excel, and Parks and Open Space. We had multiple agencies provide no response. So our evaluation, I won't go through all of the criteria, just the ones that are the most pertinent to this particular application. Number 2 talks about the use being compatible with the surrounding area. So there's no changes to the buildings proposed, so we're just looking about the use as being compatible. And these upper mountain areas do have quite a few second home cabin situations, and we feel that use is compatible with the historic use of the area. Number 4, the use will not result in an over-intensive use of land or excessive depletion of natural resources. So we look at that in terms of the use, what the use would be like for a single family residential, which is approved out there at the moment. And we feel that the use is comparable to single family residential. Number 6, the use will not require level of community facilities and services greater than that which is available. So the OWTS system is sized for 6. However, the applicants are proposing a maximum of 4, which is under that. So no concerns there. Moving along, the use will support a multimodal transportation system and not result in significant negative impacts to the transportation system or traffic hazards. So no concerns there. However, we do recommend clear directions and address signage at the highway, just because it's a little easy to miss and turn into the neighborhood drive versus their private drive. So just having easy to find signage would help mitigate that issue. Number 8, the use will not cause significant air, odor, water, or noise pollution. So we do recommend quiet hours due to the proximity of neighbors. 9, the use will be adequately buffered or screened to mitigate undue visual impacts. So again, they're not proposing any construction, and the parcel is already well screened from other properties. Number 10, the use will not otherwise be detrimental to the health, safety, and welfare of inhabitants of Boulder County. So we have no concerns with the removal of fire pits, which should mitigate those potential fire hazards. Number 12, use will not result in unreasonable risk of harm to people or property. We're not concerned with that as long as evacuation material is to be provided. We recommend they provide that for both fire and flood events, given the proximity to South St. Vrain, and many of us have experienced the 2013 floods where all the highways got shut down. So it's good to understand how to get out in those situations. So the community and planning and permitting staff recommends that the Planning Commission recommend conditional approval for docket SU 220005 Drogsvold vacation rental, subject to the conditions outlined in the staff recommendation.
All right. That Ian, does the board have any questions?
I have 2 questions. Ian, thanks for your presentation.
What's your name, Gavin?
Is there a requirement or condition of approval? I didn't see it, or maybe I missed it, to remove those fire pits, or is that just something you've discussed with them?
It is a requirement. They will have to remove it. The discussions revolved around what we would accept in terms of removal, and what I mentioned to him is removal would be inaccessible to guests in terms of having a fire. So for instance, he was talking about trying to preserve the chimenea potentially, and I said, well, if it was locked off somehow, that a guest couldn't start a fire there, then we would accept that.
Okay, but that's not a current condition of approval. That's just your understanding with the applicant or is that written in here somewhere?
The removal of fire pits is written in there. That is a condition.
Okay.
I think the question is what constitutes removal. And in situations where they may be historic, we look at adaptive reuse. But again, it needs to be absolutely unusable to a guest is really the bottom line. So.
Got it. And then my second question is, there's a minimum of 2-night rental period. And I don't know if that, you have to remind me, is that a condition that we've been putting on these, all of these rental permits, or is that something that this applicant specifically has suggested?
That's something that this applicant has suggested. And I believe it is actually a requirement for vacation rentals, but I'm actually not sure about that. I wonder, maybe Kim can weigh in if she knows for certain, but I believe it is a requirement, 2-night minimum.
It's Kim Sanchez. I don't think it is a requirement, but I think we're just approving what the applicant proposed. I'm assuming Ian can confirm.
Okay. Great. Those are my 2 questions. Thank you.
Thanks, Kevin. Any other questions for staff? Okay, seeing none, for the applicant to make comments or give a presentation if they have one.
This is Anna Milner, staff. I've just promoted Bruce as panelist. If we can just give him a moment.
Okay, Bruce, when you're up, if you can state your name and address and then give your statement or presentation together.
Hello, can you hear me?
Yes,
Okay, I don't think you can see me. Can you see me?
cannot.
Okay, so I'd like you to be able to see me as well. So let's see. Oh, I'm sorry,
Hello, Bruce. This is Anna Milner, staff. If you go to the bottom left corner of your Zoom screen, there's a start video button. If you just click that, we should be able to then see your video.
okay. Suddenly my Zoom screen is missing. Can you get me back on return to meeting? God dang it. There.
Perfect.
You
We can
just-
see and hear you. Yes.
Okay, I can't see anybody right now. So should I just begin? Well, I'm going to just begin. Thank you for giving me the opportunity to speak to you today. And I'm going to just read what I've written to be kind of efficient. I'll welcome any questions that you have concerning this property. So my name is Bruce Drogsvold. My wife Susanna and I live at 1527 5th Street in Boulder. We are applying for a vacation rental so that we can continue doing short-term rentals at our property located at 46877 Peak to Peak Highway, Ward, Colorado. I want to share a little background for you today. We've owned this property for 30 years. The property is 2.8 acres and South St. Vrain Creek runs through it. It includes the old rock and log home that you just saw some photos of. We're bordered on the west by the 320-acre Camp Tahosa Boy Scout camp. We're bordered on the north by 4 other properties that Susanna and I have owned for a long time. There are no neighbors to the south and to the east on the other side of South St. Vrain Creek, and closer to the Peak to Peak Highway is the old Ogallala Lodge property. That lodge burned down in the 1960s, and the present owner rents the property to long-term tenants. Practically speaking, we do not have close neighbors. Our house is a sturdy rock and log cabin built according to public records in 1937. Our own research shows that the house was more likely built in the early 1920s by Joe and Grace Buckley Stapp after World War I. An interesting thing about our property is that it is an old homestead property. We have a chain of title that shows President William H. Taft deeding this property to Sarah Cheeseman in 1924 as part of the 1862 Homestead Act, called "To secure homesteads to actual settlers on the public domain, subject to any vested and accrued water rights for mining, agriculture, manufacturing, or other purposes." We hope our purpose can be to provide a very nice getaway for out-of-town guests that hope to experience the beautiful Rocky Mountains in a unique and special way. We feel qualified to provide a safe, rich, and refreshing experience for them. Susanna and I have taken good care of the property for 30 years. We are Septic Smart certified. We participated in the Energy Smart program in 2017, and we made approximately $20,000 worth of energy efficient upgrades, including foam sealing our crawl space and installing high quality aluminum clad double pane windows, and a lot more. We are Wildfire Partners certified. Every 2 years, we do a complete minerals water quality test on our well, even though it is not required. We have good potable water, and we've never had a problem. After the 2013 flood, we completely replaced the old water lines and the well pump, so our entire water system is relatively new. The gas line from our propane tank and our gas regulator are both less than 1 year old. The electrical panel is less than 10 years old, and we had a whole house electrical inspection less than 4 years ago. We keep a landline telephone in the house to allow someone such as the Indian Peaks Fire Department to call us in case of an emergency. 2 years ago, during the Calwood and troublesome fires, our guests actually got such a phone call telling them that there was a mandatory evacuation for all of the residences in our area. For the first 25 years that we owned this property, we rented it out long-term with a year-long lease. We did not enjoy that arrangement at all. It was a revolving door. Tenants came and went. We didn't get to use or maintain our own property because of the long-term leases, because we had to respect the tenant's right to privacy. That's why today it is exciting for me and Susanna to have this opportunity to get licensed. We will finally be allowed to legally do short-term rentals. Our homeowners insurance will also cover our short-term rentals as well. Back when Boulder County decided to regulate short-term rentals in Boulder County, we were unhappy and felt it was too intrusive at first. We wondered, why should short-term rentals be held to such a high bar when long-term rentals are not held to that same higher standard? We don't feel that way anymore, and our opinion has changed. Short-term rentals are, in fact, very different from long-term rentals. There are different issues. We now understand that it is of utmost importance that short-term rental hosts get educated to have at least a minimum level of competence and awareness about the implications of allowing someone unfamiliar with the life and the issues in our mountain community when they stay at a short-term mountain rental for a week or less. We believe this vacation rental application process contributes to a safer environment by improving the quality of the housing stock and the awareness of the folks who want to host short-term visitors. This is all I have to say today. Thank you for the opportunity to speak to you. And do you have any questions for me?
Does anyone on the board have any question for the applicant? Not seeing any, so thank you for your comments.
Thank you.
Does staff have any response to the applicant's comments?
No response to the applicant's comments, but I did have a chance to look through the vacation rental definition in the code and wanted to respond to the question about the 2-day minimum. So it doesn't appear that we have a day minimums or even occupant minimums. I think that's really driven by the OWTS system and then also what the applicant provides. There may be stipulations in the vacation license part, but my quick Google search, I didn't turn up anything, but in the code, it's not in there. So.
Okay. Thanks, Ian. Anna, it looks like we have one sign up. Is that right?
We do, Mr. Edward Gaggi. One moment and I will promote him.
Well, I have to go through my spiel first. Again, I'll just repeat. And once those who've been spoken, I will call for any additional members of the public to speak. If you join by computer, you can sign up by submitting your first name, last name, address, and the docket number in the chat box to your right. As each person who is joined by computer and signed up to speak is unmuted, Zoom will adjust your participant status so that you can speak and be seen by a video. Once you are finished speaking, Zoom will place you back in the room as an attendee. If you dialed into the meeting via phone, please raise your hand by pressing *9 and we will unmute you and call on you to provide comment. The system will request that you unmute yourself with *6. Once you are unmuted, either via computer or phone, if you have called in, please state your name and address for the record before providing comment. Each speaker will be allotted 3 minutes to speak. The timer will be at the end. Time can be pulled for a maximum of 3 minutes per person for a maximum of 10 minutes. You'll need to provide the names and addresses of the other people, up to 3 others beside yourself who are in attendance and donating your time to you. Okay. So it looks like Mr. Yagi, has he been promoted? Oh, there we go. Mr. Yagi, I will warn you before you begin, you may have your 3 minutes, but I won't tolerate you impugning the staff in your comments. Please proceed with your name and address. Mr. Yagi?
Yes. How are my audio and video?
They seem to be okay.
Okay, can you hear me all right?
Yes.
My name is Edward Yagi, and I am co-owner of 5th Generation property on Big Owl Road in Allens Park. I support the current applicant, SU 220005. Short-term rentals are a net plus to the community, and the county's claims to the contrary are unsubstantiated, dishonest lies. Your STR policies are irresponsible and dangerous. At a public hearing on August 4, I detailed how these rules, which you are endorsing with today's hearing, are potentially inciting the exact kind of gun violence you say you don't want. You say that you want homeowners to do fire mitigation. What you are doing with STR suppression is destroying rental income without which much fire mitigation cannot be done. What you do is fail to keep our roads properly maintained. Big Owl Road this summer was in the worst condition I have seen in 60 years. You failed to open our forestry sort yards, which only operate a few weeks a year anyway, on time. Your bad governance follows 7 predictable steps. 1, fail to provide basic services, including answering taxpayer questions. 2, delude yourself into thinking that your petty authority can solve national or global problems like climate change, violence, and housing. 3, draft bad rules that make things worse and more expensive for everyone. 4, hold 1 public comment session at the same meeting where you have scheduled a pre-decided vote. 5, ignore internal dissent and don't even pretend to listen to the public, the majority of whom oppose the new rules, often by a huge margin. 6, approve the expensive and typically incoherent new rules, often with no way to administer or enforce them. 7, repeat steps 1 through 6 with a different issue. You can waste $500,000 a year for a horrifically wasteful diversity guru, but you can't find a college student to work 10 hours a week in Meeker Park over the summer. Failed states have more competence and honesty than you do, and I'm not the only one who thinks so. Here's what one citizen wrote regarding accessory units. I understand that the published proposal was not what was drafted by planning and that the commissioners came in over the top with their own opinions. Why did you even ask for our input? All you have done is cost our neighbors time and money under the false pretense of community input. Many are afraid to speak out as they need the cooperation of planning and permitting to rebuild their houses, but you have completely missed the mark with this proposal. I know that I am not alone in saying that the proposal was arbitrary and capricious. So wrote taxpayer initials AF, June 20, 2022. So listen up, Boulder County. Repeal your stupid STR rules. Answer your phones. Fix our roads. Establish and enforce a code of conduct and ethics rules. When a taxpayer sends you an email, answer it. Only after these basics are met should you be holding any kind of hearing like this one. Otherwise, shame on you all. This concludes my remarks.
Thank you, Mr. Yagi. Does staff have any response? Oh, sorry. I didn't close public comment. Anna, do we have anybody else signed up? I don't see anyone.
We do not. We do have a number of individuals called in via phone. If you're on the phone and you'd like to speak, please press *9 to raise your hand. Chair Bloomfield, I'm not seeing anyone indicating they'd like to speak today.
Okay. Seeing that, then I will go ahead and close public comment. And so now I'll ask if staff has any response, or if the applicant has any response to public comment.
I'm sorry, you were broken up a little bit. Did you ask for staff response?
Yeah, I was asking if
Okay.
staff for the applicant comment.
This is Ian Brighton, CPMP planner. We have no response.
Okay. So we'll go ahead and close the public hearing then, and we'll move to discussion. Does anybody have any questions for staff? Or for the applicant? Discussion. Okay, not hearing any.
Commissioner Bloomfield, this is Commissioner McMillan. I don't know if anyone else is having this trouble. I'm having a little trouble hearing you breaking up now and again.
Okay.
Maybe turning on video or might help a little bit.
Yeah, thanks for that. So I was just calling for discussion from the board.
Yes, this is Commissioner McMillan. I believe the application meets the criteria for approval. I do think it's important that the fire pits are removed, so I'm glad to hear that's a requirement. I asked a question about the minimum stay because I think it's been our policy to commit to whatever the applicant has suggested will be their policy, and I think that's fine. If they have suggested, that's how they'll operate. I just want to be consistent with how we're applying the rules of the ordinance between all these that we hear. And so if it's the case that we are in fact just matching what they have proposed, then I'm fine with that being part of the conditions of approval. So I'm okay with the conditions of approval as written, and I would be able to put a motion forward if there was no further discussion, but I'll leave it open to my fellow commissioners for additional comment.
And this is Leanna James, Assistant County Attorney, and I may have missed it because Mark Bloomfield was breaking up, but I wanted to make sure that we gave the applicant the last chance to respond before moving into discussion.
I apologize. I did say that. I don't know if it came through. Mr. Drogsvold, do you have any comments?
I think that again, after hearing the comments, that I do respect your process, and you know, I do think there is a difference with short-term rentals and the fact that visitors do come and they're not familiar with our world up there, and it's a different kind of world for a lot of people across the country. And the fire pits, we're very comfortable figuring out whatever will be appropriate. Right now, we strictly forbid any of our guests to be able to light any fires on our property. There's no guns allowed. There's no ATVs allowed. We don't want industrial mentalities. We want, you know, people who really appreciate the wilderness, and so I think this is the kind of world that we're hoping to create up there. So thank you for giving me the time today.
Thank you. Okay, so
Commissioner Whitney, sort of one comment and then a question. Just as in addition to the fire materials, often we have talked about including current fire ban status in kind of that packet you give rentals, just as a note for the applicant. That's also generally a good thing to include in the paperwork you give applicants, just because out-of-towners may not understand the current fire ban status in Boulder County at any given time. And then my one question was, I don't know if I saw a snow removal plan, which we often discuss in vacation rentals as well. And that was my question as well for the applicant.
Okay, I'd be happy to answer that. The reason on our own, before this licensing process became a thing, a year and a half or 2 years ago, we disallowed, we just didn't open up our cabin to be available for the very reason that you're thinking about in terms of snow. Somebody comes from Florida, they rent a car at DIA, they don't have snow tires, and suddenly we've got 3 feet on peak-to-peak highway, and we just didn't want that sort of liability in the first place. From time to time, we can't even plow our driveway with a snow plow. We need a backhoe, you know, so it's can be pretty serious. So I don't want guests stuck up in the cabin, kind of like Dr. Zhivago or anything of that sort. So we do take good care of it. We have a local guy, Jesse Farmer, high altitude backhoe, and he's been plowing our driveway for a really long time. He was born and raised in Ward. And so I hope that answers your question about that.
Yeah, Commissioner Whitney, yeah, that's exactly what I was looking for, just to make sure you had kind of contracted snow removal if you needed that for a guest, you know. So that answers my question.
okay. Any other commissioners have any comments? Okay, Gavin, I think you said that you had a motion.
Yes,
Nice.
Mr. McMillan.
I still cut you off.
No, I hear you now. Sorry. Dramatic pause. Commissioner McMillan, I recommend that the Planning Commission, I move that the Planning Commission recommend conditionally approving docket SU-22-00005 Drogsvold vacation rental with the following, with the 14 conditions of approval in the staff report.
Commissioner Fitch, I second.
We'll go to a roll call vote. Commissioner Bloomfield, aye. Sam Fish,
Aye.
Gavin McMillan,
Aye.
Connor Kennedy,
Aye.
and Chris Whitney.
Aye.
Okay, passes unanimously. Thank you, Ian, for your time, and Mr. Drogsvold for your time. And we will now close that public hearing. And we will open the next public hearing. This is public hearing for docket V-22-0001, the Maedke vacation. Apologize if I didn't pronounce that correctly. We'll now hear from Pete Laurent and staff. If you would please present your staff report.
Good afternoon, Commissioners. Pete Laurent, CT&T Planner. Let me share my screen here. All right, I'm assuming everyone can see this. This is docket V-22-0001, Maedke vacation. This property is located up in the Gold Hill area along Sunshine Canyon. Aerial photograph. This is the existing configuration of the parcels on site. A little bit better. These are the 3 existing parcels. This is the alley. The applicant has requested that this alley be vacated and joined with their 3 parcels. This is part of a larger SE subdivision exemption request that will go to the Board of County Commissioners to combine the alley and all 3 parcels into a single parcel. The stated reason for this is that the applicant's well and cistern are located on this parcel, the red one, while the house is located on the green parcel. The proposed new parcel, again, that will be reviewed through the subdivision exemption process by the Board of County Commissioners, would look like this. A couple of site photos. The subject property is this green and brown house on the right side. A couple of neighborhood or area photos just to show the character. And then the location of the well. This is an aerial photograph with the location of the alley that has been requested to be vacated, shown in blue, the existing parcels in green, and in red is a commonly used hiking trail that goes up behind the house and up into the hills. As far as referrals, Boulder County Development Review Team, Access and Engineering, noted that the county engineer supports the vacation request as proposed. There are no public road improvements on the right-of-way, and Public Works Department has no future plans for that. The vacation of the right-of-way does not preclude any parcels from having legal access. Access and Engineering staff also noted that a copy of the recorded access easement for the shared driveway over 470 Boulder Street must be submitted to staff prior to recordation of the deeds. Likewise, an access improvement and maintenance agreement, an AMA, will be issued for the shared driveway during building permit review. Boulder County Parks and Open Space Natural Resource Planner noted that there are no natural resource concerns with the proposal, and the alley serves no public access purpose, and that the vacation and combination of the parcels should not result in any significant natural resource impacts. We had a number of agencies that responded with no conflict to the vacation, specifically Boulder County Public Health, Building Safety and Inspection Teams, the Wildfire Team, the Historic Preservation Team, and Excel Energy. We also had a number of agencies that did not respond at all. Staff received, notice was sent out to 93 property owners in the area, and to date, staff received 2 public comments in response, one opposed due to the potential loss of the hiking trail, and one not necessarily opposed to the proposal, but also concerned about access to the hiking trail. As noted in the aerial photograph, the hiking trail actually crosses the majority of it is located on the applicant's properties as they are currently configured, and vacation of the alley would not impact that access. As far as criteria for vacation. The section Article 10-100 of the Boulder County Land Use Code sets the standards for vacations. 10-100A states that they may be vacated after consideration at a public hearing by both Planning Commission and the Board of County Commissioners. This obviously is the Planning Commission hearing, and subsequent to this, the Board of County Commissioners hearing will be scheduled. Therefore, this criterion is met. B, portions of the road and alley vacated will be divided down the center line and added to the respective adjacent properties. In this case, the applicant has requested a subdivision exemption that would combine all of the parcels. Therefore, staff would recommend that as a condition of approval, if the SE is approved, that the alley be included in it. And likewise, if the SE is denied, that the alley be divided per this criteria. Therefore, as conditioned, this criterion can be met. C, application and process requirements for vacations are included in Article 3 of the Land Use Code. This application was submitted, referred, and reviewed per Article 3, including the Planning Commission hearing that we're having today and the planned subsequent Boulder County Board of County Commissioners hearing. Therefore, this criterion is met. D, following the approval or conditional approval of vacation, the applicant shall submit to the Land Use Department all necessary documents. The applicant, as a condition of approval, staff would recommend that the applicant comply with all conditions of approval. So as conditioned, this criterion can be met. And finally, the vacation becomes effective upon recordation of the board's resolution. Prior to that, the applicant must comply with and complete all conditions of approval. And the Land Use Department staff shall record the commissioner's resolution of approval with the clerk and county's recorder within 1 year. Therefore, staff would recommend a condition of approval that the applicant shall meet all post-approval requirements within 1 year after the date of the Board of County Commissioners resolution. Therefore, as conditioned, this criterion can be met. As such, Community Planning and Permitting staff recommends that the Planning Commission recommend to the Board of County Commissioners to conditionally approve docket B-22-0001.
Okay. Does anyone have any questions for staff?
Commissioner McMillan, I just have one. Is the hiking trail in question, is that an official trail or is it a social trail?
It is a social trail that has developed over time, and based on conversations with the applicant, and can confirm this with them, I believe they have no intention of closing that off to any of the members of the community.
Thank you.
This is Commissioner Candidate with a follow-up question to that. The applicant has no intention to be closing off that access point, but it is within their property. I just want to clarify that if they change their mind in the future, that it is within their right to be closing that social trail off to access.
That is my understanding, yes.
Okay.
Questions? Okay, is the applicant present for presentation or comment?
This is Anna Milner, staff. I'm promoting the applicants now.
Hello there.
Hi. If you can go ahead and state your name and address. And then feel free to give us
Sure. My name is Christine Maedke. The address is 412 Boulder Street, Boulder, Colorado 80302.
And do you have a presentation for us or some comments?
No, just some comments. So I appreciate all the work Pete's done. Thank you so much for all of that. My husband, Dan, who's on the call here, and we bought our house 2 years ago. just before the pandemic started, and it was so difficult to purchase this house. Trying to find a title company that was willing to work with this complicated piece of property. We have 3 different addresses, we have 3 different tax bills, and an alley running up through the middle, and we have a driveway, a main driveway. We have an alternative driveway too, but a main driveway that we don't have official access to. So it was challenging to purchase this, and we just need to go through all the steps to get it cleaned up so that it isn't a disaster next time the property tries to change hands. But the biggest issue was the fact that the water is on one side of the alley, both the well and the cistern, and the house is on the other side of the alley, and so they're not adjacent properties, technically speaking. So that's pretty complicated. The title companies weren't terribly happy with that situation. So, in the future, it would be great if it was just all one property. Somebody would have to buy the 2 main pieces of property, but that top corner property, we'd have to ask them to please buy that little chunk as well. The previous owner actually just quit claimed us that one just to make it simpler. So we're just really working to try to clean everything up. We did we're up in Gold Hill. It's a real small town. We did send an email out to the town, but fortunately I didn't know that those postcards were coming, so I wasn't able to get ahead of the public comments. But we sent an email out to our whole town explaining that we have 0 intention of closing the trail. We've actually done a lot to improve the trail and make it more user-friendly. We outlined it in stones. We put a bench at the bottom. We fixed up the stairs where there's stairs. We mulched it. And so we're very, very happy to have people on the trail, but it does, there's very little of it that's actually on any kind of public grounds. It starts on our property, and then it goes through the neighbor's property and up through the people who own the whole set of parcels behind us. So it is across private property, but we don't have any intention of messing with access to that. We welcome people. We're just trying to do what we need to do to clean up our property lines so that it makes sense, that we have one tax bill and one address, and we can sell it eventually if we want to. That's all I have.
Okay. Do any of the commissioners have questions for the applicants? No? Okay, thank you for your comments. And we will move to public testimony. And I'm not seeing anybody signed up.
This is Anna Miller, staff. We currently have no members of the public signed up to speak to this specific item. If you are interested in speaking to this item, the chat is now available. You should be able to enter your name and address there. If you're dialed in via phone, please press *9 to raise your hand to let us know that you'd like to speak that way.
And we did talk to all of our neighbors, specifically the ones who had concerns, and hopefully we alleviated those concerns.
Okay. I do see 2 hands up. No, I'm not sure what that means.
Ms. Cassidy, if you have a comment, can you please put your name and address in the chat for us?
So it seems like there are nobody's raising their hands on the phone. I don't see a comment from Ms. Cassidy. Is that fair to say, Anna?
Yes, I'm not seeing anyone indicating in the chat that they'd like to speak to this item. Thank you.
Okay. Well, given that there's no public comments, and then I think there's need for the applicant or the staff to respond. So I'll go ahead and close the public comment and see if there are any final questions for the staff from commissioners. Not seeing any. So we'll just open it up for discussion. Anybody have any thoughts here?
This is Commissioner Candidate. I don't have any concerns with this application, given that there's no planned use of that right of way, and looks like a good opportunity to make it a lot simpler for both the applicant and for the city to be enforcing this as one property. So, and I don't have any further questions.
Commissioner Bloomfield, I would agree with that. Discussion. We have a motion.
I can make a motion. This is Commissioner Candidate, unless Commissioner McMillan, unless you were about to do that.
It's all yours.
Okay, this is Commissioner Candidate. I move that the Planning Commission recommends that the Boulder County Commissioners approve docket. Approves docket V-22-001 with the conditions of approval outlined by the county staff.
It's Commissioner Whitney, I second.
Okay, we have a motion and a second. And we'll do a roll call vote. Mark Bloomfield, aye. Sam Fitch.
Aye.
Gavin McMillan.
Aye.
Connor Canaday.
Aye.
And Chris Whitman.
Aye.
And Kim, I see. So motion passes unanimously, and I see Kim has turned her video on. Did you have something to say before we wrap this one up?
Not for this docket, just preparing for the next.
Okay, great. Thanks, everybody. Thanks, Pete, and for the applicants. We appreciate your input, and glad we could clean that up.
Yes, thank you.
Kim, what did you?
Yeah, so commissioners, Commissioner Conde will need to leave the meeting at 3 p.m. as he previously let us know. And Commissioner Goldfarb will be joining at 3 p.m. We do need 5 commissioners to be in attendance in order to have a quorum. So you have a couple of options at this point in time. I think we can either take a break until 3 o'clock and then reconvene so that Commissioner Goldfarb can hear the staff presentation, or we can proceed with the staff presentation, given that Commissioner Goldfarb has received the staff packet and the recommendation and has the analysis in front of her. And the staff presentation would simply be a summary of the information that's already on the record. And then we could pause after the staff presentation if it isn't 3 o'clock yet in order to allow her to join. We do think it would be wise for her to have joined the meeting when by the time the applicant is allowed to speak, so that she can be a part of that in order to help render a decision and recommendation on the docket. So it's up to you. We can either pause now or hear the staff hear the staff presentation and then pause after if it's not 3. And that explanation might just take up until 3 o'clock. So we can just let me know your preference.
Commissioner Fitch, I would prefer the latter alternative. So let's go ahead and hear the staff presentation, since she already has a written version of that, and then take a break if it's not 3 o'clock.
We don't need an official motion or vote on it, but does that sound agreeable to the rest of the Planning Commission informally? Okay, yes. Looks like we've got a thumbs up. Okay, so we will go ahead and proceed with the next item. I believe it's Sam Walker. Thank you.
Thanks, Kim. Okay, so this is public hearing for docket SU-22-0004. Pivot Energy Solar Facility. We will now hear from Sam Walker from staff. If you will please present the staff report.
Good afternoon, commissioners. Can you hear me?
Yes.
Yes. Okay. Sorry, I'm having a little bit of technical issues with my laptop, so I'm called in, but we'll still be able to present on my screen. So just give me a second to share my screen and we can go ahead and get started. Everyone see my presentation?
Yes.
Great. Okay, so I'm here to present docket SU 220004, the Pivot Energy Solar Facility. This is on a property at 5980 North 79th Street. So for an overview of the project, the owner of the property is Charles Rogers. However, the project is being represented by Kyle Sunman and several of his employees on behalf of Pivot Solar, or I guess co-workers on behalf of Pivot Solar Energy. The zoning of the property is agricultural. It's a little bit under 36 acres in size, so it is a legal building lot by our definition in the land use code. In terms of existing conditions, there's a residence on the property and then one large and two very small agricultural outbuildings. And then there's a large kind of roughly 33 acre field, and that's where the array is actually proposed to go, which we'll see here in a few minutes. The request that we're reviewing today is a special use review to construct a 5 megawatt, 24 acre solar energy facility on this 36 acre parcel. The existing floor area is 10,500 square feet of mixed residential and agricultural development, although that's not proposed to change here. And then they have not actually proposed any site disturbance on the property, although there will be some just from driving posts and running trenches for conduits and things like that. So here's a vicinity map just to make sure everyone's oriented. This property is on the east side of North 79th Street, just west, or excuse me, just east of the Gun Barrel area. So here we have a vicinity map, or excuse me, a location map just showing the exact same information, but more zoomed into the specific property. And an aerial map from 2020 showing the existing development on the parcel. So you can see that most of that residential and agricultural development is concentrated in the northwestern portion of the property. And then the vast majority of the property is this kind of open agricultural area. It's typically hayed, is my understanding. And so this is largely where the proposed solar array is going to go. Here we have a regional aerial map just showing the wider area around the parcel, a lot of ag land around here. And then at the very bottom of this image, we can see Lookout Road, which is going to be relevant when we take a look at some of the site photos. This is a comprehensive plan map showing what could be a lot of information. The main one of relevance that we'll talk about more in a few minutes is this yellow layer in the southern area of the property that's agricultural land that the comprehensive plan identifies as being of local importance. And then the entire parcel is also covered in this green cross hatching, which indicates that it's part of the White Rocks and Gun Barrel Hill environmental conservation area. I'll also point out that there's critical wildlife habitat. That's the red cross hatching, but it's not on this property. It's on the adjacent property to the south, which is owned by the City of Boulder's OSMP department. And then I'll also point out that there's a view protection score associated with North 79th Street, which we'll touch on briefly during the criteria analysis. Next, we have a contour map of the property. This one, I think, maybe doesn't read quite as clearly as it should, but the property generally slopes downward from south to north. So it's kind of a bowl that is the lowest point is down near where the existing residential and agricultural development is. There's a gentle slope that goes upward toward Gun Barrel Hill, or toward Lookout Hill, I guess. The entire parcel is covered in moderate swelling soil potential. And here we have a public lands map of our recommended conditions of approval. To the north, we have some property that's owned by the county's open space, Parks and Open Space Department. This is referenced in one of the requested or recommended conditions of approval. And then, as I noted earlier, the property immediately to the south is owned by the City of Boulder's OSMP. We also have some conservation easements nearby, although the conservation easement team didn't have any issues with the proposal. This is a zoning map just showing that the property is zoned for agriculture, and there is also a 90-foot supplemental setback along North 79th Street, although it's not really relevant for the purposes of this application, just the zoning is mainly. So this site plan is the original submittal that was submitted by the applicants. They have now submitted a revised site plan, and that's what we're recommending approval of with some conditions attached to it. But this was the original site plan submitted by the applicant. So you can see it's a large area of disturbance for the array. They show fencing surrounding that area of disturbance for the actual arrays or the panels themselves. And then we also have an extension of the existing driveway further into the parcel to provide access for both construction and maintenance after the construction is completed. However, there's a requirement in the land use code that we'll talk about more in detail later that no more than 7 acres of identified agricultural land. So we saw the comprehensive plan map. No more than 7 acres of those lands can be disturbed by a large solar array. That's a supplemental provision for large solar arrays in the agricultural zoning district. And so there wasn't really a way for them to get around that, at least as perceived by staff. And so the applicant submitted a revised site plan to reflect it. So this slide shows the overlap between the original site plan that was noticed to the public and the agricultural lands. It's a little bit difficult to see, but you can tell that that yellow layer of the significant ag lands that cover most of the southern portion of the property, the proposed array went pretty far into that, I think to the tune of, yeah, like it says right here, 12 acres. So the applicants in response submitted a revised site plan. It's much more basic, but this site plan is them acknowledging that they could build the array such that they would only put 7 acres of disturbance within those significant agricultural lands. And then this hashed area in the northern area is where the majority of those solar panels would be located in the future. So we're recommending approval of this site plan with the caveat that at permitting, they provide a revised site plan that actually shows the specific layout of the panels like the original submittal did. This slide shows the elevations of the kind of electrical equipment that's associated with the arrays. I also want to point out here that this is a side-on view of the actual panel, like an individual panel structure, which shows that the maximum height at max tilt is 8 feet because these arrays will track the sun, so they'll change in angle and well, they'll change in, I guess, horizontal and vertical angle during the day. But the original thought by staff was that the maximum height would be 8 feet above existing grade. That was a recommended condition of approval. That the limitation, the upward limit on height, be 8 feet. However, after discussion with the applicants, it seems like that was more of a measurement of the array on a flat ground. And obviously this property, like I said, slopes. And so they were more comfortable with 12 feet. So I've actually got a revised recommended condition of approval to reflect that at the end of this presentation, but we can look at that in detail later. Here we have elevations of the fencing that's intended to surround the arrays. It is 8 feet tall, so it has to meet setbacks. It can't be right on the property line. I just wanted to note that for the record. And then this is a very brief summary of the narrative. They actually submitted a very robust narrative, which I was very appreciative of. I got a lot of detail, but I just pulled out kind of the more relevant parts here, which is that they felt that generally their proposal does meet the requirements for a large solar array outlined in the land use code. They found that the soil structure of the site was sufficient to support all of their structures and installations without any soil amendments or changes. I left solar arrays in there and I don't know why. They did want to dispute the quality or applicability of that restriction of those significant agricultural lands. I think they'll go more in detail on that in their presentation, but they did want to call that out specifically. They also noted in the narrative that this project is proposed to sunset after the useful lifespan of the array is over, which they anticipate to be 25 to 35 years in the narrative. And so that's reflected by our recommended condition of approval that the array be retired and the land remediated back to useful agricultural status after 35 years or after the array's lifespan is kind of ended, whichever is sooner. They also noted that the property will be grazed during its use. So they propose to have sheep graze the property after construction is completed, but while the arrays are still there, and that it will generally remain vegetated because most of the soil will not actually be disturbed once the arrays are put in. We'll take a look at a few site photos. These first two photos are the view facing directly west and then directly east from the proposed driveway entrance. This property has a double entry driveway. This is 9th Street and they're proposing to use just the southern entrance for to get the materials onto the property for construction, and then the back for maintenance crews whenever they go out there. This photo is standing further back into the property, facing again west toward that driveway entrance, just showing kind of the wide area they have for construction vehicles to come on. In the photo on the left, that driveway continues around and onto the large agricultural area of the property, which we'll see in a second. This large gray building is their existing agricultural structure that's proposed to remain unchanged. And then on the right, we have a wing of the existing residence on the property. So this photo is just a slightly better view of the kind of corner around that barn. This is roughly where their property line is, and then the access for construction and maintenance will extend off to the right in the distance. I'll also point out that this is one of the only views of the public right-of-way to the north that will potentially be visually impacted here, and I just wanted to illustrate that in terms of distance. So this is a photo facing generally north toward Lookout Road, which you can see just barely off in the distance. It's marked by these telephone poles. This area in the foreground is the area of the property that was mostly originally proposed to have the solar arrays installed on it. So you can see it's vegetated right now. It's used for hay. And then if we need to, you can use this pile of dirt as a reference point. You can see this in the aerial photos to get a better sense of what direction we're facing. This is some of that existing agricultural development on the property facing south. So the residence and agricultural building that we just passed in the previous few photos are off to the left, and then the array location will be partially off to the right and then behind the viewpoint of this photo. A better view of those agricultural structures. And then the next few slides are pictures that I took from Lookout Road, just to kind of illustrate the visual impact or lack of visual impact. So this is pretty far to the east on Lookout Road, facing generally toward the property, but it's a little bit difficult to tell. This is actually a ridge line where the land starts to drop. All of the individual panels will be located well below this elevation and not visible from this vantage point. This is a little bit of a better vantage point, again, from Lookout Road, closer to the subject property. We're facing mostly northwest in this photo. It's difficult to see, but this little dark area of trees right here is the southernmost, I think the southernmost residential property on 28th Street, which is several houses upslope and higher elevation than the residential property that's connected to this one. Another view from Lookout Road, and that's it. So in terms of referral responses we got standard responses back from our building team, noting the requirements for the construction, but little else. Our Parks and Open Space Department had really minor concerns with impacts to the adjacent parks and open space land. They also didn't express a lot of concern about the potential loss of agricultural land or visual impacts. They expressed no concerns regarding impacts to the environmental conservation area that we saw covers this entire parcel, or the critical wildlife habitat that's on that adjacent parcel to the south. But did ask for several requirements or conditions of approval, including a prohibition on construction when soil conditions are wet, because that tends to destroy the soil characteristics. They also asked that no disturbance be allowed outside of the proposed disturbed areas in order to kind of help maintain the soil outside of the disturbed area for the array, revegetation plan, and then a prairie dog barrier and fencing between the array location and the Parks and Open Space parcel to the north. And I can talk more about that logic in a little bit. The Access and Engineering team had some requirements for providing access to the property during construction. I think the existing access is pretty good. They just wanted to make sure that we had a haul plan and a plan for traffic direction, because that is a narrow one-lane road that large trucks are probably going to be coming off of to deliver materials to the site. The Public Health Department noted that the septic system on site is not sized appropriately for the current residents because there's too many bedrooms, which is how they size that septic system, and noted that it was an issue that would need to be rectified before the property was ever sold, but we don't think at the staff level that it's necessarily something that should preclude this project from moving forward specifically. The City of Boulder's open space and mountain parks had kind of their standard comments in terms of protecting public view sheds and their adjacent properties. Noted that there are prairie dogs on the property immediately to the south that they own, and also noted that burrowing owls, which are a state protected species of owl, have been found on the subject or on the property to the south in the past, and that there's some special requirements in terms of building too close to a burrowing owl nest during their nesting season. And so we have a condition of approval to reflect that. However, that's another one that's been modified based on some internal discussion since the staff recommendation was issued. We received no response from several referral agencies, and then responses with no concerns from several other agencies as listed on this slide. And then in terms of public comments, we received 3 public comments prior to the issuance of the staff recommendation. I also did meet with one adjacent neighbor on the property along with a member of the applicant's team. 4 of the 5 comments that we received in total were opposed. I've very briefly summarized their concerns here, although their full outline of their concerns was included in the staff recommendation packet. But essentially, they found that the proposal doesn't really fit with the character of the neighborhood and would be an eyesore and potentially lower property values. And then one comment that we received earlier this week just expressed general support for the application and solar as a whole. So now I'm going to very quickly try to go through a few of the more relevant criteria in terms of the conditions that we recommended for approval. So the first criteria discusses the use complying with minimum zoning requirements and all other applicable requirements. The reason I've included this one is because of that supplemental requirement regarding the area of disturbance or the limitation on area of disturbance in significant agricultural lands as identified in the comprehensive plan. So that's what's summarized here is that we found that most of the additional provisions for the array were met in terms of the impacts outlined in the second bullet here, but that the original proposal did not meet that requirement that only allows for 7 acres of disturbance within significant agricultural lands. And so the last bullet I've already stated kind of is that the revised site plan submitted by the applicants is the one we're recommending for approval that limits their area of disturbance to 7 acres in those agricultural lands. And then we are also recommending that an additional site plan with more detail be submitted as part of the permitting package. Next, we'll discuss criteria 2, which concerns use compatibility or the compatibility of the use with the surrounding area. We did find that the use is overall compatible, although there's not really a large solar array in the area of this property. It's mostly rural, residential, and agricultural properties within the area around the subject parcel. We found that the proposed site actually doesn't have a lot of agricultural utility. That's based on analysis provided by the applicants as well as by our own Parks and Open Space staff. It's dryland agricultural land, and so it typically is only harvested once per year for hay. It's not like a dramatically productive piece of agricultural land that we're going to be losing for a long time. The applicants are proposing very minimal site disturbance, although the area of disturbance for the array as a whole is pretty large at like 22 acres. The actual disturbance is going to be relatively minimal because they're just driving posts into the ground. They're not doing large topographic changes or anything like that to the property. Once the construction is completed, day-to-day impacts are going to be pretty minimal because it's a relatively self-sustaining system. There's only going to be periodic maintenance workers out there. But there won't be a lot of noise or a lot of traffic to and from the site after construction is completed. We found that visual impacts were relatively minimal. The arrays will be, as currently or recommended for condition, a maximum of 12 feet above existing grade, but they're going to be of a uniform height mostly, so they won't really have a significant massing effect and will be pretty well set back from any surrounding areas. And then there's also a recommended condition of approval that's reflected to reflect the statement in the applicant's narrative that the array will be decommissioned after 35 years. So we found that it's also, the lack of kind of on paper compatibility is mitigated by the fact that it's a temporary thing. It's only going to be there for 35 years, after which the array will be decommissioned and the property is remediated according to a plan that we're asking be required at permitting. And the final criteria that I've included is number 4, which states that the use will not result in an over-intensive use of land or excessive depletion of natural resources. We found that, again, although the disturbed area for the array is quite large, the actual site disturbance that will result if the array is approved is pretty minimal, and there will be relatively little impervious area created, which is part of this criteria. They're not proposing any topographic alteration of the property. It will continue to be grazed during operation of the array and then will be decommissioned and remediated afterwards. We did note the potential impacts to the burrowing owls based on the referral response we got back from the City of Boulder's OSMP, and so we have some conditions that are designed to mitigate that. We also have the same thing with regards to the impacts of prairie dogs. We have some recommended conditions there. And then we have the condition about not building during wet soil conditions, which is intended to preserve the existing soil characteristics as much as possible so that when the array is decommissioned, it can be remediated effectively. I'm sorry, I have one more. So the last criteria we'll talk about is the visual impact criteria. So staff had limited visual impact concerns related to the proposal for the array. That's because where it's located is largely not going to be visible from Lookout Road. I don't think it's going to be visible at all from Lookout Road. It's unclear if it'll be visible from North 79th Street, which is the road where all the residences are to the west. But if it is visible from there, it's going to be broken up by that intervening residential development, as well as the vegetative screening that we're asking be required for it along that western boundary. And then most people, I think, would be looking further west and away from the array. If they were on 79th Street, they would be looking at the Indian Peaks and the Flatirons. However, several of the adjacent neighbors did express concerns regarding the visual impacts of the array. I want to note that the applicants have proposed to provide stipends to those neighbors so that they could plant their own vegetative screening or put up fencing or something to limit the visual impacts on their own property. But staff weren't quite comfortable with that idea. It's difficult to write a condition that we can enforce that achieves that. And then we also just have kind of a much better process for requiring applicants to put vegetative screening on their own properties. And so we've recommended a condition to reflect that. So overall, the community planning and permitting staff found that the proposal can meet all of the requirements of the code as conditioned, and so we're recommending that the Planning Commission conditionally approve the application, subject to the commission's or the conditions that were recommended in the staff recommendation, but also subject to the amended conditions that I have on the next few slides, which we'll talk about very briefly right now. So the first amendment I wanted to show was to condition 2, which was the height limitation on the arrays themselves. The original condition as issued was a limitation of 8 feet. Again, after discussion with the applicants, it seemed like that was more of a figure that was based on a flat property, which this is not, and they would be more comfortable with a limitation of 12 feet. At the staff level, we're okay with that. There's not that much change in the visual impact proposed or imposed by a 12-foot versus an 8-foot solar array, and it's still well below the code requirement, which is that arrays don't exceed 15 feet in maximum height above existing grade. The second amendment that I wanted to point out was to number 8, which is just there was a typo, and so we want to make sure that the applicants and not an appliance submit the decommissioning and rehabilitation plan at permitting. And then these are the 2 larger changes that I wanted to point out, which were to condition 10, that's the burrowing owl condition. So originally we used the OSMP comments, which said that there shouldn't be construction during the nesting season, which is from March 15th to August 31st. So we just said they couldn't build anything during those months. However, I reached out to OSMP and had a discussion with them via email and talked with our own Parks and Open Space planner as well. And so now we're recommending this revised condition language that says if site disturbance or construction is to commence during the burrowing owl season, then the applicants have to provide a survey showing that there are no burrowing owls within the state required buffer that would prevent them from starting construction. However, if they start construction outside of that burrowing season, then the assumption is that the owls won't move onto the property, onto the adjacent property during construction. So we're okay with them not providing a survey. Condition 11 discusses the potential impacts of prairie dogs. The concern is that there are prairie dogs on the OSMP property to the south of this property. And the concern is that once the arrays are established on the subject property, the prairie dogs could move under the arrays and then move from there onto the Parks and Open Space property to the north, which is a no prairie dog zone in the Parks and Open Space management plan. So we're asking that the applicants put a prairie dog barrier in the intervening area between the array and the Parks and Open Space property. I think this condition just lacked specificity when it was originally written, and so we've revised it now to clarify that the prairie dog barrier has to be just between the disturbed area of the array and the Parks and Open Space property to the north, and it can be placed along that shared parcel boundary, or it can be placed in a manner that incorporates it into the existing perimeter fencing they were already proposing, the 8-foot fence that'll surround their area of disturbance, as long as that design is approved by Parks and Open Space staff. And then we just want those that barrier shown on the plans for permitting. I think that's everything that I had to talk about. So hopefully all of that made sense, and I'm available for any questions from the commissioners.
Great, thank you, Sam. Before we move on to questions, I just want to acknowledge that Commissioner Kennedy is no longer with us, and Commissioner Goldfarb has joined us. Hi, Ann. Can you just state that you're here for the record?
Yes, Ann Goldfarb, present.
Great, thank you. So now we'll move on to questions for staff. I've got a couple to start with. Sam, before you move away from this screen, I noticed that your modified condition 11, I think you should have BCPOS city property, not CETO. Just a typo there.
No, that's the actual name of the property. It's known.
Yeah.
BCPOS is the county. CETO is the property.
Okay, I got it. I was confusing.
But good catch.
City open space. If you can go up to the other page on your modified conditions. I don't know which one it was. It was keep going. It was the one where you allowed the 12 feet. Yeah. One question that I had there is, it says the height of the proposed fence is also limited to 8 feet. Does that mean that we want to actually allow them to do a 12-foot fence, or are we still sticking with an 8-foot fence?
The intention is that the fence will still be limited to 8 feet as proposed. I don't think the applicants had any issues with that limitation.
Okay, great. And then the only other question that I had was the proposal for the decommissioning, did that start with the county or did that start with the applicant?
That started with the applicants. It was included in their narrative with the application submittal.
Okay, then I will ask some questions of the applicant. That's all I've got. Does anybody else have questions for staff? No, no one?
This is Commissioner Goldfarb. I have a couple. What specifically is the prairie? What does it look like?
I'm sorry, what is the prairie, what?
I think you cut out there for a second, Ann.
I'm wondering what it looks like.
Hi, Ann. This is Rick Hackett, CP&P staff. Your audio is coming through garbled. You may want to try turning off your video camera so we can see if that'll improve the audio quality.
Yeah,
and repeat what you said, please.
Could you say that again, Rick? All of you is garbled too.
Yes, this is Rick Hackett with CP&P staff, and your audio is garbled. If you can turn off your video camera to see if that improves the audio. And other commissioners, is my audio sending okay and clear?
Yes. This is Commissioner Bloomfield. I heard it fine.
Commissioner Rainey, I heard your audio fine, and I believe, and Commissioner Goldfarb's question is, what does the prairie dog barrier look like? Or what is it made out of?
So I don't know that we have a specific design in mind. That was something that I ended up looking up yesterday with the Parks and Open Space planner. We had a chat about it. And so typically prairie dog barriers are a partially above ground and partially below ground barrier. Part of it is an above ground barrier that's a visual barrier. It's like either closely stuck together slat fencing, or I saw some vinyl products that kind of are, I guess they're like 2 feet above ground. And the idea is that they block the vision of the prairie dogs. So they don't want to keep moving in that direction because they want to see like the open air. And then there's also an underground component. It seems like the underground component varies. So my intention is after this hearing to reach out to another member of Parks and Open Space staff to see if we have a standard that the Parks and Open Space Department themselves use. The depth of burying underground components to the prairie dog barriers that I saw seemed to vary between 6 inches and 2 or 3 feet. It just kind of depended on what the product was. So it would really look almost like silt fencing, although hopefully maybe a little bit more permanent and durable above ground. And then there would be a below ground fencing component that's buried to a certain depth as well.
Okay. And after I ask this, I'm going to leave the meeting, I think, and try to see if my audio will be better. Question is in regard to the, again, what
I'm sorry, I didn't
Were
catch
you
that at all. I
able
think
to-
you broke up again.
I'm asking about what it would look like.
What the prairie dog barrier would look like, or what the array would look like?
Sounds like she's typing it in, and I'm happy to read it for the record. So the question is, what will 12-foot fencing, I think? But I think we said that the fence is not,
Yes.
the fence will be 8 feet around.
Yeah, so the fence is allowed to be a maximum height of 8 feet. They did provide some elevations of it. So in the top row here, we have kind of a basic illustration of what the fence would look like. I think this is probably a little bit lower quality than what was in the actual application submittal. So the actual application submittal had more detail and showed, I believe, like fencing mounted to these posts, and then in the left there will also be an access gate, and that's for the maintenance teams. That's going to be a little bit, I imagine, more heavy duty.
Thank you.
Okay, any other questions for staff? Not seeing any. So we will go to the applicant. For the applicant presentation.
This is Anna Milner, staff. I've promoted Kyle Sunman, applicant, and Julia is being promoted now. We can give her one moment.
Good afternoon, commissioners. Can you hear me all right and see the presentation?
We can.
Great. Shall I get going?
Yeah, if you can state your name and address to begin with.
Sure thing. Good afternoon, commissioners. Thank you for having me. My name is Kyle Sundman, 1750 15th Street, Denver, Colorado. Representing Pivot Energy, we are talking about the Pivot Solar 34 LLC Community Solar Garden Project. Let me just get over here so I can scroll.
Okay, Wes?
Excuse me.
Go ahead. There was some background noise, I think.
Okay. Thanks again, Sam, for the presentation, the detail you provided. As noted, we will be requesting a recommendation of approval, conditional approval for the solar project. And then there's a couple of the staff conditions we want to ask for your reconsideration on, or to apply a little bit of more specificity to give us some more information. We'll go through the project details, some community benefits, and then talk about the Q&A if there are any. I'm going to kind of breeze through this section because Sam touched on it already, but the project is owned by Charles Rogers off of 79th Street and Mineral, about 36 acres. The impact of the solar would be about 21. Primary surrounding uses are open space and farmland. This is the map that you've seen. The project is approximately 5 megawatts AC in size. Be surrounded by a decorated wildlife-friendly game fence, which we have a photo of so you can see. The construction is a relatively short amount of time, a few months, relative to the operational period of 20 to 40 years, which I will note we will be discussing due to the 35-year condition. We will submit a detailed decommissioning plan to staff for review and approval, I assume, prior to the Board of County Commissioners hearing or prior to the building permit submittal. So the project is, it's a relatively basic solar energy facility. It's a single axis tracker, so it follows the sun. It starts facing east in the morning, and then the panels slowly, very imperceptibly rotate to follow the sun throughout the day to produce the most energy and make the system as efficient as possible. The approximate height at full tilt, which of course would only be in the very early morning and in the evening, is approximately 10 feet, and it has to do with the way that the site slopes to the north. The array near the kind of northern portion of the site would be slightly elevated to accommodate for torque tube tolerances, which is what the panels sit on. It's not sure if you can see my cursor, but it's the torque tube that the panels are attached to, and then what allows it to rotate. The code does allow it for up to 15 feet, so we think that 10 feet is well within that. These are not a significant source of nuisance. There's no dust, no noise, no light pollution. We did a glare study, which we can talk about. There's going to be no additional glare to the neighbors or to properties surrounding. It's obviously a relatively low impact use, all things considered, and it allows the property to be returned to its original agricultural condition after the operation. We will, of course, control the noxious weeds and vegetation. A primary method for doing so is grazing sheep underneath the panels. We like to think that also helps retain a bit of agricultural use throughout the life of the system as it's producing clean energy for your residents. Post-construction, we conservatively estimate 4 to 8 trips from routine operations and maintenance, just normal pickup trucks. So certainly not an increase in traffic for the long term. It doesn't require any additional resources in order to operate. So from the county's consideration, we're not looking for any sewer, water, police, fire, et cetera. But of course, we are paying property tax, so a net positive for the county there. The project maintains the existing surface drainage, so it doesn't affect the imperviousness. It actually decreases the imperviousness of the surface by changing from a row crop to a native prairie seed mix. So that'll actually help existing drainage patterns. And there's no water used on the project. On this parcel, it's dry land farming right now, so there's no irrigation anyway. Why here? It's a good topography, relatively speaking. It's flat, it's open, it's not shaded. There's proximity to the distribution level infrastructure, and it's the highest and best use for the property based on the evaluation of the landowner. They've identified this opportunity as a preferred option to generate income because currently they are only dry land farming every other year. So they're not producing much revenue from the property right now. We do utilize holistic land management, as I mentioned, including the grazing of the livestock. And I'll talk a little bit about a possible study with the National Renewable Energy Laboratory to investigate continued agricultural and kind of holistic measures on site. What I really like to highlight about this project, I think the best thing about it is that 100% of this power that's going to be generated is donated by Pivot to low-income Coloradans, which amounts to a lifetime donation of $17 million. So the question I'm sure is going to be asked, you know, how can you build a facility and donate 100% of the power? And the answer is we sell the renewable energy credit to Xcel Energy. They have to retire a certain amount of these credits on behalf of Xcel Energy in order to meet the state statutes that are required of them based on their renewable portfolio mix, basically saying that they have to have a certain amount of renewables in addition to their combustibles that they use to produce their energy. So we're selling the power back to Xcel at a slightly higher rate than is normal. And in exchange for doing that, we're able to donate the power or donate the benefits, the subscription bill credits to low-income Coloradans at no cost to them. So yes, we are, of course, the project is making money, but it's not making money through residents, which is typically how community solar operates. Property tax revenue would amount to about $350,000 to Boulder County over the lifespan of the project. And of course, as noted, we're not utilizing any of the services provided by the county. So that's just a net $350,000. There are utility bill savings for the local ratepayers via this subscription program. As noted, this like specific program donates all of its capacity to low-income Coloradans. Pivot is the largest developer of community solar projects in this program in Colorado. And we have other projects that don't have that same donation component. So if anybody's interested in subscribing, it's a guaranteed rate savings. Obviously no pressure, but just wanted to put that out as a possibility if anybody's interested in participating in community solar. And of course, this is diversifying energy source by generating the power locally, just by the nature of how energy is used. The closest light bulb or dishwasher to request or need power is actually going to use the electrons that are produced here. So it all does stay in Boulder County. Pivot is a B Corp. We're an ESG focused company. This project actually will also allow us to donate an additional $85,000 to Boulder County to help with the electrification of manufactured homes. And that's been a collaboration we've had with the city and with the county. And those folks, as you electrify and switch out appliances from gas to electricity, to the extent that they would also qualify for a low-income subscription, they could be, signed up to receive basically, free energy. We would also love to host periodic site tours to community members if that's interesting to you all. The NREL research project that I mentioned, we have engaged the National Renewable Energy Laboratory, along with a couple of universities, including School of Mines, to talk about integration of food crops in the PV installations. They're looking for 3 sites to evaluate the feasibility of growing food crops. I'm sure you're familiar with Jack's Solar Garden. It's not dissimilar from that. It's just part of a more robust and national study. The proposed measurements would also include things like carbon sequestration of the crops versus sort of the traditional seed mixes that we would revegetate the property with, and looking at how does this help the soil increase the water retention and potentially utilize less water to grow crops because there's shade and things like that. So this could be a cool option for Boulder County to support continued research into agrivoltaics and holistic land management to set the standard for solar development in the future. So neighborhood outreach, Pivot sent proactively and prior to our initial application submittal a letter to all adjacent property owners, sharing our intentions and to open up a line of communication. We have engaged directly with several of the folks who've made comments, and I'll go through a few of kind of the major concerns that we've heard and talk about how we're going to try to address those. But the the headline is that we've offered no cost subscriptions from alternate community solar facilities to these neighbors, and landscaping stipends to mitigate the visual impact concern. So just to run through a few, the visual impact, the project on the left is obviously an existing facility. This photo is taken from approximately 600 feet away from a solar project. Depending on where the actual facility is sited within the boundary of Charles Rogers' property, it probably would be closer to about 300 feet. I didn't have a photo from 300, but you can imagine it's closer. But the point is that it's still relatively low and off in the distance. To the right here, you can see a before and after photo of a row crop that had been harvested, and on the same site after we had revegetated with our native seed mix. That's what it looked like within about 6 months of the commencement of the system. So a pretty vast improvement aesthetically, and also just from a retention standpoint very quickly. One thing we would request, and this is not a formal condition, so this is more of just an informal comment, but we would request that the commission allow Pivot to work directly with the applicants to satisfy a screening obligation, rather than requiring just sort of a blanket landscaping, which is a little bit undefined at this point. But the reasons are because it's more efficient, because obviously if you're a little bit closer to the homes, you can plant less vegetation and use less water. And obviously there's an alignment of interest there, because if we were able to provide a stipend, and the landowner who was concerned about the visual impact could ensure that their vegetation is to their liking for their property, and also is whatever height they need, and they would obviously be able to take care of it and ensure that it is robust and provides that screen that they're looking for. We think that it's a higher likelihood of success to achieve the outcome of this visual screen. We can't plant like a tall canopy tree next to the solar facility due to the possibility of shading, which obviously just decreases the revenue, and obviously then the donation that we could provide to the constituents who would benefit from it. The shorter foliage, which is what I think the county is proposing right now, doesn't really provide a visual buffer. It just is sort of adding vegetation that's going to be around the facility, but it's not going to obfuscate it. And also this site slopes up and away from the homes, so it really would be challenging to provide any sort of screening that would completely mitigate that. And so again, the closer we are to the applicants, or excuse me, to the neighbors, I think the better we feel that they'll be able to achieve their goal of a buffer between them and the facility. We heard some concerns about property value. I won't go too deeply into this, but we hired Cohn Resnick, which is an independent agency, to evaluate and perform a report for us about adjacent properties and solar facilities. And the upshot was that there is effectively no impact to property values, whether you're a solar facility or not. We heard concerns about glare. We used the industry standard Forge Solar glare gauge tool to evaluate all these red points that you can see here are homes, and the greener kind of teal areas, the roads nearby. There, as you can see, is 0 minutes of glare provided. This is what the FAA requires for any projects near airports, to ensure that there's not visual impact to pilots or to the control tower. So you can rest assured that it is the most robust and industry standard to determine what the effect of the solar facility could be. All of these are coated in anti-reflective coating, so they are, they're designed not to glare. And just generally speaking, regardless of any number of minutes that you would see, it's still less than water, snow, or steel, as noted in this study, though there is no glare. We've heard concerns about noise. So the equipment that makes the noise, which is the inverters, has a decibel rating often similar to an air conditioning unit, which is not supposed to be a nuisance to their own property or to their neighbor's property. You can see the 300-foot sound buffer, so noting that there's not going to be any of these large inverters near within 300 feet of the residences. So at that point, it returns to ambient conditions. Obviously, none of the equipment operates in the early morning or in the night or overnight. It only operates while the sun is shining. So coming from a quiet hour standpoint, there's would still be no perceptible noise. We just pulled a few things from the Boulder County comp plan to show how this is in alignment with what we believe Boulder County is pursuing. I'm not going to go through all these in detail, but we believe that the guiding principles have strong favor towards social, environmental, and economic opportunities for the county, and we believe that this satisfies those. And obviously, this is we are helping with social equity and fairness and access to the community resources by the fact that we were able to donate all the money to the low-income Coloradans. Just another snippet: upon the review of a new development, all impacts and concerns should be considered, but safety and environmental concerns should take precedence over aesthetic concerns. Obviously, this project does change the appearance of the site from its current use. This will not impact the skyline for Boulder County, nor will it impact the westerly mountain view for the neighbors, and it remains a lesser impact than other use by right proposals that could be developed on the property in its agricultural zoning. Boulder County shall continue to protect air, water, soil, et cetera. The proposed project does that by providing clean, renewable energy to Boulder County and your constituents. A snippet from the sustainability mission statement to ensure that your decision-making reflects your commitment to environmental, social, and economic sustainability. And we, of course, feel strongly that this proposed project reflects that harmony within the county sustainability plan and the comprehensive plan. Will be used to benefit low-income electric customers served by Excel, and whenever possible, we use Colorado-based companies to complete the installation. So just a couple of requests for updating to the conditions. The first couple are very minor in nature, and then we'll talk about the significant ag lands piece a little bit more after that. The first is that the timeline, this is condition number 9, the timeline associated with the structures must be decommissioned and remediated within 35 years, whichever is sooner. There was a miscommunication on our part. We submitted our site lease, which demonstrates we have 40 years of site control. The narrative generally says that the useful life is 25 to 35 years. The program with Excel is 20 years. The assumption is that we can convert into what's called a qualified facility and continue selling wholesale energy back to the community and back to Excel Energy as the utility provider. But solar panels don't expire, right? So they're going to continue producing energy, and basically all we're asking is that you strike the whichever is sooner, noting that we will decommission the plan in accordance with our decommissioning plan at the end of the useful life, and that kind of depends on what we're able to get with Excel, which can't be determined today because we don't know what's going to happen in the next 25 to 35 years. Even if it was 35 years as a useful life, we would suggest it should be 35 years plus decommissioning, because you would want to utilize the full 35 years to maximize the economic ability of the project to create revenue and obviously then donate the capacity to the low-income Coloradans. Obviously, again, we do have a detailed decommissioning plan which aligns, and so it will be decommissioned whether it's 35 or 40 years. We're just asking to extend that to either 40 or remove whichever is sooner. The construction, this is we feel sort of a vague condition where it says construction cannot occur under moist or wet soil conditions or during rain. Obviously, the latter is very easy. We wouldn't intend to be building during a rain event. And we're requesting a more thorough and specific definition of what moist or wet is. And also furthermore, to define what specific construction activities are allowed versus prohibited. So we understand the spirit and we agree with it that we're, not to be driving the post pounder around when it's, wet and tearing up the facility and turning it into a mud pit. That's not in our best interest either. But, when we're talking about, somebody on foot installing a module, they're not impacting the soil, whether there was a rain event, 2 days ago or not. And so the idea is just to be a little bit more precise in the definition here, just so that we can make sure that we're able to follow it. So the significant ag lands piece. So as noted by this map, the significant agricultural land is bifurcated on this property. So the first question that we have is it's a little bit hard for us to understand how the southern area would be deemed, having different significance than the northern area, considering that there's no sort of perceptible or obvious physical change in the site there. But what we did is we dispatched a qualified biologist to specifically evaluate this parcel. We understand that the way the methodology was determined happened about 20 years ago or 40 years ago, depending on how you look at it, using aerial imagery available at the time. And so we sent out a qualified biologist to actually look at this site, which we submitted to our planner in the initial process. And the ultimate determination was that there is no difference between the two areas, and that this specific property, which is dry land farming, there's no irrigation on the site, has some bedrock relatively shallow. So in addition, we have actually had an anecdotal conversation with one of the neighbors that supported that. We just don't really think that this specific area is as significant as some that are in this zone of local significance. But furthermore, what we're talking about doing here is obviously donating a significant amount of money to low-income Coloradans. We are retaining an agricultural use of the property. If you were to eliminate, the portion of this in the southern facility, that would force the project to move north, which gets closer to our neighbors, which, as a matter of good faith, we were trying to avoid. If we do move north, the area down on the south part is not like it's going to be dry land farm. It's going to be a thin strip of however many acres remain down there. And so I don't think it's something where those acres would actually be utilized. I think they would be relatively stranded. If the system is downsized beyond the loss of donations to the low-income Coloradans, Boulder County is going to lose property tax revenue. We are going to return the entire parcel through a robust decommissioning to its agricultural use at the end of the project anyway. And the average yield from a bushel of, or I guess an acre of dry land farming per NRCS is about $168 per year. We can confirm that number with Charles Rogers about what his yield is. But the point is it's relatively limited compared to the amount of money that would be lost in the donations to low-income Coloradans. So the request is that we, certainly appreciate the conclusions drawn, and we have a similar interest in protecting agricultural lands that are in fact significant. We do think that the site-specific evaluation by this expert and the anecdotal information from the neighbor, the relatively low yield of winter wheat and the benefits to low and moderate income Coloradans does set the foundation for our request of allowing additional acres of impact in the portion on the southern portion of the site that's designated presently as that of local significance. This is my last slide. Conclusion. This is a great project. It benefits Boulder County's low-income residents with a lot of donations, both in the bill credits, but also in the electrification support. It supports your commitment to renewable energy generation 100% by 2025. It complies with the land use code for this zoning district as outlined by Sam. There's a relatively minimal impact or disturbance to surrounding properties relative to other options. It does allow the landowner to utilize the property how desired. And this is a great project that shows a sign of both Excel and Boulder County's progress towards clean, renewable solar energy, helping your constituents. Thank you very much for your time, and happy to answer any questions.
Thank you, Mr. Simon. Do we have any questions for the applicant?
If no one else has questions, can you hear me? This is Commissioner Goldfarb. Can you hear me better now?
Yes, we can, Ann.
Certainly can.
Oh, good. Good. Thank you. Couple of questions. You referred to some other projects and compared property values with those. Question I have is, were any of those other sites on a hill, and how visible was the solar array from the property owners parcels?
Thank you for your question, Commissioner. It's a document that we would be willing to provide and share both with staff and the public and yourselves. It's hard to quantify exactly kind of what the slope of the other projects were. It was a study that looked at several projects both around Colorado and otherwise, that doesn't have as many site specifics as I think what you're asking for, but it's a relatively comprehensive report that we'd be happy to share. And the conclusion is that I think kind of at a high level there is limited impact.
Okay. What is the distance from a neighboring property? What's the closest distance that, given the current proposal, how close would a neighbor be to the array?
Again, it depends on what the outcome of the significant agricultural lands piece is. If we're allowed to impact a couple more acres in the southern portion of the site, we can kind of keep it in the southeastern corner of the site. And so it's probably, closer to 600 feet from a residence. If we are not allowed to utilize that significant agricultural land, it will get closer. As noted in that site plan, it's the layout of the actual facility is not there because we received this comment from staff a little bit later, and so we didn't have time to actually lay out the facility. But needless to say, it would be closer. I would guess probably to the tune of about 300 feet from the neighbors.
Thank you.
You're welcome.
Does anybody else have any questions for the applicant? I guess I'll chime in with one. You indicated that the land lease was 40 years. Are there any options to extend that?
No, sir. 40 years is inclusive of the options to extend.
Okay, and then your request for modification of the condition, if we made it to 40 years, then at the end of the 40 years, you would have had to remove and mitigate, right? Because that's when your lease is up.
That's correct, yes.
Okay. Does anybody else have any questions for the applicant? Oh, I actually had one more. You mentioned the use of livestock. Would that be a continuous livestock, or would it just be for essentially cutting the grass?
The latter, that's correct. Yeah, we would hire a local, I don't know if you call them shepherds, or a company that has mobile kind of sheep operations, much like you would see with kind of the goats that go out and eat, along trails and things like that. They would just bring them temporarily to the facility until it was grazed down, and then they would remove them until the next kind of mowing or grazing.
Okay, thank you.
You're welcome.
This is Commissioner Goldfarb again. Would the shepherds stay with the sheep, with the herd while they're there?
It's a good question, Commissioner, and I can certainly find out. I don't know if they leave them or if they stay, but obviously the facility is completely encompassed by a wildlife fence, so there's no risk of sheep leaving the area, for example.
Thank you.
You're welcome.
Okay, last call for questions for the applicant. Not seeing any, so I'll go ahead and open public testimony. We'll go through folks who have signed up in advance first, and then call on people that signed up in the chat box, and then take any comments from folks on the phone. First, I'll go with the instructions for public comment. All members of the public will have a chance to speak, even if you didn't sign up from the Planning Commission homepage beforehand. If you join by computer, you can sign up by submitting your first and last name and address and the docket number in the chat box to the right. As each person who has joined by computer and signed up to speak is unmuted, Zoom will adjust your participant status so that you can speak and be seen via video. Once you are finished speaking, Zoom will place you back in the room as an attendee. If you dialed into the meeting via phone, please raise your hand by pressing *9 and we will unmute you when we call on you to provide comment. When it is your turn, the system will request that you unmute yourself with *6. Once you are unmuted, either via computer or phone if you have called in, please state your name and address for the record before providing comment. Each speaker will be allotted 3 minutes to speak. A timer will beep at the end of your speaking time. Time can be pooled at 3 minutes per person for a maximum of 10 minutes. You will need to provide the names and addresses of the other people besides yourself who are in attendance and donating their time to you. Anyone who is pooling time will need to attend the virtual hearing so that we can verify their presence as we would at an in-person meeting. Please do not submit comments or questions in the chat box during the meeting. The chat box is for speaker sign up only. Let's see, but members of the public will be unable to share their screens during public comment. And with that, we will go to the public comment. Let me pull up the list here. Okay, and I'm going off the spreadsheet, so I have Mr. Fox as the first speaker. Mr. Fox, oh, I see you. If you could unmute yourself, if you want to turn on your video, you may.
I tried. Can you hear me?
Yes, I can hear you.
And I don't, I'll start video. I'm going to try that too. It's not letting me unmute, or it's not, there we go.
Oh,
there we are. Okay, great.
If you could state your name and address for the record.
Yes, William Fox, 5974 North 79th Street, Longmont, Colorado, 80503. I am an immediate neighbor next to this project. And before we get started, here with me today is my wife, Karen Fox. If she could show her presence, and she'd like to donate her 3 minutes to me. And also here today is Michelle Williams, a neighbor 3 doors down, and she has asked me to use her 3 minutes as well. So I just heard that I can have up to 10 minutes. I have a short presentation. I think I can get it done sooner than that. Before though we start, I had sent in an 11-page PDF to Sam earlier today. I had hoped that he could display that as we go. If not, I'm gonna look at my copy and I'm gonna hold up the page that I'm on. I'm told that you have that in your packet and you can follow along with me. Is that true?
Yes, that's correct.
Okay, so, all right, well, assuming we can't share the screen, we'll just get started. And so thank you for having us this afternoon to talk to you. And I'm a 34-year resident of this house that I'm in next door to this project. I'd like to say on behalf of myself, my wife, and Michelle Williams, we strongly object to this industrial scale solar power plant to be constructed in our backyard, in our immediate backyard. And as much as I hate to sound like a NIMBY, I am a NIMBY because this is in my backyard. This project is proposed on the iconic Gun Barrel Hill, the most scenic hill in all of eastern Boulder County. This is a great project. All the donations of things to people that, for the donations of electricity, good ideas, absolutely wrong place. Absolutely wrong place. I know that Chuck Rogers is going to make some money, and Kyle, you're a good salesman and you're going to make some money, and Excel Energy is going to get some credit for solar, and people are going to get power donated. Just put it in an appropriate place, and this isn't it. And I have to say, I've read parts of the comp plan, the land use plan, the land use code. I've read the staff response and the applicant's proposal. And I just feel like we're doing an end run on the comp plan and on your land use code. And you have all these maps in there, and I'm going to show you some of them. Most you've already seen. And now you just want to throw them away in most cases and say it's okay. So I'm going to go to my next, my first picture. There's the view. If you can see that, there on the left is the view out of my backyard today. And the view on the right is what it will look like. It'll be a sea of black solar panels in the future. To me, personally, that's unacceptable. My second page has got red and green hand drawing on it. It's the original picture of the solar array provided. I understand it's changed a bit, but it shows the row of 7 houses along the left side along 79th Street. It shows all the various local adjacent considerations, and we'll talk more about those in a minute. But I guess in my opinion, this project is wanting to create a black smear in the middle of the iconic Gun Barrel Hill. My third sheet is a map of Boulder County. It's the Boulder County Open Space and Public Lands map. And if you can see on that map, if you have it in front of you, there's a little red triangle. That's where the site is relative to all the county. And you can see a tremendous amount of green. That is the green open space that's been secured to keep this an amazing place. And a lot of that green is on Gun Barrel Hill. The next sheet is a zoom in of that version. And we've seen this already today, so I won't belabor it, but it shows this site adjacent to all the open space of the city of Boulder, Boulder County to the north, Boulder City / jointly to the east. And there's that red triangle with our sites backing right up to it. And when you think about all of the time and effort and money and tax dollars that have gone into securing all this as open space, and to then say we want to put a black smudge in the middle of that, again, good idea, wrong place. And so my next picture is this one. It is the environmental conservation areas, and you can see the little red triangle again. At least I hope you can. And that little red triangle is entirely within the White Rock and Gun Barrel Hill environmental conservation area. So why do we do these maps if we're just going to ignore them and say, we can put a solar energy generation facility right in the middle of that? That just doesn't make sense to me. The solar facility is not conserving the local land. It's exploiting the local land. It's exploiting it environmentally. It's exploiting it to all the neighbors. But we can talk more about that. My next map is the critical wildlife habitat and mitigation corridors map. I don't think you've seen this one yet today, but it shows the little red triangle is immediately adjacent to Area 88, which is the Gun Barrel Hill critical wildlife habitat and mitigation location. We're right up against it. There's no fence in between there. I mean, maybe there will be a fence in the future, but it's part of the same part of Gun Barrel Hill. And so we have critical wildlife habitat just didn't get put on this map because it wasn't owned at the time by the city of Boulder. Okay, my next map is the one that's yellow and green. It's the significant agricultural land map. And if you look at this map, you can see that the entire Gun Barrel Hill is yellow. Yellow meaning it's lands of significant importance. And yet when you look a little closer and zoom in on that map, there's little bitty pieces of that somehow were excluded from the significant importance category. Kyle talked about it, and I think Sam talked about it. No one's sure how that area got separated out. And Kyle just mentioned there, the local latest opinion is that there is no difference in this land. So call it one or the other. Call it significant agricultural land, and if that's the case, you only get to put 7-acre solar panel on it. But if you want to violate that and go beyond and say this solar facility is okay, then call the parcel all the same. And what that does is allow you to push the solar panels away from the houses. So at the very least, call it the same. Don't, this historic 20 or 40-year-old aerial photograph interpretation about differences. I mean, I've watched the same combine go across this land for 35 years almost, and there's no difference in the land across this area. My next map is it looks like this. It's the green and white map that has the view protection corridors. And on this map, you can see the little red triangle. It borders 79th Street, and it's just south of Mineral Road or State Highway 52, and it's north of Lookout. And those are the roads that go around this iconic Gun Barrel Hill. It's the most amazing views in Boulder County, in the eastern part of Boulder County. Every afternoon, people stop and take pictures of the sunset from 79th Street. People we know have diverted their commute just so they can drive on 79th Street because the view is so important or so beautiful. And you may not be able to see this from Lookout Road. You certainly will be able to see it from 79th Street. And you will be able to see it from Mineral Road or State Highway 52. Staff says, oh, well, it's not a problem because the local residents provide a buffer along 79th Street. Well, I take issue to that. What about our buffer? We don't have one. You saw my first picture where you look over my fence and there's nothing in between us and those solar panels. It would take a row of 20-foot tall mature trees. I'm looking out my window at that field right now, and it would take a 20-foot tall mature trees to block that solar panels all the way to the ridge to the southeast of here. It can't be screened with vegetation like that. And so I was really disturbed when I heard that now staff wants it to go from 8-foot high to 12-foot high, a 50% increase in height for no apparent reason that I could hear today, other than the solar panels, might have to be a little bit different. But good grief, if you're going to do this, keep it at the 8-foot height. I didn't hear a compelling argument for 12 feet. Even Kyle said 10 feet was tall enough. Okay, so my next screen is back to the same picture that I started with. It's the ones of the view out my backyard and what it would look like in the future. But and so I'd like you to look at that and say, would you want this in your backyard, I guess? But there are other issues. We're concerned about the heat generated by 21 acres of black solar panels. We're concerned about the noise. Everybody says these are going to be quiet electric motors. Great. Well, transformers and electric motors, they're quiet until they fail, and then they make a lot of noise. And so certainly we're going to hear stuff in the future. Glare. They say there's going to be no glare, but one of the pictures that Kyle or Sam showed distinctly showed glare from the far end of the solar array, looking at the people that were looking at the solar array. So there will be glare, particularly in the morning when the sun's coming out of the east and bouncing off these things toward our houses. One thing I haven't heard a word about is fire and fire mitigation. These things are going to be underneath. There's going to be wild plants and or weeds, mostly weeds, I guess, and it's all going to dry out. And you can graze it with sheep, but they're not going to eat it like a lawnmower would. And so you're going to have dry vegetation under these things. Someday, if a transformer were to fail, I'm almost done. If a transformer were to fail,
That's the timer. If you could just finish your comment.
Yeah. Well, if it were to fail and the wind came out of the east and it started a fire, it would send the flames right toward our houses. It's too close. We learned a hard lesson last December about wildfire around here. So anyway, that's my presentation. I hope that you deny it. Find a better place, not on Gun Barrel Hill. Thank you.
Thank you, Mr. Fox. Next up, I have Kimberly Shields.
Hi.
Hi, Ms. Shields, if you can state your name and address for the record.
Sure, my name is Kimberly Shields and my business address is 303 East 17th Avenue, Suite 405, Denver, Colorado 80203.
Okay, you got 3 minutes.
Thanks. Hi, commissioners. My name is Kim Shields. I'm with Energy Outreach Colorado. We're a nonprofit that helps Coloradans afford their home energy needs with a variety of energy-related services such as utility bill payment assistance, energy efficiency upgrades in homes, and community solar subscriptions to projects like this one. So I'm speaking today just in support of this project and all of the great benefits that it can deliver to people that need it most. I wanted to share with the commissioners that our organization served over 2,000 Boulder County residents last year with assistance on their past due utility bills. In total, these households carried over $1.4 million in debt because they couldn't afford to pay their home energy costs. And that just represents the people that we had funding to serve. And these numbers were over a 100% increase from the prior year. So energy affordability is a real and worsening issue for your own neighbors right in your county. What that can look like is people making dangerous choices about how to spend their limited income and maybe foregoing necessary medications or even food to try to pay their energy bills and keep the lights on or try to keep their homes warm and safe for their families. So solar projects like this one can provide incredible relief to those energy costs for households enrolled. They can provide monthly bill savings and enable people to be able to afford their bill, keep the lights on, and stay safe and warm. Not only will this project deliver clean, renewable energy to the grid, but it also represents a really unprecedented amount of donated subscriptions that we've never seen before. And so we'd be really excited to see it come to fruition. I think it also is a perfect project to meet sustainability goals, but also represents social, environmental, and economic justice that I think is a national focus right now and should be prioritized. And I just want to say any reduction in the size of the project, as Kyle mentioned, will significantly impact the number of people that we're able to assist with those bill credits. And that would just be millions of dollars lost for those people that need it the most. So I just hope that everyone recognizes kind of the serious situation at hand for a lot of families today that are faced with energy poverty. And this provides an opportunity to relieve that. Overall, I just think that if I ever had the chance, I would more than welcome a project like this in my backyard. So thank you for the time.
Thank you, Ms. Shields. Next up is Robert Woodruff.
Can you hear me?
Yes, we can, Mr. Woodruff.
Okay. I don't know that there's a picture there, but I can guarantee you, you're not missing much.
If you could state your name and
Robert Woodruff, 6082 North 79th Street, Niwot 80503. So our 2+ acres is immediately north of Mr. Rogers' property. And I just wanted to make certain we were referenced in one of the letters of opposition as one of 7 adjacent properties, which I guess is true. And for whatever reason, the construction process by the prior owner of our property was referenced. So just those, so there's no confusion, as one of the 7 adjacent properties and immediately north of Mr. Rogers, we strongly support the project. We strongly support clean energy. We haven't been here long, less than 2.5 years. We moved from central Denver. And if anything, as we have gotten acclimated to Boulder County and Boulder, we're impressed by the commitment to solar, both by the residents and Boulder County, Boulder City. So we're very positive with respect to solar. With respect to the land use, I'm no farmer. I've seen 3 planting seasons. It doesn't look to me like Mr. Rogers' land, and I've never asked him, but it doesn't look to me like his land is really farmed. So I don't think we're affecting the world food supply by converting it to solar. In fact, it seems to be a very good use of that land if it's not going to be farmed. And we've got some solar across the street. As we go back and forth, there's a lot of solar, 75th, both on houses and in fields. I don't find it offensive or unsightly. I've seen some unfarmed farmland that is somewhat unsightly due to its condition or stuff stored on it, that kind of stuff. So don't find it offensive at all. Pleased at the prospect. You got to really admire that it's going to help some less fortunate people. So, and again, I don't know the area intimately, but it seems to me that we're not talking about plopping a solar farm in the middle of recreation use Boulder or Boulder County space. So anyway, those are my thoughts.
Thank you, Mr. Woodruff. Next up, we have Kevin Schneider. Mr. Schneider, I see you in the room.
Can you hear me?
We can hear you. I can hear you, but just barely.
Can you?
It sounds like your connection's a little rough.
Let me see if I can show on a speakerphone. Let's see if I can.
So it looks like Mr. Schneider just left. So for right now, we'll move to Mary Jo. And Anna, if you can see if you can get Mr. Schneider back, that would be great.
Sure, thank you.
Good afternoon.
Good afternoon. If you could state your name and address for the record, and then you'll have 3 minutes.
Mary Jo Bowerman, 7815 Country Creek Drive, Niwot, Colorado.
Okay, go ahead with your 3 minutes.
All right. I just called in today. I don't have a lot to say, but I just want to let you know that I'm totally in support of the solar garden in Colorado with our 300+ sunny days. We have the perfect climate for it. It's a great use of the land to produce a clean, renewable energy source in Boulder County. It's going to help out a lot of people that are less fortunate. And very non-invasive, clean way to produce energy. There's not light pollution. It doesn't create any additional traffic. There's no emissions of any kind. And I don't really see any downfalls. As to the farming aspect, the land is not being farmed. It hasn't been for quite some time. It's dryland farming. It's only being used to produce wheat. There's not much that comes from it. In reality, as far as the fire danger that Mr. Fox was speaking of, I think this will reduce it. With the sheep in there to cut down the weeds and the grasses. When it dries out, and actually before it dries out, it's going to help out the situation. I realize Mr. Fox is opposed to it because he doesn't want it in his backyard. Nobody ever wants these things in their backyard, but they have to go somewhere. It's not really going to be that intrusive. The views up there are to the west, not to the east. Anyway, that's all I have to say. Thanks for your time.
Thank you. And I saw Mr. Schneider up there a minute ago, and he seems to have disappeared again. Anna, do you know if he's...
I did see Mr. Schneider joined, but I now also see that he has dropped off of the meeting. If we want to give him another couple of minutes to join, in the meantime, I do see a number of dialed in folks. If anyone on the phone is interested in speaking, please press *9 to raise your hand so that we can then, I do see an individual here dialed in 303-974-0461. So let me just press allow to talk and then unmute. So you'll need to press *6 to unmute yourself.
Yes, can you hear me?
We can.
Yes. If you could state your name and address for the record.
Charles Rogers, 5980 North 79th Street. I'm the one that started all this. There was a couple of reasons this started. One, keep hearing everybody talk about the farmland. Our last viable crop off that land was 2014. So it's been 8 years. We just harvested 2 weeks ago, and we got 9 bushel per acre. 9 bushel per acre doesn't even pay for the fuel to cut the wheat. That land used to produce anywhere from 50 to 60 bushel per acre in its good days. It seems to be a good option to repurpose the land for a good cause. And I know it creates a little issues with my neighbors and the view, but the view is of generally weeds back there until the farmer comes and sprays, and it's generally always dead. So there's always a fire hazard back there. The sheep and the mowing will mitigate any issues with that. It's great that we can do this and be able to donate all this energy to people that really need it. So I hope you approve it, and we'll do everything possible to work with our neighbors. Thank you.
Thank you, Mr. Rogers. I do see another entry in the chat.
Hi, Chair Bloomfield. This is Anna Milner. So we now have Kevin Schneider and Hunter Lovins.
Okay. Mr. Schneider, was that you chiming in? It sounds like we're still having some audio issues, Mr. Schneider. Well, as we continue again, Mr. Schneider, Ms. Lovins, if you could give your 3 minutes, if you could start with your name and address for the record.
I am Hunter Lovins. I live at 5150 St. Vrain Road, Longmont, Colorado, 80503. And I was actually sitting in on this meeting because of the CEMEX proposal, but this is an important opportunity for Boulder County. These sorts of agrovoltaics actually take carbon out of the air and put them back into the soil. When you graze animals underneath photovoltaics, that act, the plants that grow up are absorbing carbon. When they're grazed by animals, that carbon goes into the soil. The very act of grazing it helps feed the microbiological community in the soil. So you are getting two climate benefits from this project: the renewable energy that's being produced. You're getting the equity benefit from the energy that is being donated to people who really need it, and you're getting the carbon sequestration. And I see Mr. Schneider is here, so I'll shut up. I would strongly urge you to approve this project.
Thank you, Ms. Lovins. Mr. Schneider, I can see you now. Is your audio working?
I hope.
You're still cutting out.
Are you? Try calling.
There is a call-in option, Mr. Schneider. We're having a hard time hearing you. There is a call-in option. If you can see the chat, there's a call-in option, an 833 number with the meeting ID. Okay, and is there anyone else that's waiting in the wings while we try and get this issue with Mr. Schneider resolved?
So this is Anna Milner, staff. I do see that Kathleen Sands and Kathleen Kennedy both have their hands raised. If they could please indicate in the chat whether or not they want to speak. Kathleen, I've tried promoting you a number of times and have been unsuccessful. So I'll try that once more. You'll need to click OK to join as a panelist. There will be a pop-up on your screen. And/or you could put a note in the chat letting us know. Okay, so it looks like Kathleen actually wants to speak to CEMEX, and we're not actually on that item here. We're discussing SU 220004 Pivot Energy. So we will make note of that in the CEMEX speaker sign-up list. Anyone else that would like to speak? If you're signed up or called in via phone, press *9, please. Thank you. So I do see Chair Bloomfield, 2 other individuals. So I will allow them to talk. If you're dialed in on the phone, you'll need to press *6 to unmute yourself. And I do see call-in user 1. Can you please press *6 to unmute yourself?
Schneider is here.
Oh, great.
We can hear
Thank
you.
you.
I
Thank you.
apologize for the poor connectivity. Oh my goodness. This is
Thank
Kevin
you for your
Schneider. My
perseverance.
address is, yes, my address is 5801 North 79th Street in Longmont, 80503. And I had written in a comment letter concerning my support of the solar proposed application. I think for the many numerous items that have been expressed by other speakers prior to me, with the benefits to the low-income community, with the benefits to Mr. Rogers, with the benefit to the community as a whole by reducing the carbon footprint of energy that's generated by fossil fuels. I think all of those are good reasons to support this project. And I would strongly speak in favor of it. I've lived in the area for 22 years now. And as Mr. Rogers had indicated, the land doesn't produce much of anything with regards to cropland. We've got pasture land, which minimally supports a couple cows, and we have to bring in hay to feed the cows because there's not enough water to support the growth of the grasses that are in that area. So I strongly suggest that the commissioners approve the application for the solar complex.
Thank you, Mr. Schneider. I see in the chat that we have Edward Keene, who's being promoted.
Mr. Keene's been successfully promoted. This is Anna Milner, staff.
Okay, Mr.
Hello, my
Keene.
name is Edward Keene. I live at 228 Welch Drive in Lyons, downtown Lyons. I've lived in that house for 30 years and Boulder and St. Vrain Valleys since 1976. Whenever I have an opportunity to travel through the area that you're discussing today, I enjoy both 79th and in particular Lookout Road, so I understand concerns about views. I wanted to call in and support this proposal because it's absolutely essential, echoing Hunter Levin's comments that we move as rapidly as possible away from our climate crisis and towards renewable energy. I'm absolutely enamored of this homeowner who is willing and able to put up. I'm kind of jealous that I'm not able to do this myself quite yet. So I strongly urge you to support this proposal. Thank you.
Thank you, Mr. Keene. And if I'm not mistaken, that's our entire list, unless someone else has put their hand up.
This is Anna Mulder, staff. That is correct. If you're dialed in via phone, press *9 to indicate that you'd like to speak, or enter your name into the chat, name and address, please. Last call to speak to this item. Thank you.
Okay, I'm not seeing any additional. Are you seeing anything on your end, Anna?
I am not. I believe that is everyone that wanted to speak to this item. Thank you.
Okay. Wanted to give the opportunity for staff to make any clarifying statements or respond to any of the public comment. Sam, you have anything?
Hello, can you hear me?
Yes.
Great. Sam Walker, staff. I'm going to try this out on speaker this time, so I'm not holding my phone up to my face. Just wanted to make sure. So I did write down a few notes that I just wanted to touch on. I don't think it's anything too wild. the first thing that I wrote down was a response to Mr. Sundman's request that the timeline for the proposal be extended to 40 years to match the lease agreement they have with the property owner. I don't really feel that there's any strong feelings one way or the other at the staff level about that extended timeline. I think functionally 40 years versus 35 years is probably not a huge distinction that we need to worry about. The 35-year cap was tied to what was explicitly stated in their narrative. So I think if they provided us a revised narrative even before the county commissioners hearing, then I think that would be more than acceptable at the staff level. So I think if the planning commission were to move to change the language to say 40 years rather than 35, I don't think we would have any issues with that whatsoever. Mr. Sundman also mentioned during his presentation the lack of specificity in the, I think it was condition number 12, which addressed the not constructing during wet soil conditions. I actually tend to agree with him. That was something that I had tried to work out ahead of time with our Parks and Open Space staff, kind of trying to get it a more definable time frame where they could or could not be actively constructing. It's my understanding they also may have some issues with the construction timelines once construction begins. So I think there's no recommended changes for that condition at this time from staff. However, I do think it's something that we're going to be revisiting after this hearing is over to try to make it something that they can actually meet rather than something that's just kind of nebulously required of them. I did want to speak, I think Commissioner Goldfarb had asked a question of Mr. Sundman about the closest distance to the property owners. And he gave a figure of 300 feet. I do think that's probably accurate. I did want to note that the structures, the arrays and then any other structures will have to at least meet the minimum setbacks for the agricultural zoning district, which would be 25 feet from all the property lines that are going to be in question. So I think the absolute minimum is 25 feet. I don't think it's the applicant's intention to build arrays that close to the shared property line, but I did want to point out that that's the absolute minimum that we would require. I also did want to maybe clarify a little bit. One of the public comments was just with regard to the environmental conservation areas and what they mean. So I went and pulled up the comprehensive plan, the county's comprehensive plan, which is where those environmental conservation areas are identified or established. And then the mapping that he showed was from there. So those are actually addressed as part of the environmental resources element of the county's comprehensive plan. And just very generally, they're kind of designed to protect specific areas of the county. I've touched on this in hearings for other applications where really the idea behind those environmental conservation areas is to identify a resource or resources that we feel need to be protected. And then we use those environmental conservation areas. They're drawn as a big buffer around those resources, and they act as kind of a tool for the planning staff to know to look more closely at the potential impacts to the resources within that environmental conservation area, whatever they might be. So this is something that I tried to address a little bit more in the actual text of the staff recommendation. It wasn't really described in detail in the presentation earlier, but I just wanted to point out that there were no concerns from staff about the impacts to the environmental conservation area proposed by this application. I think generally our position is that the area is already disturbed. It's already been used for ag land, and this isn't really a big change from that, and it won't really impact the White Rocks or the Gun Barrel Hill environmental conservation area one way or the other. The final thing that I wanted to address was the 7-acre limitation. I do think that we've interpreted that as a code requirement, that we have to meet that requirement in order to recommend approval for this application, the restriction of 7 acres in significant agricultural land. So that's why that condition was written that way in the staff recommendation. That's why we asked for the updated plan from the applicants. Other than that, I'm available for any questions, any final questions the commissioners may have.
Great. Thank you, Sam. Mr. Sundman, do you have an opportunity to make any comments based on public comment or what staff has said? If you would like to say anything.
Thank you, Commissioner. Yeah, I think I won't pull the presentation back up, but just verbally, I first want to acknowledge and share our distinct gratitude to everybody who spoke in support of the project. This is a great project, and it has an immense amount of benefits to Boulder County and especially your low income constituents. I just would like to note something that I did not bring up in the presentation, but based on the way that Xcel Energy awards these projects, there is no opportunity to move the site. So they awarded it on this specific site for a number of reasons. And if this project were to be denied at any stage, there is not an opportunity to revisit this project on another parcel elsewhere. So a denial would equivocate to a loss in the entire project and the revenue provided to the low income constituents. I think that's all I'll say. Thank you again also to Sam and planning staff for supporting us through the project, and the commissioners for hearing us out. And if anybody has any more questions, I'll be happy to answer those. And I guess one other thing is that, we absolutely also appreciate Mr. Fox's comments, and we have continued to reach out to him proactively. We've had multiple discussions on the phone and via email. We are going out of our way to do whatever we can to mitigate his concerns. Obviously, we don't expect him to become a supporter of the project overnight, but I do want to acknowledge that we hear you, Mr. Fox, and I will do whatever we can to try and help this, especially if that means moving it further away from your property within this parcel. Obviously, we would love to do that. But thank you for speaking as well. I think it's important to hear both sides, and we will continue to work with you to mitigate your concerns. Thank you.
Thank you, Mr. Sunman. Sam, I see your hand up. Did you have something you wanted to add?
Yeah, I did. Sorry. Thank you for recognizing that. And I'll also note that this was something I wanted to mention and forgot to, and that Mr. Sunman should be allowed to respond after I finish. But the final thing that I wanted to talk about was with relation to the visual screening. There was a request during his presentation that we recognize their plan to provide stipends for the adjacent property owners to provide their own visual screening, rather than having the visual screening put on this property and subject to the actual approval. So there was a little bit of staff discussion after or during his presentation, and I think where we landed is that we'd be amenable to a condition that provides just some sort of vegetative screening plan or some sort of visual screening plan. And then that plan could involve the stipends, as long as we have a plan that is submittable that we can kind of use as a reference point when we're doing our permitting review. So I think there is an avenue to getting the visual screening to protect the views of the adjacent property owners on their own properties. We just want a more formalized plan to reflect that. So I think that we'd be okay with a slight change in the existing condition, or that's something we'd be willing to work with the applicant on after this hearing is over, in preparation for the Board of County Commissioners hearing. And that's it.
Great. Thanks, Sam. That sounds like a good compromise. Mr. Sunman, did you have any response to that?
We certainly appreciate that, and we do think that's a better solution that more adequately addresses the concerns of the neighbors. So I would appreciate if you would consider that as well.
Great. Thank you very much. With that, I will close the public hearing. Do any of the commissioners have questions for staff or the applicant before we go into discussion?
Yeah, this is Commissioner Rennie. I have a question for staff. I'm not entirely sure what the process was originally for mapping the areas of local agricultural significant local agricultural importance, but given the evidence that the applicant provided, is there a process by which those maps could be amended, or in order to not have that be a code requirement?
Sam Walker, staff. So the way that the significant agricultural lands were originally designated was kind of a long process. It started really in, I want to say, the 70s. It's outlined in the comprehensive plan. I should know it by now because I've been asked this question a few times in hearings. but unfortunately I never seem to really commit it to memory. So here we go. So I think it's probably easiest if I share my screen because I have it pulled up currently. So bear with me for 1 second. Okay. So hopefully you can see that this is the third page of the agricultural element within the county's comprehensive plan. And right here where I'm going to highlight is the kind of start of the definition of those significant agricultural lands. So in the late 70s, the county mapped or designated significant agricultural lands. And then the methodology employed in updating those maps was in 1995, which was using aerial photography. And then we translated that over to some zoning maps that we had, overlaid that on Soil Conservation Service surveys, so like surveys of the soil quality throughout the county. And we kind of cross-referenced the soil surveys that we had with the aerial photos showing the lands that were actively under agriculture or could potentially be used for agriculture. I believe somewhere in here, there's also a description where we reference the availability of irrigation or the potential availability of irrigation as well. So that's kind of the way that they were defined. So it was originally done again in the 70s, and then those maps were updated in the late 90s with some updated information that we had access to. There is, I'm sure, a process to update that mapping. I don't know that this application is the avenue that we could change that mapping in. It's probably something more involved with updating the comprehensive plan itself, which would be a much more robust public process than we're looking at right now. So I'm not sure if that answers your question or not.
Yeah, that does. I think my question was mostly around if there was ability to do it on a parcel basis, like an exception process or something, or like a way to amend it per parcel as opposed to having to amend the whole map in the comprehensive plan. But it sounds like you answered.
Yeah, I don't think we have that ability through this process.
Commissioner Bloomfield, I don't know if there's a way to put a note for whenever you do the review process to add the ability to have an amendment, but it certainly seems like that would be helpful.
There's been some discussions that have maybe reflected that a little bit internally as a result of this and past applications. So I don't know that it's on the schedule for the comprehensive plan updates that we currently have, but it's certainly being discussed at the staff level.
Great. Any other questions for staff?
I have one. This is Commissioner McMillan. And Sam, while you have your screen up, can you pull up the applicant's amended site plan? Do you have that? I just want to make sure I'm clear on what we're going to ask them to do with staff and you if we were to approve this. So looking at that, the area to the south, the significant agricultural land, I understand it to be that they can do no more than 7 acres of disturbance on that portion of the land. Is that correct? And that's
correct.
About approximately 12-acre chunk of land. Is that correct?
No, so it's more than that. Their original proposal extended, I don't remember the exact calculation that I came up with. I want to say it was in the neighborhood of 14 or 15 acres that when I just took a rough measurement of their site plan and then referenced that to the ag lands. This exhibit, which the applicant submitted as part of their response to the change or the kind of more specified requirements we gave them prior to the hearing, is that this is their exhibit showing their original site plan overlaid over it. So their encroachment was 13 acres, or excuse me, 12.2 acres, we'll call it. So that's the area they would have had. So, but the areas that are highlighted in yellow are the entirety of the ag land. So it's probably more in the neighborhood of 15 to 20 acres, if I had to guess.
Got it. So what we're saying in this condition is that they could disturb 7 acres of that, and then the remainder of their array would have to go on the hatched area north of that. And then the only restriction to location of that would be the setback of 25 feet from the property line.
That's correct.
Okay. Thanks for clarifying that.
Sam, while you have that up, I'm curious because on what you have there, it says 10-foot side setback.
Yeah, I think that may have just been an error by the applicants. The required side setback in, well, hold on, before I start quoting things, I should probably just pull up the code, right? Let's see. So the required side setback, oh, it's actually 7 feet in the agricultural zoning district. So I apologize, I was wrong earlier. The required side setback in the agricultural zoning district is 7 feet. They're showing a 10-foot setback, which would have them exceeding it. I mean, anecdotally, the applicants have shown a pretty clear intent to not get as close as possible to the properties. I think we could probably try to establish a more robust setback if we wanted to in order to mitigate the impacts to the neighbors. But that's the required side setback, and the way that the code defines setbacks is that a front is what separates the property from a public right-of-way, and then a side setback is anything that isn't opposite and parallel to the front line. So that means that all of these property lines would have a hypothetical 7-foot setback. They would all be considered sides.
Okay, thank you. Any other questions for staff before we go to discussion? Okay, I'm not seeing any. So I'll open it up for discussion. Anyone want to kick it off? If not, I'm
This is, or go for it. Go for it.
No, go for it, Chris. You've already unmuted yourself. So
This is Commissioner Whitney. I think this sounds like a really great project, right? Like it's rare that we get a project in which the exceptions why we're approving the exception is so perfectly aligned with multiple facets of the comprehensive plan in terms of not only providing renewable energy, but this is increasing the economic value of the land use, and then also the benefits for the low income program. So I think it is very much in keeping with kind of the spirit of the comprehensive plan. And then just kind of these projects also in terms of what Boulder County considered significant agricultural use. We've seen things like Jack Solar Garden provide kind of a different take on a significant agricultural project in the community. And I could see this project playing out similarly, especially as the applicant noted, like kind of opportunities to do some research on agrivoltaics here, or just in general, changing a row crop into a prairie seed mix, right? Like there's opportunities certainly with this project to kind of not use the traditional definition of agricultural lands or significant agricultural lands in Boulder County, and use kind of more of the direction and what the community supports as significant agricultural uses. And I think that was my overall comment. It seems like we're fighting a little bit the rules versus what I think would be the better outcome in terms of just that little strip of significant agricultural lands. Because certainly if we could push that from 7 to 12 within kind of the rules, it seems like that would be a win, both in terms of moving it from the neighbors more and also being able to provide the array that they want to build. But I'm not entirely sure how we do that without kind of violating the zoning rules there. So open to more discussion on that as well. And that's that's my initial comment.
thanks. This is Commissioner Bloomfield. I agree with what Commissioner Whitney has said. I'd actually encourage staff to see if there is an opportunity to have some kind of exception between now and the commissioner's hearing. I agree that I think it would be a better outcome for everyone. And I don't want to hold up the project based on that either. One thing that I actually meant to say at the end of public testimony, which I did not, was, staff has made presentations on the people that have the opportunity to attend planning commission meetings. And there are a lot of people who, for various reasons, who can't attend because they've got jobs and they can't take time off, that sort of thing. And I would suggest that the very people who would benefit from this type of project are probably the least likely to be able to attend these kind of meetings. And so I just wanted to kind of put their voice into the room in support of the project. Yeah, I would say overall I'm in support. I certainly, there's always trade-offs with sort of impacts on private property owners and then public benefit. For me here, the public benefit significantly outweighs the impact on the private property owners, and I'm hopeful that the applicant can work with the private property owners to really mitigate the impacts as much as possible. Those are my comments. Oh, I'll also say that I'm in support of extending it to the 40 years.
Commissioner McMillan, I agree with all the sentiments that have been expressed thus far, so I won't repeat them. Other than to say I'm really encouraged by the vegetation under the array. I think that's a really neat development that we've seen and a lot of research going into it, and I'd like to see that proliferate, and maybe we can be a leader in this county on developing that technology and biodiversity moving forward. So I thought that was great. It's gonna be one of my suggestions, so I'm glad to hear it. The only thing I'll add is that I certainly, empathize with the neighboring property owner. It's a big change. I don't think we should push that aside. It's going to be a different backyard. So, whatever we can do, and this is probably a comment to staff, to move this thing into the southeast corner of that property. I understand the limitation with the 7 acres. I fully get it. And if we're beholden to that and we can't move past that, I think just moving this as far to the east as possible and making the array the right size that, it meets the needs of the applicant to provide the power that they need, yet still provides that buffer. I want to make sure we acknowledge that comment from the neighbors and do everything we can to kind of limit that impact. So to me, that means pushing it to the south and east as far as possible. Other than that, I do believe that the application meets the conditions of approval, and I also agree with the 40-year cap. We can amend the condition, I think, to read that way, and I would vote for approval with those changes. Thank you.
Thank you, Commissioner McMillan. I also want to acknowledge that Commissioner Kennedy has rejoined the meeting. Glad to have you back. Any other comments? Looks like Ann, you have your hand up.
Yeah, thank you. I would agree with Gavin. This is Commissioner Goldfarb. I would agree with Gavin about the location and moving it as far as possible from the neighbors. And also, this is, again, a comment for the applicant and for staff that I would like to see everything possible done for the neighbors in regard to screening, whatever can be done. I would like to see as much as possible done to help them out in that regard.
Thanks, Ann. I certainly concur with those comments about pushing it as far away from the residences as we can. Any other comments or discussion?
Yeah, this is Commissioner Kennedy. Thank you, Commissioner Bloomfield, for acknowledging I've rejoined. I was not able to hear all of the public testimony, and so I plan to abstain from the vote if and when we do vote. But I just wanted to say that, like, on the record, that I do approve of the application. I think that a lot of you have brought up a lot of good concerns in areas to consider. But should I feel comfortable to vote, I would be certainly voting to approve. Thanks.
Thank you. Kim, I see you have your hand up.
Yes, I just wanted to offer one additional suggestion based off of the discussion that the Planning Commission was having in regards to the location. So another option would be to condition that it may be allowed in a different location if the Boulder County Comprehensive Map is amended in the future. And then we can, as a staff, visit to see if we're able to get that on our timeline for amendments and bring it forward to Planning Commission and the Board of County Commissioners later this year. So that
Great.
that is an option to allow some flexibility on the location.
Great, thank you.
This is
Okay.
Commissioner Goldfarb. Do you suggest specific language, Kim, on that? In a
You're muted, Kim.
Muted, famous mute button. We can craft something and offer it to you, but I do think it's just something along the lines of what I literally just said. So maybe the location may be, amended and move further, whatever direction you want to move it into the significant agricultural lands. If the Boulder County Comprehensive Map is amended in the future, and leave it at that. And then as far as the, staff working it in to our timeline, we can figure that out on our own. But I think you could approve it as applied for if the Boulder County Comprehensive Map is amended.
Okay. Thanks, Kim. Any other discussion?
This is Commissioner Whitney. Yeah, thanks, Kim, for that, just because I feel like this is a case where certainly the applicant has provided a lot of evidence that the 1978 and 1995 kind of definition of what was good soil for farming in the area may no longer be true. And so given that they've done all that homework, it feels kind of inconsistent to use the old data against this project when certainly there's significant research and evidence that they've provided that that's no longer true. So if that would be an option, I'm definitely for that.
Agreed. Does anyone have a motion if we don't have any further discussion?
This Commissioner Whitney, I have a motion, but I was working on trying to write it up with the additional changes. I'm just referencing what the.
While you're doing that, I'll remind you that Sam had some amendments to the change as well.
Yes, I believe it's.
I'll interject as well as Commissioner McMillan. Sam, if you could you put up the language from those changes on your share screen? Just I think that'll make it easier on whoever's making this motion. If Sam is still there.
I see him.
Okay.
You're muted.
How about there we go. Hi, Sam Walker, CPMP. I'll share my screen. There was a few different conditions that were recommended for changes. So I just wanted to point out it might be easier to make a motion for approval with conditions as amended in the staff presentation or something like that, and then adding on the condition that Kim recommended after the fact. But I've got my screen shared if you want to take a look and make changes to any of the amendments that we're looking about.
I guess I would request striking the also in number 2. The height of the proposed fence is also limited to 8 feet.
This is Commissioner Whitney. I'll give it a go. Let me know how I do. I move to recommend to the Board of County Commissioners conditional approval of docket SU 22004 Boulder County Pivot Energy Solar Facility with the 18 conditions listed in the staff's recommendation, with the edits outlined by the staff's presentation, and changing Amendment 9 to read 40 years, and adding an amendment that the location of the array may change if the Boulder Comprehensive Plan map is updated before the project is approved. I don't know what that language is, but
I think that's close enough.
Commissioner Fitch, I would second Commissioner Whitney's motion.
Cam, is that enough for you?
What I would just suggest, I think that's gets to the intent of it. What I might suggest is that you say the location as proposed by the applicant may be approved if the Boulder County Comprehensive Plan map is amended in the future. I think that was pretty close. I just, instead of saying that the location could be changed, I think we want to talk about the precise location that the applicant had initially proposed.
Commissioner Whitney, okay. The location as proposed by the applicant may change if the Boulder County Comprehensive Plan is updated.
Okay. Sam, are you still a second to that?
Yes. Amendment accepted.
Okay. Any further discussion?
This is Commissioner Goldfarb. Yep, Mark.
Yep.
You said something in reference to the condition number 2, and you cut out for a minute for me. Could you repeat what you said?
Oh, I just said that I wanted to strike the also, because it says also a height limit of 8 feet for the fence.
Can that be put back up so I could look at that while you're telling me what you said?
Oh, sure.
So you're
the
saying
second sentence, the height of the proposed fence is also limited to 8 feet, but we're no longer limiting it to 8 feet. So I just wanted the also struck.
I see what you're saying. Okay, thank you.
Mm-hmm. Okay, any discussion before the vote? Hearing none, roll call vote. Mark Bloomfield, aye. Sam Fitch.
Aye.
And Goldfarb.
Aye.
Gavin McMillan.
Aye.
Connor Kennedy.
Abstain.
Chris Whitney.
Aye.
Okay, it's unanimous with one abstention. Thank you, Sam. Thank you to the applicant and everyone who participated in the public process.
Thank you, commissioners.
So we have one item remaining, the CEMEX plant. I would propose a break before we get on to that one. What do the commissioners think? 10 minutes, 15 minutes?
Uh, 10 should suffice for me.
Okay. Looks like I'm getting some nods. So let's go ahead and take a 10-minute break, which will have us back here at 5:02. Anna, could you hang on for a second just so I can try and look at audio issues?
Sure. Rick, could you also remain, please?
Yeah.
Yes.
Are we out of public streaming?
We actually are still live and recording, Commissioner Bloomfield.
Okay. Do we pause that for the break?
If you can bear with me one moment, Rick and I can convene and see how we might best test your audio. We are still streaming and live though, so we'll be right back.
Okay.
Commissioner Bloomfield, this is Anna Milner. I will send you a separate meeting invite in Teams so that you, Rick, and I can troubleshoot your audio.
Okay, why don't I go ahead and I'm gonna restart my computer. And then, I mean, I guess one question is, how do I sound right now?
I think you sound great. Rick, can you confirm? But I think you've resolved the issues with the headset.
Okay, I'm gonna restart my computer then and see if that can help with the video aspect.
That sounds good.
And then I will get back on as soon as I can.
Perfect.
All right, thanks y'all. Hi, Anna. This is Mark. Can you hear me?
Hello, Mark. Yes, we can hear you very well.
Okay. Let's hope it stays that way.
Thank you.
2, 4. Okay, so it looks like we're all back. And are we recording? Or can we just jump back in?
This is Anna Milner, staff. Yes, we can proceed. We're recording and streaming.
And Mark, excuse me, this is Richard Hackett, staff. I would just suggest that you take a roll call again at this time. Remember, just to make sure we have the recording of which planning commissioners are present for this agenda item.
Great idea, Rick. Thanks. Mark Bloomfield here. Sam Fitch.
Here.
Ann Goldfarb.
Here.
Gavin McMillan.
Here.
Connor Kennedy.
Here.
Chris Whitney.
Here.
All right. So we are up to our last agenda item. This is a public hearing for docket SU-22-0003, CEMEX Dowe Flats. Oh, sorry. Yeah. Mining and Reclamation Extension. We'll now hear from Pete Larange from the staff. Would you please present your staff report?
Absolutely. Let me bring up the presentation. Good afternoon, Commissioners. Pete Larange, CPMP staff. As stated, this is for docket SU-22-0003, CEMEX Special Use / Site Specific Development Plan Extension. The request is for a special use site specific development plan review to amend an existing special use approval SU-93-14 for limestone / shale open mining / coring located at the Dowe Flats Quarry, extending the approved mining activities for an additional 15 years with commitments of record in order to mitigate the land use impacts of the proposal. The property is approximately 709 acres. Zoning is agricultural. The owner is CEMEX. Representatives of the project are Pam Hora and John Heffernan. Here is the location map. You can see north of Highway 66, east of Lyons. Aerial. This is the comprehensive plan map. As you can see, there are a number of identified resources in the area and on the subject parcel, and we will look at all of those in a little more detail as we go through the review. But there are a number of comprehensive plan concerns on the site. Public lands map. You can see the county conservation easement on the subject property, as well as the county open space surrounding it. Staff would like to note that this review is specific to the Dowe Flats property, which is north of Highway 66, which is the operating under the Colorado State Mining Permit M 1993-041 and Boulder County Land Use Approval SU-9314. There is also the Lyons Quarry and Cement Plant. These are not under review as part of this application. That is, the Lyons Quarry and Cement Plant operate under Colorado State Mining Permit M 1977-208 and is considered a legal non-conforming status under the Boulder County Land Use Code. This is a map provided by the applicant. It shows on the left, it shows the boundaries of the current SUP, special use permit area. And then on the right, the proposed boundaries, which have been reduced to just that kind of light blue section inside the yellow dashed line. The other areas would be excluded from this proposed extension and would not be involved. Some site photos. This is part of the conveyor system to move the materials from the quarry
across the road to the processing plant. Just some the landscape around. A lot of the landscape surrounding is former mining land that has been reclaimed. Looking west. This is starting to look down into the mining pit area, looking north. The Rabbit Mountain trailhead across the way. And then some idea of the actual mining activity, pouring activities going on site currently. And then this is looking kind of southwest. You can see the crusher facility that's on the Dowe Flats property here. And then across the way, this is part of the cement plant, which again, is not under review as part of this application. To provide a little bit of docket history for this case, as stated, SU 9314, which we have termed 14A, is the original approval. It approved the operations with conditions. Those included the conservation easements, the development of the conveyor system, periodic reviews, a limit on hauling and loading if winds are more than 30 miles an hour, the required reclamation, cultural resource plan, and that required that mining be complete within 25 years and reclamation within 3 years after that, with all activities to cease within 31 years, which would be 2025. SU 9314B was an amendment for temporary operations center. 14C was the 1-year compliance review. At that time, it was found to be in compliance with the approval of SU 9314 with the addition of a catalog of cultural resource monitoring activities. SU 9314D is another amendment to the approval for an amendment to the temporary operations center. And then 14E, F, and F2 are the 3, 5, and 10-year compliance reviews. During those reviews, it was determined that the project was in compliance with the original approval. And finally, SU 9314G was the 20-year compliance review. At that time, it was found to be in compliance with the addition of ground disturbance monitoring, working with Parks and Open Space on issues surrounding wetlands and ditch management, weed management, and prairie dog management. As far as referral responses, from the Boulder County Community Planning and Permitting, Access and Engineering team, they looked at the application materials and concurred with the trip generation estimates provided by the applicant in their pre-application methodology statement dated October 17, 2021. And as such, they found that they did not anticipate the mining and reclamation use to have any negative impacts on the surrounding transportation network, and stated that they had no concerns with the continued use of the subject property for mining and reclamation activities. Boulder County Public Health stated that they would be willing to support the mining extension if the applicant would commit to completing upgrades and improvements to the plant, and they outlined those specific upgrades. Again, the plant is not under review as part of this application. Boulder County Parks and Open Space found that the proposed mining at Dowe Flats will not extend outside the current area of disturbance, and rather it would just result in the mining activity going deeper within the existing footprint. Therefore, they found that the additional disturbance to environmental, cultural, and open space resources is limited. However, they did note that the 15-year extension prolongs the disturbance, which has already happened, and the impacts to nearby land. The department also determined that the commitments of record from the applicant have important benefits, and as part of that, they included detailed comments about the application as well as recommended conditions of approval. Those were included with the staff recommendation, with the staff packet. Additionally, Boulder County Parks and Open Space Natural Resource Planner stated that they agree with the applicant's premise that the impacts to natural resources would not significantly change because The mining activity footprint would not be modified, and the future impacts can be interpreted as a continuation of the existing previously approved conditions and impacts. They did note that if the proposal is approved, the mitigating commitments noted in the application, the long-term public benefit would significantly increase due to the payment changes and the public disposition of many parcels after mining and plant closure. The Town of Lyons submitted their referral response. Just for the record, the original deadline for referral responses was extended at the request of the Town of Lyons to provide them more time to look at the application and provide a more comprehensive response. These comments reflect that comprehensive response. The town has stated that they oppose the proposal and recommend denial, and have stated that they believe that the town should have been included included in the initial negotiations. They have stated they would be open to a 5-year extension with certain conditions. Staff would note that their statement, mining permit M 1977-208, says the plant must be decommissioned if mining operations north of Highway 66 cease. Based on staff's review of the materials, including those permits, we do not find any basis for that statement. They also questioned the related plant permits and GEM audits, and noted that nothing would stop them, the applicant, from asking for another extension in 2037. They stated that the facility and the plant violates federal clean air regs, and that there was nothing to stop them, the applicant, from selling to another general industrial operator. And then they noted some of the current ongoing planning efforts that are either ongoing or soon to be under development. The referral response from Larimer County stated that they had no concerns. We received no comments from a number of different agencies, including notably some of the water conservation districts, City of Longmont, as well as Colorado Department of Natural Resources, Division of Reclamation, Mining, Safety, and the Colorado Department of Transportation, U.S. Environmental Protection Agency, Region 8, or the Hygiene Valley Fire Protection District. In total, staff has received 106 comments from the public. I believe the commission was provided all of the comments that were received as of noon today. Since that time, we have received 7 additional comments. Those 7 are reflected in these numbers. It was just too late to send them on to the commission as part of this review. All 7 of those fell into the opposition category. Total, there were 7 comments in support, 85 in opposition, and 14 that staff have classified as other. The comments in opposition focus on environmental and wildlife impacts, greenhouse gases, including some that have suggested that a new environmental impact statement should be drafted. Several of the comments spoke directly to dust and a history of permit violations, as well as light and noise at night. Some spoke specifically to traffic concerns. One noted blasting without notice. Several cited minimal economic impacts, and several suggested that the continued operation has potential negative impacts on property value. A number of comments could be classified as saying that the plant could be sold to someone else who would continue to operate it. And then a number of comments suggested that if the Dowe Flats quarry were to be closed, that the cement plant could not continue operating because it would not be feasible or would not be allowed. And then several noted that the offers were not enough to mitigate the impacts. The primary statements in support focused on jobs and employment. Those comments that staff classified as other were mostly related to a request to delay the planning commission hearing or asking about the process in general. Staff would note that there was some misunderstanding that this had been scheduled for a hearing in July, that it had not been scheduled for. So that's where those requests to delay primarily came from. And as those comments were received, staff tried to clarify and address that. As far as the special use criteria, it follows under Article 4-601A, and the criteria 1, except as otherwise noted, the use will comply with the minimum zoning requirements of the zoning district in which the use is to be established, and will also comply with all other applicable requirements. In this case, open mining is an allowed use in the agricultural district through the special review process. So it meets that part of the criterion. Additional provisions specifically to open mining use include that the property is not required to be located on a building lot or comply with minimum lot size. However, in this case, the property does both. It also requires that the use shall be granted and maintain all applicable local, state, and federal permits. Staff would recommend as a condition of approval that the applicant be required to obtain and maintain all of those applicable local, state, and federal permits. And then finally, that the processing of mining material may occur on the parcel where the mining is situated or on a parcel owned or leased by the mining parcel owner, lessee, or operator, provided the parcel is located within 1,000 feet of the mining parcel. In this case, it's across Highway 66. So staff found that as conditioned, this criterion can be met. A2, compatible with the surrounding area, and in determining compatibility, should consider the location of structures and other improvements on the site, the size, height, and massing of structures, number and arrangement of structures, design of structures, proposed removal or addition of vegetation, the extent of site disturbance, including any grading and changes to natural topography, the nature and intensity of the activities, and in determining the surrounding area, the board should consider the unique location and environment of the proposed use. In looking at this, staff determined that there is no proposed change in use and no proposed new structures. And staff determined that the utilization of an existing mining site is a rather unique situation, which may allow for this criterion to be met subject to the conditions of approval. The specific conditions of approval under this criterion that staff identified include that the applicant develop a grassland reclamation plan consistent with the approved reclamation plan and reflective of the pre-mine vegetation potential of the site, that the applicant submit a final reclamation plan for review by Boulder County Parks and Open Space staff at least 6 months prior to December 31st, 2037, and that the applicant shall make a good faith, reasonable effort to incorporate into the final reclamation plan requests for modification from Parks and Open Space staff. Staff also found that the footprint of disturbance under the extension would not increase. Rather, again, it would just go deeper. Continuing on A2, the staff did find that the extension would prolong the visual impacts. In the long run, the reclamation will mitigate these. County Parks and Open Space does not support the wetlands as proposed by the applicant and recommends a revision of reclamation plans to grassland. And staff determined that the extension provides the opportunity to refine that reclamation plan, and the applicant has agreed to work with County Parks and Open Space to do that. Therefore, as conditioned, staff finds that this criterion can be met. A3, the use will be in accordance with the comprehensive plan. In looking at this application, staff specifically looked at elements 3, 5, 7, 10, and 11. That's cultural resources, environmental resources, geology, open space, and public health, respectively. As part of that, staff looked at considerations such as the cultural resource monitoring that is ongoing, the impacts which have already occurred, the required reclamation, and the post-extension closure of the Lyons cement plant, and recommended mitigation measures, including continued enforcement of the cultural resource management plan, and county involvement in the grasslands management plan, as stated in criterion 2, and the acquisition of land by the county post-reclamation. Therefore, as conditioned, staff finds that this criterion can be met. A4 will not result in an over-intensive use of land or excessive depletion of natural resources. In evaluating this, board should consider the extent of the proposed development in relation to parcel size and the natural landscape and topography, the amount of blasting, grading, and other alterations to natural topography, elimination or disruption of agricultural land, the effect on significant natural areas and environmental resources, the disturbance of plant and animal habitat and wildlife migration corridors, the relationship of the proposed development to natural hazards, and available mitigation measures. In looking at this criterion, staff determined that no new land would be excavated, again, rather just deeper in the same location. And staff did again find that it would extend the period of the impacts which have already occurred. Staff found that the post-mining reclamation and preservation of open land would be a significant mitigating impact on this project. And as outlined in the staff recommendation, noted that as a condition of approval, that the commitments of record from the applicant and the conditions of approval as outlined under criterion 2 would be would mitigate the impact. Therefore, as conditioned, this criterion can be met. A5, not have a material adverse impact on community capital improvement. No indications that there would be any adverse impact, so this criterion is met. A6, this use will not require a level of community facilities or services greater than that which is available. There were no identified adverse impacts, community facilities or services. Therefore, this criterion is met. A7, the use will support multimodal transportation system and not result in significant negative impacts to the transportation system network or traffic hazards. Again, as stated earlier, the access and engineering team concurred with the submitted pre-application methodology statement and found that there would be no negative impacts to the transportation system. Therefore, this criterion is met. A8, the use will not cause significant air, odor, water, or noise pollution. In reviewing this application, staff found that the mining activities operate under an air pollution emissions notice and a stormwater permit as issued by the State of Colorado Department of Public Health and Environment, and that there are no records of violation at Dowe Flats. The staff would recommend as a condition of approval that the operations at Dowe Flats continue to be subject to 5-year review and assessment by county staff, which is consistent with the original approval. Staff also found that the indefinite continuation of operations of the cement plant would have significant ongoing impacts. As included in the commitment of record from the applicant, the closure of the plant at the end of the 15-year period would be a significant mitigating factor under this criterion. Therefore, as conditioned, this criterion can be met. Number 9, the use will be adequately buffered and screened to mitigate any undue visual impacts of the use. The existing mining pit and most of the quarry operations are not visible from the public roads. Those portions that have already been impacted and were already approved. The ongoing activities would not change this visibility, again, as the mining operations are simply going deeper in the same location. Therefore, as conditioned under the previous criterion, this criterion can be met. A10, the use will not otherwise be detrimental to the health, safety, or welfare of the present or future inhabitants of Boulder County. Obviously, there are inherent risks and environmental impacts of open mining. However, staff found that these impacts are mitigated by the recommended conditions of approval, most significantly the closure of the plant and the eventual acquisition of open space by the county. Therefore, as conditioned, this criterion can be met. A11, the use will establish an appropriate balance between current and future economic, environmental, and societal needs by minimizing the consumption and inefficient use of energy, materials, minerals, water, land, and other finite resources. Staff found that the proposal balances the societal and economic needs for cement and concrete by providing for efficient extraction and transportation of raw materials while mitigating the environmental impacts. Those mitigation measures are outlined in the previous criterion. Therefore, as conditioned, this criterion can be met. A12 will not result in unreasonable risk of harm to people or property. Staff noted that the site does have multiple geological hazards on it, primarily as a result of the mining activity. However, the site is not open to the public, therefore the risk to the public from geological hazards is relatively low. And likewise, reclamation as required will address and remove these hazards. Therefore, with the previous conditions of approval related to reclamation, this criterion can be met. And finally, A13, the proposed use shall not alter historic drainage patterns and or flow rates unless associated development includes acceptable mitigation measures to compensate for anticipated drainage impact. The original drainage patterns on site have already been impacted, and it is not expected that there would be any new impacts from the extension. And again, the reclamation will mitigate these impacts. Therefore, as conditioned, this criterion can be met. As such, community planning and permitting staff recommends that the Planning Commission recommend that the Board of County Commissioners conditionally approve docket SU 220003. And I'm happy to answer any questions.
Thank you, Pete. Does the commission have any questions for staff?
This is Commissioner Fitch. I have a significant question about the decision of the staff to only consider the on-site impacts of the mining itself, in essence, to separate the question of the mining from the use of the mining materials across the highway. But I would recommend that we have the applicant make its presentation first, and then we come back to that question.
Okay. Any other questions from the commissioners?
Commissioner McMillan, I have just one question. Is there any guidance in the code with regards to how to consider the duration that's being requested? Or is there a criteria for approval that maybe speaks directly to that request? I guess what I'm looking for is some sort of way or part of the code that consider the 15 years that have been requested versus some other amount of time. I mean, how do you review that as a staff member on this?
There's nothing specific in the code that speaks to, a specific time frame on these kind of reviews. It's simply a matter of, I don't want to use that word. It is a matter of looking at the cumulative impacts that would happen over the whatever period of time. In this case, looking at this application, the 15 years is what was requested by the applicant. And the impacts do not appear to, be significantly more or less, again, on-site related to the Dowe Flats site, based on the time frame involved.
Thanks. I appreciate the response. That's my only question. Thanks.
Any other questions for staff? I've got a couple. This is Commissioner Bloomfield. One was there's mention of Boulder County Public Health supporting it conditional to agreement for upgrades to the longstanding dust and maintenance issues. I didn't see that CEMEX agreed to that. I don't see it in the conditions. I'm wondering if I missed something.
No, those were not included in the recommended conditions of approval. Again, simply because the cement plant is operating under a different state permit. It's operating under essentially as a separate entity, and those issues are related to the cement plant. And it was established. The cement plant and the operations at the Lions Quarry were established before Dowe Flats, and it's considered a non-conforming use. So there's,
sure. I mean, we have a condition that with the 15-year extension that the plant will cease to operate at the end of the 15 years. So it seems like
we could consider that because that was a commitment of record made by the applicant.
Okay. Let's see. I think that's all I have for now. Anne, I see your hand up.
Yeah, this is Commissioner Goldfarb. In your presentation, you mentioned that some of the comments reference permit violations. Do you have any information on that?
I did a little bit of looking into that. I could not find any record of permit violations on the Dowe Flats property and related to the mining operations there. In looking at the Lions Quarry and the cement plant, there are some records of violations. However, from what I could find, there is nothing outstanding and no current violations.
Thank you.
Any other questions?
Commissioner McMillan, one follow-up question. Is the operation of the cement plant, just to be clear on this, without the I guess offer to close it that is associated with this application, is there any other, I do realize this is a separate property, so I'm asking this question because I think they are tied together, but is there any other method by which that cement plant could close other than just the decision of the owner to close it?
As it's considered a legal non-conforming use, it would be allowed to continue to operate indefinitely, separate from, again, the commitment of record under this application and the offer from the applicant.
Okay, thank you.
Any other questions for staff? Okay, hearing none, we will move to the applicant's presentation.
This is Anna Miller's staff. The applicants have both been promoted and should be able to speak when they're ready.
Okay, if you could start with stating your name, and you'll have 20 minutes for your presentation. Sorry, name and address.
Sorry about that. It was taking a while to generate. Can you see and hear me?
Yes, we can. Let's try
Okay. My name is John Heffernan. My address is 10100 Katy Freeway, Houston, Texas. Good afternoon. Thank you for having us. We're here today to present Dowe, CEMEX's Dowe Flats Special Use Permit Mining and Reclamation Extension Application. Again, I'm John Heffernan. I'm VP of Business Development for Cement Division. Joining me today from the CEMEX side are Mark Davies, the Director of Aggregates and Cement Resources, Jeray Carlson, Senior VP of Sustainability, Communication and Public Affairs, and Michael Clausen, Corporate Social Responsibility Specialist. Mark or whoever's controlling, could you advance the slide? Go ahead and there you go. So that's everyone I just introduced. If you could go to slide 3. We're also joined by consultants, Pamela Hora, a senior planner from Tetra Tech, and Robin Bay, a senior environmental scientist from Habitat Management. So with that, I'm going to turn the presentation over to Mark Davies. Mark, are you?
We can't hear you, Mark, if you have.
Yeah, we can't hear you. I see your name, but.
Yes, can you hear me?
Yes.
Yeah. All right, we're trying to get the video to connect. There we go. There we are. You can hear and see me?
Yes.
Great. Thank you, John. Thank you, commissioners, for taking this evening to hear our application for an extension of the special use permit to extend mining at the Dowe Flats Quarry for an additional 15 years. We'd also like to thank others who are participating on this virtual meeting, our fellow employees at CEMEX, as well as our neighbors that live in and around us at Lyons. You can see in front of you 2 separate drawings depicting on the left the current special use permit boundary, which represents 1,810 acres. And on the right, the proposed special use boundary, which represents 709 acres. So that's a reduction in the SUP footprint of greater than 60%. Also in that drawing, you could see the current mining area on the left, which is about 385 acres, and the proposed acreage on the right, which is approximately 112 acres. And that is a reduction in proposed mining area of greater than 70%. I've got some items blocking my view of my screen here. So reasons for approval, reasons the extension is being requested, because we've been asked why over the past 25 years since 1997 have we not mined all the resources from the Dowe Flats property. Just like the economy in general, there are fluctuations in the construction market over any period of time, and certainly over 25 years, there have been ebbs and flows. As a result of that, there is more ore remaining on the Dowe Flats property that can be utilized to produce clinker, which is then ground to produce cement. Also, there are 4 separate ore ridges on the Dowe Flats property, and in between those ridges, there's what we call inter-ridge material that initially was thought to be waste, but we found over time that portions of one of those ridges could actually be used as our raw feed. So as in compliance with Boulder County sustainability guidelines, we did our best to utilize as much material on site for better extraction efficiencies and utilization of natural resources. Another one of the main reasons, of course, for extending the life of the Dowe Flats Quarry is preserving jobs at the quarry site itself. These jobs are good family wage based jobs with full benefits. They're jobs that most communities would be proud to have, and we would be proud to extend and preserve those jobs for an additional 15 years. Again, the responsible and efficient use of local resources, continuing to mine out of an existing quarry would prevent new quarries having to be open either in Boulder County or elsewhere, and that material having to be trucked to the site. So some reasons for the approval of the SUP: there will be no change to the mining operations. The mining will continue as it has for the past 25 years. As I shared earlier, the reduction in the size of the county permit boundary by greater than 70%. I'm sorry, the permit boundary is a reduction of about 60%. The mining footprint is a reduction of greater than 70%. The continued conveyance of material from Dowe Flats directly to the cement plant, which prevents alternate sourcing and delivery and reduces a significant amount of truck movements that many similar type operations would have. Dowe Flats operates in a manner compatible with other land uses in the area. Topographically, the area is quite flat. There's a large buffer area surrounding the property. You almost need to be in the quarry to realize the impacts and the fact that there is a mining operation there. And as was stated in the staff report, CEMEX is committed to working with open space to modify the current reclamation plan to return it back to a prairie habitat. Specifically, what is being offered by CEMEX is Dowe Flats will be sold to the county for a price of $0 plus title and closing costs, which is a $6.6 million savings over the current agreement. We're offering an additional 200 acres around Dowe Flats to be available for a cost of $0 plus title and closing costs. We're offering to increase the lease price we pay significantly on the buffer property around the quarry. This was property that was previously owned by CEMEX and has been or will be optioned to Boulder County. That payment over 15 years represents an additional $6 million. We'll offer a permanent, non-exclusive recreational trail easement along the south bank of the St. Vrain River. And we'll also offer to the county the option to purchase approximately 830 acres of land for open space around the cement plant. In this property, portions of this property is in Lyons planning area and will be subject to the town of Lyons approval per the Boulder County and Town's IGA agreement. And the big offer is, of course, CEMEX's commitment to close the separate operation, which is the cement plant on the south side of State Highway 66, after 15 years of additional mining at the Dowe Flats Quarry. As explained by the county staff and in their recommendations, our application does or will meet the 12 special use review criteria. Actually, I think there were 13 that were stated in the presentation. CEMEX does, however, request minor modifications to conditions of approval 7 and 11. And that The suggested language there is the applicant shall sign a real estate option or other agreement that comprehensively documents the applicant's commitment to grant Boulder County options to acquire land and easements from the applicant. The new agreement shall be mutually acceptable to CEMEX and the county. Modification of approval to item 11. We suggest at the expiration of the 15-year extension, as dated from the date of approval by the Board of County Commissioners, the operator shall cease all operations at the Lions Quarry site and carry out all required reclamation. This shall include the permanent closure and deconstruction of the Lions Quarry cement plant and the reclamation of the plant site per DRMS requirements. So our request for recommendation of approval, we respectfully request that all the conditions be approved as written by county staff, by planning staff, except for the slight modifications suggested in conditions 7 and 11. And that for docket issue 220003, CEMEX Dow Flats Mining and Reclamation Extension be approved. Thank you for your consideration this evening.
Thank you, Mr. Davies. Pull up my in here. Okay, so does the board have any questions for the applicant?
It's Commissioner McMillan. I just have one related to the duration of 15 years that was requested. Can you provide some background as to how that duration was determined?
Yes, Commissioner. Through discussions and negotiations, quite frankly, with county planning staff, that number was agreed upon. We actually requested a longer timeline initially, but through many months of conversations, that's the number that was agreed upon.
Is it your anticipation that you need the 15 years to remove the remaining material on site?
I'm sorry, can you repeat that question, please?
Yeah, no problem. Is it your determination that you need, I guess, the 15 years to remove the additional material on site?
Yes, yes, Mr. McGillen, by our McMillan, by our estimations, yes, we would need that additional 15 years to properly utilize the resources on site.
Thank you.
I have a question. Oh. Okay, thanks. Mr. Davies, you had mentioned that the quarry employs local residents. How many jobs are we talking about at the quarry, and any estimation of what percentage would be Boulder County residents who are also residents who would be affected by the effects of having a quarry close by?
Yeah, there are currently approximately 10 employees at the quarry. It's an efficient, well-run operation. They move a lot of material per man hour. As far as number of employees that live in the area, we do have that number. And we are looking for it. We have it for all the employees. For the quarry staff itself, yes, there are currently 2 employees from the quarry that live in Boulder County, one of which is a Town of Lions resident.
Okay, thank you.
This is Commissioner Bloomfield. A couple of questions. if you're not successful today and the quarry does close, where would the materials for the plant come from?
They would have to be sourced offsite. They would be trucked to the south side to the plant area.
Do you have any idea where offsite that would come from?
Yeah, I mean, the limestone may come from as far as 90 miles away. You'd think there would be a lot of limestone along the front range of the Rockies, but there really isn't. It mostly occurs in thin ridges, much of which has been mined. We currently mine limestone and shale at the Dowe Flats quarry. Historically, more limestone, more recently, more shale. So both of those would have to be sourced off-site. The shale is used as an alumina source. It wouldn't necessarily have to be shale. It could be other products such as fly ash, for example, recycle fly ash from power plants, which is also a source of alumina.
Okay. And do you have an estimate of how many trucks per day that would be?
That is a good question. We can run that number very quickly.
Okay. While you're running that number, maybe you can just answer me. Another question: is anything trucked to the plant right now, or is it all from across the street?
No, we do currently truck limestone from offsite. We still do mine some limestone at the Dowe Flats quarry, but as that played out over the years, the predominance of the limestone has started to come in from offsite. So Dowe Flats over time has pretty much become a shale source. Now the shale there is a bit unique in that it has a lot of calcium in it, so it provides a calcium component that we can use, which helps us minimize the amount of limestone that has to be used.
Great. Were you able to get the number on the number of trucks?
They're calculating those numbers now.
Okay. Does anybody have any questions while those calculations are going on?
I'll call the material in. How many trucks a day would that be?
Oh, you muted yourself.
All right. That really is a cement plant question, which we haven't prepared to answer, being that this application is specifically for Dowe Flats. But yes, if the Dowe Flats quarry shut down, everything would have to be trucked from offsite.
Okay, thank you. I didn't hear that there were any other questions for the applicant. Is that correct? Does it have any come up? In that case, we will go ahead and start with public testimony. We currently have 40 people signed up for public testimony. Pull up my list for that.
Commissioner Bloomfield, I think we have a hand raised from Pete.
Oh, Pete, yeah. Do you have a comment? Thank you.
Pete Larange, CP&P staff. Just wanted to clarify that the negotiations were between the applicant and Parks and Open Space, not CP&P staff. Our role has simply been to determine whether the application meets the land use criteria.
Yes, thank you for clarifying that. I was asked to clarify that as well on our end, so thank you.
Okay.
Mark?
Yes.
I'd like to ask Pete a question.
Go ahead.
Can you respond to the claim that the the plant could continue to operate as a non-conforming use regardless of whether it had actually expanded operations or the conditions had changed. I think there's an impression there that's incorrect, that non-conforming uses can go on forever, no matter how different the circumstances are from the original permit.
As a non-conforming use, if it continues to operate and function the way it has, then it can continue to operate. As far as this one in particular, source of the materials would not come into play in that. It would continue to operate as a cement plant.
Thank you, Pete. Sam, did you have any other questions there? Okay, we'll go ahead and move to public comment. I will first read our instructions for public comment. All members of the public will have a chance to speak, even if you didn't sign up from the Planning Commission homepage beforehand. Once those who signed up in advance have spoken, I will call for any additional members of the public to speak. If you joined by computer, you can sign up by submitting your first name, last name, address, and docket number in the chat box to the right. As each person who has joined by computer and signed up to speak is unmuted, Zoom will adjust your participant status so that you can speak. Once you're finished speaking, Zoom will place you back in the room as an attendee. If you've dialed into the meeting via phone, please raise your hand by pressing *9, and we will unmute you and we will call on you to provide comment. When it is your turn, the system will request that you unmute yourself with *6, either via computer or phone. Please state your name and address for the record before providing comment. Each speaker will be allotted 3 minutes to speak. A timer will beep at the end of your speaking time. We request that you finish your sentence and your time. Pooled time. Time can be pooled at 3 minutes per person for a maximum of 10 minutes if you have 4 people together. You will need to provide the names and addresses of the other people, up to 3 others beside yourself, who are in attendance and donating their time to you. Anyone who is pooling time will need to attend the virtual hearing so that we can verify your presence as we would at an in-person hearing. Please do not submit comments or questions in the chat box during the meeting. The chat box is for speaker sign up only. Please remain on mute when possible. We will mute you if we see that you're a source of background noise. Members of the public will be unable to share their screen during public comment. And with that, we will go ahead and open public hearing. Our first sign up is Mary Dobbs.
Chair Bloomfield, this is Anna Milner. I don't see that Mary Dobbs is present in the attendee list. Mary, if you're dialed in via phone, could you please press *9 to raise your hand?
Okay, we'll go on to the next one, and if Mary makes herself known, then we'll allow her to speak. Holly Rogan.
Hi, yes, good evening, everybody. Holly Rogan, I'm the mayor of the town of Lyons. The address is 432 Fifth Avenue in Lyons. Appreciate the opportunity to speak tonight. I know what it's like to have 5-hour meetings. We just had one on Monday, so appreciate you. And you have our referral response, so I'm not going to repeat that information. But what I want to say is that this application is the result of negotiations between Parks and Open Space and CEMEX. At the very least, the town of Lyons should have, for the start of our 2012 IGA with Boulder County, been involved in those discussions, because this decision directly affects our access and plans for 120 acres of our primary planning area at the Lyons Quarry. This is a great deal for both open space and CEMEX. It is not a good deal for Boulder County in general and the town of Lyons specifically. And I'd like you to know that exactly 4 Lyons residents work for CEMEX. There are two statements that have been made that are either demonstrably false or unable to be proved true. The first is that the two sites are not linked. According to Amy Eschberger at the Division of Mining and Reclamation, they are. If mining at Dowe Flats ceases, the Lions Quarry permit must be amended in order for CEMEX to continue plant operations. If the amendment is not submitted or not approved, plant operations must cease. The second is that CEMEX will continue to operate the plant indefinitely if they're not granted this extension. When would any publicly held $14 billion per year multinational corporation make a decision that would produce less value for their shareholders? Now, when I asked the plant manager what his end game was, because closing a profitable plant after 15 years does not seem like a great business model, he told me that CEMEX is building a much more efficient and less polluting plant on the Colorado-Wyoming border. Understandably, CEMEX would like to get as much profit as possible out of the Lions plant. Now, from an environmental and social justice viewpoint, consider this. The community closest to Dowe Flats is the Shady Lane Mobile Home Park. That means its marginalized residents are closest to the fugitive dust storms that blow silica into the air, which are documented. As in many communities, the poorest and most marginalized residents live closest to the biggest polluters. The CEMEX Title V Clean Air Act permit expired 16 months ago, and no one thus far has been able to tell us the status of its renewal application. Also consider that should this extension be granted, that makes certain that 900,000 more tons of coal will burn at the Lions plant, emitting more than 5.5 million tons of CO2 into the atmosphere. The plant burns 7 tons of coal per hour, 24 hours a day, 365 days a year. Yes, we need cement, and there are far more ecologically sound ways to produce it. The town of Lions strongly urges you to recommend denial of this application to the Boulder County Commissioners. Failing that, we urge you to recommend a 5-year extension with reclamation on both Dowe Flats and the Lions Quarry sites commencing immediately thereafter. I thank you very much for your time.
Thank you, Ms. Rogan. Next up is Kathleen Sams.
This is Anna Milner's staff. Ms. Sands, you've been promoted. You can speak and share your video at any time.
Oh, sorry, I needed to unmute. Did that work? Can you hear me now?
Yes, we can hear you.
Okay, great. Okay, so my feelings as Lions Climate Action Group founder is that CEMEX, this Global 2000 company, needs to go now, not in 18 years. They promised they would leave in September 22, and it's what the town of Lions wants. It's what the Boulder County citizens want. I know that Boulder County wants different, they want acquisitions of land and such and open space and whatnot, but it's not what the citizens want. It is your job to do what the citizens want, the Boulder County in general. This proposal is not good for our community, our treasured town of Lions, nor our Boulder County's people because of the huge amount of pollution it spews out. I also believe the plant and mine are tied together, so I'm speaking as such. And I believe that if we do not extend the permit, the plant will cease for feasibility reasons. They're not going to go 90 miles away and truck it in. I don't believe it for a second. And it could be the first step to ridding one of the largest polluters in our state, the 4th largest polluter in our state. So can they show their financials on the trucking and on the materials? I'd love to see that. And I think Boulder County would love to see that as well. If that's what we're basing our decisions on, I think we should see those financials. Concrete is a huge reason for climate change. And no, we do not need concrete. In Canada, they've been using hempcrete for a decade. It does not pollute. In fact, it sequesters carbon, and it has many more qualities that cement doesn't have, including it's fireproof. Fireproof. This is what we should be building Superior with those 1,000 homes. This is fireproof hempcrete. The plant's from 1969. It's been outdated and needs to be torn down. The circumstances have changed, as we mentioned earlier in this call, and that is that we are in a climate crisis. They are the #1 polluter in Boulder County. As I mentioned, the #4 in Colorado, one of the top worldwide in CO2 emissions. This should be enough right there to say no to this 15-year extension. But I'm going to go on. Boulder County has a responsibility to adhere to their sustainability goals that it's published to reduce CO2 emissions by 50% in 8 years. That's 2030. How can we let them spew out over 350,000 pounds of CO2 per year and meet those goals? It is not possible. The second polluter in Boulder County, by the way, puts out 55,000 tons. That would put us on track getting rid of them for those goals, very much so. The dust coming from that site spews onto my child, who I just brought to school for the first day in middle school, right behind the plant, about a mile from the plant, directly west. Hygiene Elementary School gets that dust just east of the plant. Lyons Elementary, the third school, is just north of the plant. We should not be polluting those children on a day-to-day basis like that. My mother lives in town of Lyons, right across from Town Hall, and has asthma and has been sick. Farmlands are getting soot. The water usage is huge. CEMEX's overhead pipe.
Ms. Sands, that's your time. So thank you for your comments.
Thank you.
Next up is Bart Lorang.
Good evening. My name is Bart Lorang. I live at 12800 North Foothills Highway in Lyons, and I've been a Boulder County resident for 25 years. I'm one of the founding members of Good Neighbors of Lyons. We've spent thousands of volunteer expert hours over the past year analyzing and unpacking the very complex and nuanced issue regarding CEMEX operations in order to educate the nearby community on this extraordinarily complex topic. Much of it is available at goodneighborslyons.com. First off, as Mayor Rogan's touched on, I would also encourage the board and staff to review the correspondence from DRMS on goodneighborslyons.com, which directly refutes staff and applicant statements regarding Lyons Quarry Permit M 1977-208 and its linkage to Dowe Flats as the sole remaining activity under that permit. As Commissioner Fitch astutely noted, the recommendation packet consistently states that the cement plant is not under review as part of the Dowe Flats application proposal. This position serves to effectively discard all of the public concerns regarding continued operations of the plant. In doing so, it has disregarded the overwhelming majority of public comments advocating for the rejection of the proposal. Now, logic, as well as the legal doctrine of cherry picking, dictates that given the decision to focus narrowly on matters related to Dowe Flats, any theoretical future benefits from the cement plant closure or any other benefits not related to Dowe Flats parcel must also be stricken from basis for recommendation. In other words, the Dowe Flats extension should be able to stand on its own merits, and the Planning Commission should take a narrow view of this application with consideration on so-called unrelated parcels removed. So real estate incentives, financial incentives, or far afield environmental benefits or otherwise. Specifically, the following incentives must be excluded from basis for decision. 1, purchase options for property south of Highway 66 should be discarded from consideration. 2, additional parcels north of Highway 66 provided for $0 should be discarded from consideration. 3, the St. Vrain Greenway Trail should be discarded from consideration. And 4th, and finally, the 15-year conclusion of the cement plant should be discarded from consideration. When looking at the recommendations through this narrow scope, 6 of the 13 special use review criteria can no longer be met. For the board's convenience, we have posted a redlined version of the recommendation with these elements removed on goodneighborslyons.com. To be more specific, special review criteria number 3, number 4, number 8, number 9, number 10, and number 11 are all supported by theoretical future benefits on parcels that have been deemed not part of this application. And thus, all of these criteria should be reevaluated. As a result, I cannot see any reason why the Planning Commission would agree that an extension of Dowe Flats aligns with the comprehensive plan as in the best interest of citizens. CEMEX is asking for 15 years of mining on land that is already under control in Boulder County through ownership or purchase options, and reclamation is due to begin in a couple short years and converted to open space. The recommended approval is not logically nor legally coherent and is not aligned with the comp plan. nor the special use guidelines. The planning board cannot cherry pick and include theoretical long-term benefits from unrelated parcels. I recommend rejection. Thank you.
Thank you for your comments. Next up, Julia Hertz.
Chair Bloomfield, this is Anna Milner's staff. I don't see Julia Hertz listed in our attendee list. Julia, if you're dialed in via phone, please press *9 to let us know.
Okay, we'll come back to her if she makes herself known. Renee Doubleday is next.
Good evening, everybody. I'm Renee Doubleday. The address is 4651 Ute Highway in Lyons. I am a partner in a commercial business or commercial real estate development in the town of Lyons. And I would just a couple of comments. So I'm with Commissioner Fitch in terms of, I don't think you can separate the Dow Flats application from the operation of the plant, because the plant does rely upon that. And because of that, it just seems inconceivable that the town of Lyons was not at the table during these negotiations. It's my understanding that they were purposely excluded. And Mr. Davies, with all due respect, thanking the neighbors of Lyons for showing up is not, it just rings hollow when they weren't at the table and you didn't have conversations with them all along the way. So I think that is it's a huge miss, as Mayor Rogan has said. And if you look at the referral document, there are just pages and pages of boards, commissions, citizens who are not in favor of 15 years. And that's not to say that there can't be some negotiation here. And I think there could be a win-win for CEMEX and Boulder County and also for the town of Lyons. So I would encourage that we look at something else. I did want to just call out section A601, I think it was 4.5, not having material adverse effects on capital improvement programs. Well, to Mayor Rogan's point, this is in Lyons' primary planning area. Currently, the town of Lyons does not receive any tax revenue from CEMEX, and yet we're pushing 15 years down the road their primary planning. And so this little town needs, it needs help to grow and have money to support itself and to be a thriving community, which it deserves to be. So I would also vote to reject 15 years and possibly look at something else, like Mayor Rogan suggested, a 5-year plan.
Thank you, Ms. Doubleday. Next up is Paul Tamburello. You can state your name and address for the record.
Excellent. Thank you, everyone, for your time today. My name is Paul Tamburello. I'm the owner of the property at 4652 Ute Highway, which is the former Longmont Water Treatment Plant. I have two comments. The first is I applaud the Planning Commissioner's support of the solar array in the previous agenda item, particularly as it relates to its impact on global warming. And I simply wanted to note that as it relates to the topic at hand, that CEMEX is, as I understand it, the largest polluter in the county, and this extension will make it very difficult or impossible for Boulder County to meet its 2030 climate goals. The second point I want to make is about a conflict of interest. Boulder County Parks and Open Space is a co-signer on the application and a co-applicant as a result of their role as a co-applicant and a referral agency, as well as the substantial economic incentives, over $16 million offered to Boulder County Open Space. The department has an inherent conflict of interest as a regulatory or as a referral agency. And I'm asking today for their comments to be stricken from the record. Certainly any supporting arguments for special review criteria originating from Boulder County Open Space should be discarded. Frankly, I believe that Boulder County Open Space should have recused themselves from responding to the referral packet at all. Should a referral packet from Boulder County Open Space be necessary, an independent recommendation should be set up as a subject matter expert appointed by planning department should be substituted in their place, in my opinion. And that's all I have for today. Thank you.
Thank you. And next up is Stephen Brose.
Good evening. I'm Stephen Bross from 3240 Folsom Street in Boulder. And thank you, commissioners, for taking my comments and for this marathon meeting, for all your hard work. Appreciate it. And I'm basically simply repeating the comments that have been said by Mayor Rogan. And I oppose this measure, the continuation of this permit, on moral grounds and on environmental grounds for what's been said before me. And I will cede the rest of my time to Hunter Levins, who's 25th on the list. So thank you very much.
Okay, thank you, Mr. Bross. Amber Revoir. Hopefully I've got that pronunciation right. Ms. Revoir, it seems like you're, oh, there you are.
Thank you for your patience.
Okay,
My name is Amber Revoir. I live at 645 3rd Avenue in Lyons. As a Lyons resident affected by CEMEX on a daily basis, I'm very much against this measure and request that CEMEX be held to its commitment of closing the Dowe Flat site this fall. There are negative consequences to CEMEX's continued operations, including diminished air quality for Colorado residents and visitors, as well as detrimental impacts on local wildlife. This is not a clean, efficient business doing its best for the environment and the local community. While the applicant would like us to consider Dowe Flats as a separate entity of their plant, these locations and operations are literally linked by the imposing conveyor belt sprawling over Highway 66. It's all CEMEX. Considering an extension of mining is a stamp of approval for CEMEX's continued bad behavior and destruction of our environment. CEMEX is the largest greenhouse CEMEX is the largest greenhouse gas emitter in Boulder County, with environmental issues and pollution leading to disciplinary measures in the recent past. They also provide little value to my community with a mere few Boulder County residents on staff. Conversely, the town of Lyons was disregarded in the Planning Commission's recommendation. Lyons residents are thousands of CEMEX's closest neighbors and must be involved in the future of this site. For these reasons, I would like to see Boulder County decline the 15-year extension proposal. I would also like further research to be done into the environmental impact of CEMEX operations. I cede any extra time to Hunter Levins. Thanks for your time.
Thank you, Ms. Revoir. And next up is Stephen Dalton.
Good evening, everyone. I'm Stephen Dalton. Address is 645 3rd Avenue. Thank you for allowing me time to speak today. I'm speaking as a concerned resident of the town of Lyons regarding the CEMEX plant proposal. I'm strongly urging the Planning Commission to reject CEMEX's proposal. In the draft recommendation, Boulder County's Planning and Permitting Division staff states that the visual impact of Dowe Flats is negligible. If I understand that correctly, visual impact is a key factor of the Planning Commission's evaluation of CEMEX's application as it pertains to the comprehensive plan, referenced as special review criteria number 2 and number 9. The conveyor belt that crosses Highway 66 from the Dowe Flats mine to the CEMEX plant is part of the Dowe Flats permit, thus making it part of the mine. The conveyor belt tube has been a frequent topic among locals for decades and has been nicknamed the brown worm for its aesthetically displeasing appearance. It's highly visible to the community as well as the approximate 4 million visitors who pass through Lyons every year when driving to Estes Park and Rocky Mountain National Park. Lyons takes great pride in being known as the double gateway to the Rockies. As you approach Lyons traveling west on Highway 66, you are greeted by spectacular views of Mount Meeker and Longs Peak in the distance. In the middle distance, you can see gorgeous red cliffs and hills that surround our town. However, this pleasant welcome to the foothills and incredible views are unceremoniously interrupted by the Dowe Flats conveyor belt, a weathered, rusted, outdated, oversized piece of mechanical tubing that momentarily blocks these views, doing a great disservice to the first impressions of the area. All that to say, this eyesore is hardly negligible. I strongly recommend that the Planning Commission reject CEMEX's application and proposal. Thank you for your time.
Thank you, Mr. Dalton. Wiley Hobbs is up next, and it looks like you're pooling time with Alberta Schulman for 6 minutes. Have we confirmed that Alberta is in the meeting, Anna?
Alberta is present and I've just promoted her.
Great, thank you. Mr. Hobbs, go ahead with your name and address first.
Good afternoon. My name is Wiley Hobbs. I live at 11683 Point View Drive, 80503, in the North Point subdivision, near the intersection of Hygiene Road and Highway 36. And I would like to thank you for letting me speak today. I know this has been quite a long meeting, and I've been here since 1:30 as well. So I'm happy to begin speaking finally. So I have to start off by saying that I'm actually appalled by how this issue continues to be open for discussion. I recognize the magnitude of this decision. However, I know that despite how complex the interested parties are making it out to be, the issue is really quite simple. We need to put our community first. That's it. That's plain and simple. That's it. I understand that the situation has an unreasonable amount of apparent uncertainty, but the one thing that is certain is that we actually can move forward in our community by rejecting this application. We have other options. I have the absolute pleasure of having an unobstructed view of this entire mining operation from our porch. I get to look at it every day. I love it. I don't love it. Let the record state that I don't love it. I frequently hike Rabbit Mountain, and it's so sad to look down and see the pits at Dowe Flats. I don't agree with the narrative that the Dowe Flats permit is unrelated to the plant permit. They are intrinsically linked due to the fact that Dowe Flats mining is useless without the plant and vice versa. So let's keep that clear. From my porch, I see trucks moving and scooping toxic silica throughout the day, activities that are always followed by large dust clouds that blow across the homes, farms, and wildlife habitats miles away. I have pictures detailing these clouds. I've submitted them for public comment, so feel free to browse them. I observe dust clouds. I feel rumbling activity. I hear noise and blasting from Dowe Flats. The plant area is constantly shrouded in a cloud of dust, no matter the weather. If they can't even control the dust from driving on a dirt road or from raw materials arriving down the conveyor, what else aren't they controlling? How can we trust CEMEX to live up to any of their promises outlined in SU 9314A if they aren't even capable of controlling something as simple as this? What other violations are they making that we just don't know about? In addition, it simply cannot be overlooked how dangerous these issues are to our community and how little monitoring and oversight is missing from the proposal, and let alone what is missing currently to date. There is no monitoring. The truth is, we don't know nearly enough about what is being emitted, and that alone is incredibly scary and remains unaddressed. Pete, I heard you mention that the public health elements were met, but you did not explain anything about how this is going to be done. Thank you, Mark, for calling this out. I appreciate that. Why didn't planning staff include even one of the Boulder County Public Health requests for improvements to the facility in their recommended conditions for approval? There were over half a dozen, and I am deeply concerned that our county public health department's very important and very reasonable suggestions were discarded in their entirety by the planning staff. What else has been discarded? I've heard this condition can be met quite frequently in this discussion, and I don't know why. Overlooking these health impact concerns have only been exacerbated by the fact that we are expecting our first child in January. We do not want to have to worry about birth complications, health impairments for our child. And I cannot even imagine what it's like for current parents to live closer to the mining operations. These are things that we should never have to consider. Never. I'd like to ask each one of you to take a few seconds and ask yourselves how close you would let your children live and play to this plant in this mining operation. Mark, John, would you live next to this mining operation? I witnessed you all in the beginning of this meeting express concern over the safety of people over fire pits and a rental property. But this issue is leagues beyond, and I hope you understand the gravity of the situation. The CEMEX plant is actively hurting everyone and everything around it, and despite what they will say, it is your duty to uphold the safety and well-being of the citizens of Boulder County. So please reject this application. If you have ever thought about your personal legacy, especially if you have children, you have a tremendous opportunity right in front of you. There is simply nothing else you can do as an individual that will even come close to the impact of rejecting this permit extension application. Corporations like CEMEX are doing everything in their power to make you think otherwise, and they have been since the 70s. But we have been duped for far too long, and it's time to change now. We need to put our community first, not the interests of a corporation who has proven time and again that it does not care about our community. I will conclude by recalling the fact that the only decision that needs to be made is whether or not we value the health of our children, our neighbors, and the wildlife around us, the quality of the air that we breathe, the food that our local farms grow, and the water that we drink, and whether or not that's more important than the profits of CEMEX. That is all what we need to consider. That is all. That is it. I'm here today because I'm a member of the community and I care about everyone and everything in it. CEMEX does not and simply cannot, as a corporation, their only loyalty is to profits. CEMEX does not care about Boulder County. None of the reps from CEMEX here today even live in Colorado. And honestly, John Heffernan probably won't even be alive to see the consequences of their actions today. Think about that. We have so many other options, including the one Holly proposed. This proposal is not one of them. Thank you.
Thank you, Mr. Hobbs. Chad Welch is up next.
This is Anna Milner, staff. Mr. Welch, I've attempted to promote you several times. Oh, and it looks like maybe you did just click the button that needed to be accepted, so thank you.
Mr. Welch, it says you're connecting to audio, which often means there's a button you have to press to connect to audio. Now it says you did not connect to audio. While we try and get Mr. Welch sorted out, next on the list that I have, Anna, is Selwyn Goldstein.
Selwyn has been promoted.
I am not seeing Selwyn. Oh. I see Mr. Welch trying to connect.
This is Anna Milner, staff. Selwyn, you will need to press OK when Zoom notifies you that you're being promoted to panelist. There we are.
Oh.
So it looks like we have Mr. Welch.
Hello?
Is this Selwyn?
Yes, this is Selwyn Goldstein.
Okay.
All right.
If you can state your name and address for the record, and then you'll have 3 minutes.
My name is Selwyn Goldstein. I live at 649 Wade Road, Longmont, Colorado, for 15 years. I've been breathing the smoke from the CEMEX plant for 15 years. I have lived in Boulder County for 52 years, since 1970. I love this place. You're letting CEMEX, the largest polluter in Boulder County, continue to pollute. The railroad tracks that supply the CEMEX plant with coal run 75 feet behind my back door. On Tuesday and Thursday, they haul 20 cars of coal to the CEMEX plant. They're burning, they're polluting. I can't believe my county commissioners are letting them extend this permit. In 15 years, they're going to ask for more. Don't you realize this? They're a corporation. They don't care about us. You're supposed to protect me and my family. Please do not allow CEMEX to continue to pollute in Boulder County. Thank you very much for your time.
Thank you, Mr. Goldstein. A point of order, Commissioner Kennedy had to leave. We do still have 5 members present and hence a quorum. Okay. Did we, Mr. Welch, are you able to unmute yourself?
I believe I'm unmuted. Can you hear me?
Yes, we can hear and see you.
Okay.
If you could state your name and address and then go ahead with your 3 minutes.
I live at, my name is Chad Welch, and I live at 11730 Point View, right across just to the west of the plant. And just, I'm in consensus with everybody I'm listening to. I oppose the application. I think it has to continue the negative environmental impacts is a tragedy. I think we should not do it. This serves nobody, saves CEMEX. They will survive without it, but the impact on the county and the area, the environment, this is an opportunity to stop it. And I think we should, I oppose it. So I'll leave it at that. And I thank you for your time.
Thank you, Mr. Welch. Next up is Lily Trienens.
Hi, this is Lily Trienens at 1336 Steamboat Valley Road in Lyons, and I'm here with Adam Dolezal, and we both cede our time to Amanda Domenico.
Okay, Anna, do you have that on the list?
This is Anna Milner staff. I can combine Lily and Adam with Amanda Domenico for a pooled time total of 9 minutes.
Okay.
We'll update the spreadsheet with that.
Thank you. Another point on seeding time. We can't seed the remainder of time. We don't have any way to track time. So if you speak for 1.5 minutes, you can't seed your other 1.5 minutes to someone else. Okay, looks like Marshall McClung is up next.
This is Anna Milner staff. I don't see that Marshall McClung has joined us unless he is joined via phone, in which case you'll need to press *9, Mr. McClung, to identify yourself.
Okay, while we're waiting on that, we will move to Jack Devil. Jack, I see you're unmuted. If you could state your name and address and go ahead.
Hi, folks. I'm Jack DeBell.
at 4500 Steamboat Valley Road here in Lyons. Thanks for what you're doing, and long day, I know. Back in 95, I built a modest house about 3 miles northwest of the plant. A modest house on some acreage right around 6,500 feet. Shortly after CEMEX started, I've endured the rumble of the crusher and the veils of ash and dust on my metal roof. I was hoping that the limestone would run out, they'd move on, the county and state could purchase and eventually restore the area, beginning, as I was told, in 2025. So during those 25 years, I also volunteered with Boulder County Solid Waste Advisory Board. And the county, some of you know, is very proud of reducing its greenhouse gas emissions with award-winning waste reduction, recycling, and composting programs, which its citizens widely support. So when I heard that CEMEX is the largest single emitter of greenhouse gas emissions in the county, I began to see all of our work in climate action overturned by the very company I've been impacted by for all these years. So I dug a little deeper into the emissions that they're reporting. And it's true. In 2020, total emissions are up 10,000 tons per year than 10 years prior. And if CEMEX operates as is for another 15 years, they'll load a substantial amount of CO2, roughly another 8 million more tons. So how can the county possibly expect to realize their climate action goals with the single largest gas emitter in Boulder County still in operation? Has trucking materials to the plant, now that the limestone has run out, been seriously looked at? Has the projected truck count on a very dangerous road, I might add, Mr. LaRange, and the gas so that these trucks guzzle even been calculated? It didn't seem like it a moment ago. So with all due respect, planning staff, you folks need to step up for our future faster and higher than you've been. So I urge the Planning Commission and the Board of County Commissioners to act promptly to end mining beginning September 30th of this year. The area should become Boulder County open space in early 2025 and begin to be restored with the expertise that our county's parks and open space is renowned for. Thank you, and I yield.
Thank you, Mr. Devil.
It's D-Bell.
D-Bell, excuse me. Elizabeth Dominic is up next.
This is Anna Milner, staff. I believe Ms. Dominic is called in via phone. I've allowed her to speak. You'll need to press *6 to unmute yourself, Ms. Dominic.
I do see someone with the last 4 digits of 2758. Again, you can unmute yourself with *6.
Hello?
Hello, Ms. Dominic.
Yes. Oh gosh, I didn't know that I had signed up to speak, but I do have a question that's just come to me during this presentation.
If you could start with your name and address.
I'm Biz Dominic at 11443 Crane Hollow Road in Longmont, 80503. So I have been in and out and off and on this property since 1965. And remember back when my father referred to the plant as Martin Marietta, I believe. And it's been a bit of a problem ever since for those of us looking west and hearing the noise. And my concern and my question or comment is, has anyone discussed the light pollution at night? It's getting brighter and brighter every year. And this is just a great opportunity to just ask that question and just see what what and where I can get information on the light pollution coming from the plant. And I know this seminar isn't actually about, or this questionnaire isn't exactly about the plant, but that's my question.
Thank you for your time. Next
you.
up, we have Jocelyn Farrell.
Hi, can you see me okay?
Yes.
Okay, great. My name is Jocelyn Farrell, and I am at 140 Stone Canyon Drive in Lyons, Colorado. I am the Mayor Pro Tem for the Town of Lyons. I am the liaison to the Planning Commission for the Town of Lyons, and I am also a former commissioner for the Planning Commission for the Town of Lyons. However, tonight I am here with you as a private citizen. I have lived in Lyons for 15 years. And first, I want to thank you for this opportunity to speak. I know what you all are doing it's a difficult process. However, I'd like to talk about Dowe Flats and the cement plant. They are well within the Town of Lyons 3 mile planning area. In fact, Dowe Flats and the plant is only 2 miles from our town limits. So logically, Dowe Flats and the CEMEX plant are incumbent upon each other. They are not separate entities as being pitched in the application this evening. Lyons has more than 2,000 residents being impacted by the 357,000 tons of carbon emissions each year from the plant. The best future growth opportunities for Lyons is directly east of town along Highway 66. Instead of allowing 15 more years of mining, let's plan now for a net zero eco village that contains affordable housing, solar generation facility that can power the entire community of Lyons. You just approved a new solar farm, which I think is fantastic, and we can do the same together here. I think that Boulder County planners should work with the Town of Lyons. Together, we can be on the forefront of innovative housing, economic vitality, and a commitment to real environmental equity and protection. So let's not wait another 15 plus years and 5.5 million tons of more carbon emissions. And it does have a cumulative impact on our community and our surrounding neighbors. So instead, let's work together, work with the town, and reject CEMEX's application and proposal. Thank you.
Thank you, Ms. Farrell. Next up, we have Molly Hardman.
This is Anna Milner, staff. Ms. Hardman, I've attempted to promote you several times. You'll need to click OK when the pop-up appears asking if you agree to be promoted to panelist. So I'm going to do that once more. Chair Bloomfield, I'm not seeing that Molly is being promoted successfully. So
Okay, we'll come back to her if we get that worked out. I'll take a second to just say that I appreciate everyone's patience with our Zoom format here. We're trying to allow everyone to have their turn to speak, and sometimes technology can work against us, but we're all doing the best that we can. So we'll go with Cecilia Gertz.
this is Anna Milner, staff. I do not see that Cecilia is present. Cecilia, if you've dialed in, please press *9.
While she's doing that, we'll go with Edward Keene. Mr. Keene.
Mr. Keene, you've been successfully promoted. You can speak whenever you're ready.
Thank you. Edward Keene, 228 Welch Drive, which is in downtown Lyons. I've been around Boulder County now for about 47 years, 30 years in my home in Lyons. I remember when this mine began, and the promises that were made at that time, that at this time here, September of 2022, we would be done. So I guess my first argument is a moral one. Why are we not doing what we said we were going to do? And how does that play into part of the promises that CEMEX and Boulder County Open Space is making right now, that in 15 years we'll be done? I think it says that in 15 years we'll be doing this exact same stuff again, especially when you consider a thing that's not in this proposal, that's not been addressed this evening, and that is there's a chunk of land that's not being talked about, which is where the plant is. It's not a big chunk, it's 100 or 200 acres. And my understanding is I've read through 1,445 pages of documents, is that that land is retained by CEMEX. I don't know how that stuff all adds up. The idea, and you know, it's hard to go 21st here and not repeat some things, but the idea that these two properties are not connected is absolutely false. And I recommend to you planner commissioners to go back to your staff and say, hey guys, let's take a look at the state permits. Let's see what they say about it. I've done that. The state has told me that without the Lions Quarry, then the cement plant is done. So from their point of view, it's kind of like one big permit, even though there's two. The air control folks in the state of Colorado has one permit for this operation, the mine and the factory. That sounds like a connected operation to me. So the state of Colorado has confirmed exactly the opposite premise, that these things are very much connected. Let's pretend though for a minute that they're not, just for fun, which I don't believe is true. If they're not connected and you guys approve 15 years of mining, what if CEMEX decides to close down their factory for some reason? It breaks, or the regulations become so great that they're not able to continue manufacturing the cement part. What happens to all those materials for 15 years? Or should you guys also be considering, you know, where does that stuff go? How many truckloads is that? What is the load on Highway 66 and all the other highways where it needs to go to either Florence, or there is a green factory under construction, or up to the border of Wyoming that you guys have discussed this evening? If they're not separated, then how do you accept the gifts or whatever these are, bribes of $17 million worth of open space and trails and whatnot? I don't understand how it can be done. Perhaps they buy something in a place that interests Boulder County and trade for that in 15 years. Thank you for your time.
Thank you, Mr. Keen. Next up, we have Julie B. I do not see Julie B promoted. Oh, now I see her.
Julie, you've been successfully promoted. This is Anna Milner, staff. You can speak whenever you're ready.
Hello, can you hear me? Looks like
Yes,
it. Julie Boyle, Post Office Box 481, Lyons, Colorado. I've lived in Lyons for 7 years, and I'd like to say that I am astounded to hear that the community planning and permitting staff were not part of the negotiations for years between CEMEX and Parks and Open Space. And I believe that that belies an agenda on the part of Parks and Open Space that the planning commissioners are totally ignoring. I'm doubly astounded that more of the commissioners did not have questions for the staff, given that the staff was not part of those negotiations. I'm sure you have reams of documents that perhaps you've read, perhaps not. I'm still quite surprised that you did not have more questions. I moved here 7 years ago from Weld County, and I will tell you, I am pleased, astounded happy to pay taxes for the proliferation of open space that already exists. I am not willing to see you all and the commissioners bow to the interests of this corporation for yet more open space. I'm content with what we have. I applaud Mr. Keen's notations about state permitting and the Air Quality Control Commission linking the quarry with the cement plant. And I would posit that if the commissioners don't approve the Dow Flats quarry, then the CEMEX plant is bound to close and be reclaimed. And I would argue that that's a huge win for the county, not to be ignored. I also want to note that it's my suspicion that all the citizens who have testified, will testify thus far, that have testified thus far, the sentiment is overwhelmingly against the approval of this extension for the quarry. And the commissioners would be remiss to approve it, given that overwhelming majority of citizens, unless, of course, that's not an important consideration. And I'm not always convinced that is. My last point is a point
That's
of
your
order.
time. That's your time.
Would Commissioner Goldfarb please be present, or you don't have the right to consider yourselves having a quorum to vote?
Okay, thank you for your comments.
Thank you.
Sheldon Sands is up next.
This is Anna Milner, staff. I do not see Sheldon in our attendee list. Sheldon, if you're okay, Kathleen Sands has confirmed via chat that Sheldon's not present.
Okay. Next up, then we have Taylor Muglia.
This is Anna Milner, staff. I also see that Taylor is absent. Unless, Taylor, you've dialed in via phone, please press *9.
Okay. While we're doing that, I have a note from staff that we did actually track the seated time that was seated to Hunter Lovins. And since we didn't make that policy clear, I'll allow the time to be seated. So Ms. Lovins, you'll have 6 minutes and 30 seconds. And if you can start with your name and address.
Thank you all so much for this marathon session. My name is Hunter Lovins, as I said earlier. I live at 5150 St. Vrain Road, Longmont, 80503, and have done since 2003. I work in hygiene, and I've been with you today since 1:30. I live in direct line of sight of the CEMEX plant, but I'm not here to talk about the visual or the noise impact, although it is a stark industrial plant in what is otherwise a very beautiful view, nor to show you photos of my white corral fences that are blackened by the emissions from CEMEX, or to tell you that I cough, which when I travel, which is often, goes away. I am here today to speak to you about much more significant issues than my personal view, and I bring a background of some expertise as a professor of sustainable management, as a globally recognized expert on energy, climate, and regenerative development, and award-winning author of 16 books. I fear, unlike the great solar project we heard about earlier, staff has not done a thorough job in this appraisal. The project is not consistent with the Boulder County Comprehensive Plan, which we had a little tutorial of earlier, particularly the environmental aspects. Staff says that the plant would continue to operate if the mine were discontinued. However, we've heard the Colorado permit requires that the Dowe Flats mine operate if the plant is to operate. Let me say that again. CEMEX cannot continue to operate if the mine is not in operation. As both the Dowe Flats mine and CEMEX plant are linked at the state level as one mining operation, it's not quite fair to say that the environmental impact is limited only to the conveyor. The conveyor is there only to take the material to the plant, and the plant's environmental impact is enormous. And you've heard about this. CEMEX operates under 1960s air quality standards. This is in part why 357,000 tons of carbon are going into the atmosphere every year from that one plant, the single largest emitter in all of Boulder County, 7 times worse an emitter than the number 2. CEMEX emits 7% of all of Boulder County's greenhouse gas emissions, and you really are thinking of allowing this to go on for another 15 years when the Secretary General of the United Nations says we are in code red for humanity. We are in a global climate crisis. Boulder cannot meet its 2030 goals if CEMEX continues operations. It can't meet it if it stays as it is. It can't meet it if it starts trucking material in, which, as an economist, they're not gonna. Worse, staff has failed to ask any of us living near this thing what our opinion of it might be. You're getting an earful of it tonight, but I was unaware that this was going on until approached by local citizens asking for my expertise. If someone is going to do something to their property, they have to put up a sign saying, hey, we're going to do an amendment. No such notice was given to any of us. Worse, no such was given to the town of Lyons. This is just bad democracy. It also is, I suggest, legal grounds for denying this request. Now, I do understand the need for open space. This is a particularly important piece of ground. I can see why Boulder County Parks and Open Space would love to become the beneficiary of, well, Ed said it earlier, this is a bribe. And I suggest you think very carefully about the ethics, about the legality of going forward with this application under those conditions. I think it would be a serious mistake. It's very tempting for each one of us to say, but what can I do? I'm just one person. Those of you who are the commissioners can do something tonight. More than anything I've ever done in my life to try to deal with the climate crisis. And believe me, this is what I do. I go down the road working on the climate crisis. You have the opportunity tonight to shut the single largest climate polluter in Boulder County. Staff's trying to separate these issues. That's disingenuous. Please, for the children of Boulder County, for those of us with compromised immune systems, for the fish in Boulder County. If you're burning coal, you're emitting mercury into the air. I don't eat fish that I catch locally. In fact, I've given up fishing. Why torture a fish if I'm not going to eat it? Because it's loaded with mercury. There are health concerns, there are economic concerns, there are environmental concerns, there are compliance concerns. Under no circumstances should you accept this proposal to permit an extended use of the mine at Dowe Flats. Please reject it. Thank you for your time.
Thank you, Ms. Levens. Next up, we have James Silvestro, pooling time with Richard and Barbara Cargill. Mr. Silvestro, I see you. And Anna, can you just confirm that the Cargills are also present?
This is Anna Milner, staff. I am promoting Richard and Barbara now and confirming that they're present.
Okay, Mr. Silvestro, start with your name and address and go ahead.
Thank you,
You'll have
Commissioners.
9
Thank you, Commissioners. Thank you, staff. My name is James Silvestro. My address is 717 17th Street in Denver, Colorado. I'm land use counsel for Save Our St. Vrain Valley, and two of SOSVV's members, as noted, have dedicated time for my 9-minute presentation. As most of you probably know, SOSVV is a grassroots nonprofit that works to preserve and conserve the natural environment within the St. Vrain Valley, especially the unincorporated areas east of Lyons. SOSVV joins with everyone else who's located in Colorado that's spoken tonight in strenuously opposing CEMEX's request to engage in 15 more years of open pit mining at this site through the year 2037. And I want to quickly, as quickly as I can, make 5 points and hopefully cover a little bit of new ground. First, SOSVV strongly disagrees with county staff that the county can authorize new mining at the Dowe Flats site without considering the fact that this will result, unquestionably, in another 15 years of operations at the CEMEX concrete facility. Second, SOSVV believes that staff has applied the wrong framework in evaluating this proposal through the prism of a continuation of an existing special use. That's not what we have here. The existing permit is set to expire next month. CEMEX is asking this board and ultimately the Board of County Commissioners for a new authorization to engage in new mining. And the impacts of that new mining have to be compared against the base case, which is that reclamation will begin in earnest next month. Third, the proposed offsite commitments and other cash payments to the county that CEMEX is proposing are irrelevant and cannot factor into the county's decision on this application as a matter of law. That's not part of the approval criteria under section 4-601A, and it would be a serious mistake, an error of law, for this board or the county commissioners to be swayed by those considerations. Fourth, CEMEX's promise to shutter the cement plant at the end of the 15 years does not guarantee that industrial uses will not continue at that site, because through an accident of history, that location is zoned for general industrial. So even if they're promising to shutter that plant, there would be nothing to stop them or someone else from putting another heavy industrial use at that site. The only way to guarantee full reclamation of this area would be to tie any extension of mining to a rezoning, and that's what the town of Lyons has proposed as an alternative here. And fifth, SOSVV is deeply concerned with the manner in which stakeholders like SOSVV and the town of Lyons have been excluded from the negotiations that county open space had with CEMEX regarding this proposed special use. So starting with my first point, we strongly disagree that this application can be viewed in isolation as something completely separate from the CEMEX cement plant to the south. The cement plant uses outdated technology, coal-fired from the 1960s, and is one of the most significant polluters, as we've heard, and the largest emitter of greenhouse gases in Boulder County. The Dowe Flats mine and the cement plant are inherently intertwined. Dowe Flats has been the only source of raw materials for the cement plant for a number of years, absent a handful of trucks that no one can even give us a number of what that is. But even more directly, the conveyor belt that physically links the two sites makes it no question that one can't operate without the other. In fact, under the county code, processing materials from Dowe Flats has to occur within 1,000 feet. So it has to occur at that Lyons quarry site, as it has historically. And also, as I think was evident in staff's questions to CEMEX, CEMEX has not actually done any work to develop a scenario where it supplies this cement plant through raw materials from somewhere other than Dowe Flats. So I don't think that it should be a reasonable consideration at this point. But most importantly, and we heard this from Mayor Rogan, she confirmed it herself, DRMS, the state of Colorado, has confirmed that the existing DRMS permit for the cement plant provides that if mining stops at Dowe Flats, the CEMEX concrete plant must be immediately decommissioned. I'm not quite sure why planning staff hasn't been able to confirm that with the state, but members of SOSVV, the community, Mayor Rogan, we have all had those conversations with DRMS, and that is a fact. We've got it in writing. Absent some sort of change to that DRMS permit, which CEMEX has made no effort to do, it provides that if mining stops at Dowe Flats, then the cement plant is turned off, which is, as you can hear, that's what the community is really focused on. So these two significant land uses cannot be viewed in isolation. Before the county can approve this application, it must consider the impact of the continued operation of the cement plant, including all of the resulting impacts related to pollution, greenhouse gases, noise, traffic, impact on wildlife, and the visual impact, which I think you all probably know is significant. To date, staff has refused to consider any of that. At a minimum, the county's consideration of this application should be tabled until staff has been given the chance to do all that work. And I want to turn to one other point that came up to me in an earlier comment, but again, I think staff is trying to have it both ways, especially when they talk about the commitment of CEMEX to shutter the plant within 15 years. That can't be a weight in CEMEX's favor while also not considering all of the negative impacts of that operation between here and now for the next 15 years. There's just no way to separate those two things. Turning to my second point, and I don't think this is a point that I've actually heard articulated so far tonight, and that's that if you look at the staff report, if you listen to the staff presentation, if we're all here for the applicant's presentation, all of that is viewing this application through the prism of a continuation of the existing mining. And as I mentioned at the outset, that's not what we have here. We have a scenario where under the permit that was approved in the 1990s, mining is set to stop next month. And so to say, well, the visual impact isn't going to be significantly different because they're just digging down, you have to compare the visual impact of 15 more years of mining to a scenario where reclamation begins next month and is concluded in 2025. And I think Mr. Lorang actually made a very strong point on this, which is that if you actually look at this application as new mining that has never been approved before, and you compare that to the approval criteria under section 4-601A, it's clear that there's been no showing by the applicant or even by staff that 6, 7, 8, 9 of those criteria can be met by what's being presented to you all. When Boulder County approved this initial permit in the 1990s, it was based on the assumption and the promise that mining would be concluded next month in September of 2022. And I've seen no compelling reason for this commission for Boulder County to change that decision that was made in the 90s. And there's been no evidence presented to satisfy the criteria that would allow CEMEX to engage in use that's otherwise not allowed by right at this site. Similarly, and this is just one example of the criteria that I don't think have been evaluated appropriately, given that this would be a new 15-year lifespan for the mine. Under the comprehensive plan, this site, the CEMEX site at Dowe Flats, was designated in 2014 as part of the Rabbit Mountain Environmental Conservation Area and the Rabbit Mountain Natural Area, a little piece of it. The point on that is that since 2014, since this property was put into those designations, I would submit to you that the Dowe Flats mine has essentially been a non-conforming use under the comprehensive plan. And so that non-conforming use is now set to sunset under the existing special use permit next month. And it would be an error of law for the county to authorize a new mining operation that so obviously violates the specific designations that the comprehensive plan has put on this site. So those are just a few examples of how the current application does not meet the special use standards and account for all of the new impacts that will result from 15 additional years of mining. I don't have time to go through all the criteria, but I would submit to you, if you look at the staff memo, if you consider the staff presentation, that no one has actually looked at the impact of 15 new years, not an existing use because it's going to expire, but 15 new years of mining under the approval criteria in light of the existing conditions at and around this site. Mining is not a historic.
Thank you for your
Yeah, if I
comment.
could just quickly make my final point, which is that SOSVV was very disappointed that Lions was not included in the consultation and negotiation of this. And we agree with Mayor Rogan that there are concerns about the intergovernmental agreements and whether or not Boulder is in compliance with its obligations to Lions. Thank you.
Thank you for your time. Next up is Sarah Lorang. If you could
Thank
start
you.
with your name and address, please.
Hi, my name is Sarah Lorang and my address is 12800 Foothills Highway in Lyons. I feel the need to first share how disappointed I am that this application is being supported by multiple county agencies. As a mother of 2 young children, climate change is something that very literally keeps me up at night. I've historically taken some comfort that I live in a community that prioritizes the environment, and it makes me feel like I'm on the right side of history in some way. So when I learned about CEMEX's history of EPA violations and enormous greenhouse gas emissions, I was confident that Boulder County would ensure that they end operations when their permits at Dowe Flats expire, as it's incomprehensible to me that they would turn a blind eye to a facility producing 357,000 tons of CO2 every year. Given that the environmental impact is apparently not enough to kill this application on its own, I also just want to point out some concerns with what's been proposed. The press release and other public commentary that introduced this application have largely spread the narrative that we do this 15-year extension or the plant operates forever. But that's a false narrative. CEMEX said they would, quote, contemplate indefinite operations. Indefinite means unknown, not forever. In addition to the fact that operating the plant without an adjacent mine is objectively not a financially viable option, meaning CEMEX is bluffing, it is most importantly not even a legal option for CEMEX. I just want to repeat, as it stands today, CEMEX's state permits do not allow them to operate the plant when mining stops at Dowe Flats. Many have claimed that these two sites are separate, but they're not, and their state permits very much link the two. The permits actually dictate that CEMEX must tear down the plant and reclaim the land to its original pasture-like state once mining has concluded at Dowe Flats. The Department of Mining, Reclamation, and Safety confirmed this in great detail in writing. So to summarize, absent the legal right to continue operations indefinitely, and CEMEX does not have the legal right, the application and proposal we're discussing is CEMEX offering Boulder County Open Space nearly $17 million of gifts in exchange for an additional 15 years of mining on land the county already owns and has options on. A deal that Boulder County planning staff is recommending we take despite the overwhelming public opinion that we shouldn't, and the Town of Lyons Board of Trustees being unanimously against it as well. Even the Boulder County Public Health Department's requests for conditions to be added to protect public health were disregarded in their entirety in the planning staff's draft recommendation. At best, all of this sounds highly unethical. While I'm not sure how or why planning staff would recommend this deal be accepted, given all of the public feedback they've received against it, I'm pleading to you, the Planning Commission, to hear the community's overwhelming feedback that CEMEX's application be rejected. I'm confident that each of you want to be on the right side of history with this too. Thank you.
Thank you, Ms. Lorraine. Next up, we have Amanda Dumenigo. I hope that pronounced that correctly. Pulling time with Lily Trianens and Alan Dolezal. Anna, can you confirm that Lily and Adam are still with us?
This is Anna Milner's staff. I do see that Lily Trianens is present. However, I'm not seeing Mr. Dolezal listed in the attendee list. Mr. Dolezal, if you've called in via phone, can you press *9, please, to indicate your presence?
And he's here with me right now too. Is this Lily Trianens?
Okay.
Want to say something? Yeah. He's right next to me.
Okay, can you just have him say something so we know he's there?
Yeah, I'm cooking dinner.
Okay. All right, Ms. Dumenigo, you'll have 9 minutes. Start with your name and address, please.
My name is Amanda Dumenigo. I live at 5625 St. Vrain Road, 80503. I'm one of the founding members of Save Our St. Vrain Valley, also known as SOSVV, and I currently serve as the executive director of the board. As a volunteer myself, I'd like to thank each of the volunteer commissioners for your time and thorough consideration of the observations shared by my peers and those that I will share based on experience and painstaking research of the last 5 years. Firstly, I'll address the staff's recommendations that you have been provided and that conventional wisdom would have you forward on to the county commissioners without the arduous task of courage and personal responsibility required in voting against the planning department and Parks and Open Spaces recommendations. POS has co-signed CEMEX's special use application. That makes them a co-applicant, not an advisory board. POS is also the primary beneficiary of roughly $15 million, which CEMEX is offering only in exchange for the county extending their special use by 60% or 15 more years of mining. In layman, non-bureaucratic terms, we call that a bribe, but under any ethical standards, POS's recommendations are clearly biased. And speaking from personal experience and verifiable in the judicial record, POS has a track record of endorsing expired special uses in the St. Vrain Valley, the least developed river valley in the Front Range, or in about 10,000 miles. POS's multiple endorsements in the last 5 years have several things in common with their endorsement for CEMEX's 15 years of mining proposal. POS's recommendation benefits foreign multinational corporations and POS's land acquisition to the detriment of the environment, seemingly oblivious of the climate crisis, and sabotaging the county's 2030 climate goals and commitments. In 2017, the case of special use 9618, Martin Marietta's mining permit from 1998, the POS approached the contractor to do the flood restorations under the assumption that their special use was active. The permit was in fact in cessation status with the DRMS since 2011 due to inactivity. Marietta did not do the restoration, but they deduced that their dormant permit must be valid. This situation ended up in the Colorado Supreme Court, who agreed with SOSVV and averted the industrial mining of almost 800 acres in the valley. Once again, POS is promoting mining in the St. Vrain Valley based on special use permits that have run their course and without considering the original agreements made by Boulder County and the operator, its environmental impact, its massive carbon footprint, or its negative impacts on the community. I will remind the commissioners that in 2002, Amy Brawley, POS's acquisition manager then, told the Daily Camera that, quote, by purchasing this land, Dowe Flats, and connecting the open space area, the county helps preserve an important habitat for wildlife, and that the majority of the funds came from a 0.25% tax designed for open space purchases. However, in POS's recent Zoom on acquisition, Janice Weissman, the current Boulder County acquisitions manager for POS, stated that she would not be around to oversee the project or its completion, and also stated frankly that POS's focus is land acquisition. POS's opinion in this case is biased and myopic. Their recommendations to the county have verifiably been on the wrong side of history, and based on that, I urge the commissioners to disregard POS's recommendation. The planning department's recommendations ignore all public comment and common sense, and nearly all of the health department's conditions for approval in their official 1,000-page recommendations. Ignoring the health department's conditions, which are intended to protect public health, is dangerous. Just as CEMEX is the #1 polluter in Boulder County for the environment, their industrial operations are equally detrimental to our public health. The planning department also ignores state permitting, DRMS. The oversight has proven in recent history to be a grave error. In the Martin Marietta special use, the county failed to consult DRMS annual reports from the operator until SOSVV submitted them. The commissioners should know that based on our group's communications with DRMS, the mining special use permit for the cement plant is intertwined with the mining permits at Dowe Flats, as has been repeatedly made. As it currently stands, the operator cannot operate the plant independently or indefinitely according to the state of Colorado. This brings up the issue of trusting CEMEX's claims and their proposals. We've read in the media those that assert that CEMEX plant will cease to operate in 15 years. How can we be sure? They refuse to honor the 2002 expressed intent and agreements. They ignore the Director of Land Use 2019 determination that next month, September 30th, 2022, is the last day of mining at Dowe Flats. CEMEX claims they will stop operating the plant concurrently with operations at Dowe Flats, but there's no language preventing CEMEX from selling the plant to any other operator. For example, someone like Marietta, who has an existing permit to build an asphalt plant. If CEMEX claims that operations of the plant will stop, as some have promoted irresponsibly in the media from the county, then it would clearly state the cement plant would be decommissioned in 15 years and the planning department would rezone the 60 acres of general industrial as part of the deal. Both of these obvious good faith provisions are notably and quite likely intentionally missing from the application submission that you are all tasked with considering. CEMEX has threatened to bring in materials by truck and rail. However, they have failed to disclose to the county from where in the proposal. They have admitted they do not have a fleet of trucks at the ready to do so. And based on our financial feasibility analysis, that alone could be a prohibitive cost of operation. Another false narrative propagated is, quote, if you don't like the deal, you'll have 1 million houses. However, land use zoning regulations in place protect against that ever happening. This area is zoned agricultural. The acreage offered cannot be subdivided in less than 35 acres and has limited use. And a review of Lyons 2012 IGA suggests violations. CEMEX exclusion of the town of Lyons, administrators and its citizens, and Save Our St. Vrain Valley, who are arguably the most impacted by another 15 years of mining at Dowe Flats, is antagonistic and injurious to social justice. CEMEX exclusion of Lyons jeopardizes the collaborative relationship that has been fostered and nurtured between Boulder County and the town of Lyons. I urge the commissioners to consider these less obvious but highly nuanced repercussions of recommending another 15 years of mining in the St. Vrain Valley. I urge the commissioners to recommend that the Boulder County Commissioners uphold the expiration of special uses, as they have recently begun to do, and see beyond CEMEX's empty threats and white elephant gifts. CEMEX is bullying and bribing their way into another 15 years of mining, the very definition of extortion. You have the honor of being in the front line for the benefit of the environment and its residents. Courage to stand with the community and the environment, congruent with the express goals of Boulder County and the recent trend to uphold the expiration of special uses. Thank you.
Thank you, Ms. Domenico. Next up, Alexandra Rodriguez.
Chair Bloomfield, this is Anna Milner, staff. I don't see that Ms. Rodriguez is present.
Okay. We'll come back to her if she does reappear. Trudy Webster is next.
This is Anna Milner, staff. I'm also seeing Trudy Webster and Jane Schellenberger as absent. If
Okay.
either of you are signed on via phone, dialed in via phone, please press *9 to raise your hand and indicate your presence.
Okay. I see next on our list is Mikkel G. I'm not going to.
What's up, guys? Can you hear me okay?
If you could start with your name. Yes, if you can start your name and address. You've got 3 minutes.
Mikkel Goicochea, 291 Cannon View, Boulder Heights. It's a pleasure. You guys on this planning commission are savages. I've been on here since 1 and quite the marathon here. Thank you so much. I'm not anyone special. I'm not a lawyer or anything like that. But what I really feel from the public that's important is that we represent Boulder's heritage of environmental protection and progression, and something like this comes up. Literally on the call today, you guys are getting excited about putting 12 acres of solar panels in and having some sheep's graze and sequester a little carbon from some prairie lands, and everyone's getting all excited about having the CU students. If that's exciting, how in the hell can you let these guys burn 7 tons of coal a day like 5 or 10 miles away? It's crazy. I think it's a terrible look for the county. I think it's a terrible look for Boulder prestige. And I think what really counts is, what are the headlines going to be next week, a month from now? Are they going to be the ones in the back? Oh, some mining thing got approved, blah, blah, blah. Or is it going to be something like, holy shit, man, we have an environmental crisis here. Town of Boulder shuts down a plant, immediately action. And then we get picked up by New York Times and things like that. There's only one point, and I'm not going to use too much time. I know you guys are hungry. So am I. It's my wife's anniversary today too, but that's how important this is. I've got a 1-year-old. It's my understanding that this plant only operates 4 days a week, right? Monday through Thursday. Okay. Let's run some math. If you were to bump that up to 6 days over 25 years, that's 2,600 days, an extra 104 days a year. That equates to 9 years. These guys already had 9 years extra worth of days that they passed on, and they didn't extract their resources. They do not need any more time. I say we go with the 5-year plan that the Lyons residents like, and that's all good. I also think it's fitting, and I'm the least professional guy on this call, obviously. We got some guys from Texas, right? These guys are literally in their air-conditioned office, in their air-conditioned car, in their air-conditioned home. It's 110 degrees down there. They live in air conditioning. You know what? I don't want to live like a Texan. I don't want to live in air conditioning. And what's the point of having open space when it's on fire? I've had a fire 1 mile from my house, 2 miles from my house. Look at your beloved open space, the crown jewel up at NCAR. It's freaking torched. It's your guys' time. I remember voting for you guys. And the reason why we vote for guys like you is because times like this, it's time to step up and make a difference. Thank you so much.
Thank you, Mikkel. Next up is Michael Schnatzmeyer.
This is Anna Milner, staff. Hi, Michael. You've been allowed to speak. If you can press *6, that will unmute your phone.
Hello, this is Michael Schnatzmeyer, 69 Hover Street, Boulder, Colorado, actually Longmont address. I'm in support for denial of the application. My considerations for denial are multiple, but here are the big ones. First, the Dow Flats area named for Dow Chemical Company has been documented to be significantly and widely contaminated by the dumping of toxic materials manufactured by Dow Chemical in Denver in the mid-1900s, similar to their disregard of environmental contamination at Rocky Flats. I'm concerned that the currently proposed and future granting of land to Boulder County, characterized as being worth millions of dollars, presumably, and provided at no cost, may simply be a Trojan horse. That it could be a handoff of a significant multi-million-dollar liability for the responsibility of eventual environmental cleanup by Boulder County at a major cost to taxpayers. I'd like to know, to what extent has the property been subject to Phase 3 environmental assessment and cleanup cost liability estimates? This is a legal issue. Do permit documents include a release, hold harmless, and indemnification of the county for such liability costs should they occur? If not, why not? Secondly, insufficient legal notice provided by statute. It appears that insufficient legal notice has been provided to the public regarding all impacted and affected areas. This should include areas impacted by rail line traffic changes, including but not limited to off-site areas east of the mining operations, to and through, including residential and commercial properties along rail lines through Longmont. Third, climate change. In regard to staff referrals that the application was apparently submitted to for response, the application, I'm curious as to why there are not comments from Boulder County Sustainability and Climate Action Department, run by Susie Strife, concerning this major sole source contributor to Boulder County carbon emissions. If one comment, if approval is granted, I would like to suggest that the following caveat be included: that there be a contractual mandate that all mining operations, hauling, transit, trucking, and cement manufacturing operations achieve a 100% net zero carbon energy footprint, i.e. electric vehicles, trucks, mining, hauling, and manufacturing and processing. If there is concern about the legality of not extending or granting a permit, I think this is a reasonable consideration and mandate to include in that permit that could effectively respond to some of the climate change considerations and make the cost of continuation of their carbon emissions financially and economically non-viable. Thank you very much.
Thank you for your time, Mr. Oh, I lost Mr. Schnatzmeyer. Sorry, I lost my place. Next up, I have Kathleen Cassidy. Ms. Cassidy, I see you in the room. If you can unmute yourself and turn on your video if you'd like.
Hey there. Hi. Can you all hear me?
We can. If you could state your name and address to start with.
Sure. My name is Kathleen Cassidy. I live at 6650 Ute Highway, Longmont, Colorado, 80503. Been here as long as you all have, and what a day. So many people have researched this greatly. Thank you so much, my neighbors, for doing that and for alerting me that this was going to happen. I feel a little bit gypped that not more people know about this. I think it's really too bad that these meetings happen during the day when people are working. I took off work to be here because I really don't want somebody else to speak for me. I want to speak for myself, as I believe most people do. So basically, I want to know if the studies that have been approved with all the 4.601-A- whatever number, I wonder if the studies that have been done and approved according to protocol, if they're actually current as far as considering the climate change and global warming that is happening today. Like, are there environmental assessments current? Because right now, I'm frying every summer since 2020, man. It is so hot, you know. So basically, I'm just making my way through every day. And I can't imagine the animals who have had to put up with this open pit mine, how they're feeling. And I'm sure they're ready to have it be done. And then as far as who can see it and how it's not visible from the road, if you actually live here and if you hike on Rabbit Mountain, it's a huge hole that you're looking down on. It's just going to get deeper. And really, it seems like it's just a nugget that CEMEX is trying to get past so that they'll be able to stay, because they're not going to be able to stay unless Dow Flats is here. So they're just, I feel like this whole process is underhanded. I mean, come on, really, they're not connected. If they're not connected, then who is Dow Flats selling their wares to? I mean, right now they're done with their limestone. All they're doing is giving shale. It seems like they're a dummy company here because they have to be here for CEMEX to continue. And I'm not like one of your educated, informed, you know, researching people, but gosh, from hearing what I heard today, that's where my mind goes. And it seems like, you know, I'm looking at the emperor and seeing no clothes there. But anyhow, the other thing is this, 4 people from Lions work there. What is this actually giving to Boulder County other than a shitload of pollution? And frankly, we don't have time. We don't have time to be polluting. We got to stop now. I can't believe this is even up for debate. Thank you for doing what you do, guys. Bye.
Thank you, Ms. Cassidy. Next up, I have Michael Robson.
Hello, guys. Can you hear me?
We can. If you could start with your name and address, please.
Awesome. Hello. My name is Michael Robson. My address is 6152 Hygiene Road. I'd like to thank all you commissioners for your time and for listening to our public input. As speaker number 36, I feel like I'll be rehashing points already made, but I think it all bears repeating. I'm a 30-year resident of Boulder County, and I'm requesting that the CEMEX Dow Flats mining extension be rejected. The special use permit should be allowed to expire on September 30th. As Boulder County's #1 polluter, CEMEX has been a detrimental presence in the St. Vrain Valley, and it would be in the best interest of surrounding residents, the town of Lyons and Boulder County, that their original permit be allowed to expire. Even though the Dow Flats permit is at issue here, it is directly linked to the CEMEX plant operations and CEMEX's ongoing detriment to the community. The Dow Flats mine should be closed and reclaimed, rendering the plant unfeasible. The plant should be demolished and reclaimed, and CEMEX should exit the area. From a personal perspective, my family is one of a great many who live downwind from the plant and in full view of the plant and the Dow Flats mine. Both entities are an absolute eyesore, and we are subjected to excessive light pollution, excessive noise pollution, and most importantly, clouds of choking dust that CEMEX seems to make no effort to mitigate. CEMEX's disregard of the community in which they operate is antithetical to the mission of Boulder County, and the county's lack of community involvement is extremely distressing. The commissioner's obligation, hang on, I lost my place here, is to their community members and their health and well-being, and their decisions should reflect the community's climate goals. I would strongly urge Boulder County to reject the Dowe Flats mining extension. Thank you so much for your time.
Thank you, Mr. Robson. Next up, I have Gil Sparks. Mr. Sparks, I see you.
Good evening, commissioners.
If you could
As
start with your
others
name
have
and address.
said, I'm sorry. Gil Sparks, 2169 Apple Valley Road, Lyons, Colorado. Like others, I'd like to express my thanks for the time and effort you have put in on this very long and I'm sure tedious day for you. This is an important issue, and it's unfortunate that it's going into the evening tonight. Many of the things I had planned to say have been covered by people far more learned and eloquent than I am. At one point, I would like to emphasize, and I have a statement it's been prepared that I want to read from, so it may not be quite extemporaneous. In their draft recommendation, Boulder County's Planning and Permitting Division staff states that an extension of CEMEX's mining permit uses less resources than CEMEX claims to consider indefinite operations of the plant. The definition of indefinite is not forever. It means lasting for an unknown or unstated length of time. I would like to know how the staff is making that assertion and how they've calculated that. In addition to the fact that operating the plant without an adjacent mine is objectively not a financially viable option for CEMEX. It is most importantly not even a legal option for CEMEX. CEMEX state permits do not allow them to operate the plant when mining stops at Dowe Flats. Many have claimed that the two sites are separate, but in reality they are not, and their state permits are very much interrelated and linked. The permits actually dictate that CEMEX must tear down the plant and reclaim the land to its original pasture-like state once mining has concluded at Dowe Flats. The Colorado Department of Mining, Reclamation, and Safety confirmed this in great detail and in writing. So again, I would like to know how the planning staff calculated the use of resources in order to state that 15 years of additional mining would use less resources than operating the plant for an indefinite or indeterminate length of time. Because quite frankly, I disagree. I strongly recommend that the Planning Commission reject the application that CEMEX has proposed. Thank you for your time.
Thank you, Mr. Sparks. Next up, we have Tess McDonald. Ms. McDonald, you can unmute yourself and turn on your video if you choose. And please start with your name and address.
Oh, sorry about that. Hi there. Thank you for being here. I'm at 376 JJ Kelly Road in Lyons, Colorado. And I just want to say you have to do this. You have to reject their permit. I know it's going to be really hard and it might get caught in lawsuits, but I will be honest with you, the way the world is going, CEMEX doesn't want you to win either. When the first guy said, the criteria has been met, the criteria has been met, and then you have Mark here, who is actually honest, and he said, they will consider the 15-year retirement. They will consider the health compliance. So he's being honest with you. Like, thank you, Mark. I just want to say, as a CEMEX representative, thank you for the honesty. And there's going to be a tipping point for all corporations out there that the bad democracy is over. And I think you guys have a great opportunity to start that trajectory here. It's not going to be easy. It's not. It's going to be held up in court. It's going to take more volunteer hours. But I know the people of St. Vrain Road have put in years and years of work, and we can do it too. We can do it together. Thank you.
Thank you, Ms. McDonald. Next up, I have Tom Knorr. Mr. Knorr, I don't see you. Anna, is he promoted?
Mr. Knorr, you'll need to press *6 to unmute yourself.
Here he comes.
Hi, can you hear me?
We can. If you could start with your name and
Thank
address, and you'll have 3 minutes.
Yes, of course. My name is Tom Knorr. The address is 11678 North 59th Street. I'd like to thank you for letting me speak. And I'm sorry that we lost Mark. Oh, he's back. Are we allowed to ask questions?
No. You can pose questions and
well, let's pose a question. If
the
I were allowed to ask, yeah, I would be tempted to ask Mark how many times he has appeared before permitting authorities on behalf of CEMEX in order to appeal for the extension of a mine specifically related to a cement plant. My suspicion, and this is just a suspicion I'd like to share and then get off the line, but it is my suspicion that the so-called unanticipated materials were not, in fact, unanticipated at all. That this is not Plan B for CEMEX, but rather Part 2 of Plan A. And that's really all I intend to share this evening. Oh, and also, real quickly, I just think it's a shame that we're playing it this way, that we're going to ignore the 2-ton gorilla in the room. And I think it is something that you need to reassess as a staff and as an entity and be thinking about things a little more seriously and what you're contributing. Thank you.
Thank you, Mr. Knorr. Next up, Elaine Paul.
This is Anna Milner staff. Elaine, you've been promoted. You can speak when you're ready.
Hello. I think I've
Hi.
got a lag. Can you hear me okay?
We can hear you.
Okay.
You could start with your name and address, please.
My name is Elaine Paul. I am at 11678 North 59th Street in Longmont. And like so many others here, I'm here to vehemently oppose the extension of this mining operation. And I'd like to echo what many others have stated and what seems so obvious, which is that you just cannot separate Dowe Flats from the cement plant. And I too believe that it's a disingenuous threat from CEMEX that materials will be trucked 90 miles to the site for processing indefinitely. I'd also like to know what happens if market forces, the market forces that prevented CEMEX from extracting all of the available mineral resources to this point, cause them to not extract all of the resources from Dowe Flats over the next 15 years. I'd like to know what ironclad assurance we have that will prevent them from seeking another extension in the future. This expiration date didn't come as a surprise to CEMEX. They knew the permit was expiring. They had their chance to mine. It feels to me like a form of extortion to extend this permit. What will prevent a similar scenario from unfolding when the county is not meeting its 2013 climate goal? or 2030, excuse me. Are the few jobs involved here really worth the current and future health and well-being of humans, animals, plants, and land in this area? It may go without saying, but the people who've taken the time here to speak represent just a portion of the population opposed to this operation. So on behalf of myself and all who are not able to speak here at this forum, I implore you to reject the extension of special use permit 9314. I sincerely hope that this is not a foregone conclusion on your part. And I thank you for all of your time today, and most importantly, for your consideration.
Thank you, Ms. Paul. That seems to be the end of our list. Anna, do we have anyone on the phone? Their hand raised, or anyone else?
This is Anna Milner, staff. We don't have anyone on the phone with their hand raised to speak. Anyone else that's interested in speaking to this item today, please enter your name and address into the chat or press *9 if you've dialed in via phone to indicate that you'd like to speak.
Okay. While we give those folks a second, my thought is to allow staff and the applicant to reply to public comment while it's fresh, and then take a 10-minute break for commissioners. If that sounds good to y'all, allow us to regroup, and then we can go into final questions for the applicant for staff, and then discussion. Anna, has anyone materialized?
This is Anna Milner, staff. It does not appear that anyone else is interested in speaking to this item tonight. Thank you.
Okay, so then we will go to Pete. Do you have any responses from the staff point of view to public comments?
Yes, thank you. Pete Larange, CP&P staff, have several responses to public comments. First would be that the application was noticed properly. Notice was sent out. The original referral was sent out on 4/25, 2022, and that included the town of Lyons. It was for an original 35-day referral period, which would have ended on May 30th of 2022. But at the request of the town of Lyons, that referral period was extended to July 22nd. All property owners within 1 mile received postcard notification with the original referral back on 4/25. And signs were posted both on Highway 66 and North 55th, excuse me, on July 21st. So the public notice requirements were met. A little bit of context that might be useful in this discussion. In looking at the records, staff has determined that the cement plant actually received original building permits in 1965, whereas the Lyons Quarry received their state permits in 77. So the plant actually predates the Lyons Quarry. And Dowe Flats obviously not until 1993. In looking at the permits for the Lyons Quarry and cement plant and Dowe Flats, we could find no requirement in either permit that requires the plant to close if Dowe Flats Quarry closes. There is a requirement that once operations cease at the Lyons Quarry and cement plant, that the plant be decommissioned, demolished, and the land reclaimed to, I think the wording is as close to an original state as possible, something to that effect. Would also say that since the Dowe Flats Quarry and the Lyons Quarry plant are considered separate under the land use code, the code would allow for the Dowe Flats Quarry to continue to operate without the Lyons Quarry and cement plant, and vice versa. Staff, would reiterate that the cement plant is considered a legal non-conforming use, and under Article 4-1003 of the Land Use Code, it may continue, and normal or routine maintenance of the structure containing a non-conforming use shall be permitted. Let's see. Other things of note that staff wanted to relay is that staff has directly asked staff at the state level if the cement plant at the Lions Quarry would be able to continue to operate with a different source of materials. And staff was told by state staff that if the source of materials changes for the cement plant, the operator, in this case CEMEX, would not have to get a new permit from the Division of Reclamation, Mining, and Safety. However, that the operator may have to revise the current permit to account for the change in source material. That revision, again, based on the information from state staff, that revision could be either a technical revision that does not require any public process, or it could be a full amendment, which does go through a public process, but that can't be determined until such time that a revision request is actually submitted. As for the comments about disregarding the recommendations from public health, again, staff would remind the commission that those were related specifically to the cement plant. And as we have done consistently through this review and others, we do consider the cement plant operations separate from the Dowe Flats mining operations. As far as the question about potential future applications, there is nothing in the land use code that would allow the county to prevent a future board from hearing a future application.
Is that everything, Pete?
That's it that I've got, yes.
Okay, thank you very much. And now, I don't know if it would be Mark Davies. You have an opportunity to reply to the public comments or staff comments for that matter.
Yes, thank you, commissioners. Certainly appreciate your time this evening. I would like to make one statement, and that is that the pre-existing non-conforming use status of the plant is not dependent on past, present, or future state permitting. It's based on historical use. So if the county denies this application and CEMEX is no longer able to locally source materials for the plant, CEMEX will retain a right to operate its plant at its as it has historically, so long as such right is not abandoned. Plant operations would not change, just the location of its sourcing of material would change. As such, we understand the plant continue operations after closure of the quarry and vice versa. Having said this, if required by DRMS, CEMEX will nonetheless proceed to confirm the technical revision of its permit. So that being said, we conclude our application this evening.
Great. Thank you very much for that. Okay. So I believe that we will close the public hearing and we'll take a 10-minute recess. And so we will return at 8:06. And then we'll go through commissioner questions for staff and applicant and then discussion. Thanks, everybody.
Thank you.
Okay, it looks like we're starting to get back together. Looks like we're waiting on Ann and Gavin. Okay. Looks like we have everyone. Let's do a quick roll call just so we can confirm while here. Mark Bloomfield here. Sam Fitch.
Here.
Sam, your sound was really low on that here. Not sure. Can just make it out.
Here.
Oh, you know why? Because I haven't put my headset in. All right. Apologies, Sam. Ann Goldfarb.
Here.
Gavin McMillan.
Here.
Connor Canada. Oh, Connor's gone, right? Chris Whitney.
Here.
Okay. Okay, so why don't we start with questions for staff, if we have any. Any commissioners have questions for staff? No one?
Commissioner McMillan, I'll ask Mark.
Okay.
One. I just want to offer one more opportunity, I think, and maybe ask the question differently, as to like how the amount of time for this extension was determined. Was there an analysis of how much time it would take to pull the material out of the ground, or was it just a proposal, or was there some analysis? I guess I'm just trying to figure out how we got to this 15-year extension.
I'm sorry, Commissioner McMillan, was that directed at staff or at the applicant?
Yeah, I guess first staff. If the applicant wanted to weigh in on the question, I'd be helpful as well. But my question is specifically for staff, at least to begin with.
15 years is what the applicant asked for in the application.
That's fair. Okay. And then I guess, well, Commissioner Bloomfield, do you want to just keep staff questions for staff right now, or do you want to go back and forth?
Yeah, why don't we do staff and then?
Okay, thank you.
Applicant, thanks. Anyone else have questions for staff? I have one question, Pete. When you were giving your response to public comments, I got a little lost. You mentioned both permits indicated that there was no link between shutting down Dowe Flats and shutting down the plant. I wasn't sure what you meant by both permits.
Clarify.
So I don't know, maybe you could just go over that a little.
Sure. To clarify, staff looked at the state mining permits for both the Lions Quarry, which is M 1977-208, and at the separate permit for Dowe Flats Quarry, which is M 1993-041. And staff could find nothing in either of those that indicated that the end of operations at Dowe Flats requires or would automatically trigger the end of operations at the Lions Quarry and cement plant site. So we could not find any tie in the state permits between the operation at Dowe Flats and the continued operation of the cement plant.
Okay, and there's nothing in the cement plant permits that would say that either, it sounds like.
From the state permit, no, there was nothing in there, again, related to the Dowe Flats quarry. The state permit for the Lions quarry says that when operations cease at the quarry and the plant, that the plant has to be demolished and the Lions quarry site reclaimed. But again, that predates the Dowe Flats permit.
Okay. I think that satisfies me for now. Thank you. Any other questions for staff? If not, we'll go on to questions for the applicant. Gavin, you want to start with your questions for the applicant?
Sure. I'll just repeat the same question. I asked you this earlier too. I don't know if you had a chance to think about it more, but I'm just curious how the 15-year determination of extended time was made for this request. Is there an analysis behind that, or how did you come up with that need for 15 additional years?
Yes, to answer that, every mineable resource is finite. It has an end life at some point. And we use those calculations with what's been mined and what remains at Dowe Flats to support the application of an additional 15 years. So yes, it basically what remains in the ground within the footprint that is being proposed for this permit extension.
Okay, thank you.
Okay, any other questions for the applicant? I have one, Commissioner Bloomfield. Is there actually a plant being built, a cement plant being built on the Colorado-Wyoming border?
I'll take this one, Mark. No, there is not. Nor is there a plan to.
There's not, nor is there a plan to. Okay, that is helpful information. Any other questions for the applicant? Okay, I'm not hearing any. So, sorry, I'm thinking about another question for staff or going into discussion. I guess I'll ask the question of the Assistant County Attorney. Is there a legal reason that we're separating the Dowe Flats quarry from the plant?
Thank you, Commissioners. This is Liana James, Assistant County Attorney. I was actually going to recommend that we go into an executive session to discuss some legal issues that came up over the course of this hearing. We would do that pursuant to CRS 24-6-4024B. If you are interested, or if two of you are interested, you can make a motion.
Thank you for that, Liana. That was kind of my knife edge question there. I would move that we move into executive session. Do I have a second?
Commissioner Reddy, a second.
Okay.
Commissioner Fitch, second as well.
I guess I don't know how we do that.
I've sent. Go ahead, Kim.
Yeah, hi, Kim Sanchez, Community Planning and Permitting. I've sent an invite for us to convene outside of this Zoom proceeding for executive session. So you can accept that invite and then we can reconvene.
So are we exiting the Zoom then?
You'll just turn your cameras and audio off, please. And then Rick can put up a sign to let people know what what's happening currently, and then we can come back when we're done.
Commissioner Bloomfield, this is Commissioner McMillan. Do you want to vote on the motion to go into executive session before we forget to do that?
Oh, that's a novel idea. Okay, we'll do a roll call vote. Mark Bloomfield, aye. Sam Fitch.
Aye.
Ann Goldfarb,
Aye.
Gavin McMillan,
Aye.
and Chris Whitney.
Hi.
Okay, we will go into executive session and we will see you all in a little bit.
And just a reminder, planning commissioners, please turn off your audio.
Kim, how do we turn off the audio?
You can press mute on the frame where your picture shows. We can also mute you. I can have Anna mute everyone as well.
Yeah, that might be the safest thing to do.
Okay, thank you. I think Anna can do that.
We are working on that now. Thanks.
This is Commissioner Bloomfield. We'll be beginning once we have a quorum, hopefully in the next few minutes. And I think you're logged in twice.
I'm logged in.
Commissioner Goldfarb, this is Anna Milner staff. I believe we have 2 instances of Zoom going for you. If you could perhaps close one, that may resolve the feedback issue. I'm seeing you logged in twice as a panelist.
We see you, Ann, but you're still logged in twice, it looks like. We can't hear you though. Still can't hear you. Anna, could you demote the other
Yes,
version?
I actually can do that. Give me one moment. I was just thinking that. So the other version's been demoted, and Anne, you should be safe to speak momentarily. Yes, right now.
Okay. Anne, can we hear you now? No. You are unmuted according to Zoom, but we can't hear you.
Commissioner Goldfarb, would you be able to try and exit Zoom entirely and rejoin? That might resolve the issue.
It's a great idea. Okay, and I see Anne back. You don't see video. I haven't heard her.
Chair Bloomfield will be calling Anne momentarily. Give us one moment.
Okay.
Chair Bloomfield, this is Anna Milner staff. Rick Hackett is helping Ann troubleshoot, so please stand by.
Thank you for the update, Anna.
And we've just received word that Ann is going to try to call in, so we'll be looking out for her. Just bear with us. Thank you all for your patience. Commissioner Goldfarb, we see you joined. You'll need to press *6 to unmute yourself.
Anna?
And we can hear you. Thank you.
Great. Sorry about all that.
Okay, thanks for persevering, Ann. We'll do a quick roll call. Mark Bloomfield here, Sam Fitch.
Here.
Ann Goldfarb,
Here.
Gavin McMillan,
Here.
Chris Whitney.
Here.
All right. So we're on to discussion. Anybody want to get the ball rolling?
So this is Commissioner Fitch. I'd like to propose to the commission that we table to a date to be determined. I think there are 3 areas that I can think of in particular that we need additional information from staff before we can recommend for or against. Mark, is it okay to go ahead and do those 3?
Yeah, I mean, we're just in discussion. So I think if you want to say what your 3 things are, and then we can discuss whether we agree that we want to table or not.
I'll try to make this short. So one would be more information about the separability or non-separability of the mining extension from the plant extension or not. That I think is mostly a legal question, but we need to clarify that for the public record. Number 2, I think there within some time period, relatively short, there's due to be more information about cumulative air quality effects and an audit that says something, audit from the state, I think it's called GEMM, reduction of CO2 emissions. At least the Lions proposal suggested that would be coming relatively soon. So maybe an extension to the end of the year. 3, we need more information about the cumulative health effects of existing impacts on public health. So the staff in several places refers to, yes, there are impacts, but the impacts are not going to be worse than they are now. But staff also says in that, I think it's page 15, that those impacts will be extended for another 15 years. So I think we need more information on what that cumulative effects are and whether those can be traded off or should be traded off for greater certainty about the closure date for the plant. Finally, we need from the applicant more information about the willingness of CEMEX to accept mitigating conditions regarding the public health impacts. So again, I think it needs to be more than simply a willingness to consider mitigating dust, mitigating silicone exposure, etc. But we need to know whether, if we approve, there would be a concrete enforceable condition and a time period for mitigating those public health impacts to the extent that they can be mitigated. So thank you for consideration. I'll mute myself.
Thanks, Sam. Any other commissioners have some thoughts?
Commissioner McMillan, I'm amenable to tabling, but I don't know that I would have requested all those items. Although it would be nice information to have. My decision, hello? The information that I'm missing, I think, to fully make a decision is why the duration. I haven't seen or heard an explanation of why we need 15 more years. I think I have trouble seeing how this application meets the criteria for approval when, I assume the goal is to wrap the operation up as quickly as possible, yet we have an ask for 65% more time, or excuse me, I don't know if my math is right there. Maybe it's 60%, 15 years on additional on a 25-year original approval. So how did we get in this place where we need to add that much time to the approval? I don't think it meets the criteria for approval in today for that additional 15 years. And I guess the information I'm looking for is why 15 years? What is the analysis behind that? And can we do it quicker? That's what I'd like to hear. So, I guess in conclusion, would be open to tabling for that particular piece of information is important to me. But if there are others that other people need, other commissioners need, I think we could add them to a list.
Thanks, Kevin. This Commissioner Bloomfield, I have a hard time agreeing with a lot of the criteria that the conditions are met for the criteria as staff has stated them. I definitely agree that the 15-year time frame is a big piece of that. But I'm also I'm really looking at if we kept the agreements as they are and evaluate the conditions compared to how things would go if we let it expire. I just have a really hard time with the conditions being met by the current setup. Sam, I think if we're going to do some kind of request on the legal part, I would want more specificity on the separation. And I had another piece in there, and the fact that I'm not able to think about it also lends me to think that we should table it for now. I guess what I would say is I would want to have a time frame sooner rather than later. And I don't know exactly what our time frame would look like in terms of appropriate noticing of meetings and whatnot. But I don't want to have it drag out.
This is Commissioner Goldfarb. I would agree with you, Mark. I'm inclined to, I'm of the opinion that the application does not meet the criteria for approval based on all the facts that we've heard today and tonight. And I'm particularly concerned about the health and welfare of the citizens of Boulder County in regard to the operation of this mine. So I'm inclined to vote against it, I guess regardless of further information.
This is Commissioner Whitney. I feel like if the time frame changes whether or not the special use would be acceptable or not under the criteria. I'm not sure if I need clarification on that, or if I would just need the applicant to come back with a different request for the special use with a reduced time frame.
This is Commissioner Goldfarb. So does that mean that you would not be in favor of the proposal as it's currently made by CEMEX?
Yes, I think I would like to see the applicant come back with a proposal that reduces the because it's an agricultural zoned area and the special use is allowing it to be used for open mining in an area that may not be fitting with the rest of the landscape, right? As those landscapes change over the years, as we've seen from when the original 1994 special use was approved until now, certainly the surrounding neighborhood has changed. And given a 15 years to me feels like a long enough time frame that neighborhood will continue to change. And so I feel that I don't know if I need clarification on the time frame or if I would just prefer the applicant to come back with a time frame that may be shorter in duration such that the special use is not continuing to be divergent from the neighborhood as the neighborhood is continuing to expand in that area.
Okay, yeah, I certainly, I think that one of the big things for me is that as proposed, it's almost like we're just saying, well, things are basically the same. And we're just continuing. And I don't feel that, what might have been appropriate in 1990s, early 1990s, does not feel appropriate now. So it sounds like we have an overall desire to table. Does anybody have a motion? And did you have
Commissioner Gold? Oh, no, go ahead. I mean, I'm not in favor of tabling.
Right.
But
Yeah, it's Commissioner McMillan. I think there's, I don't know that there'll be a motion to approve, I guess, or a vote to approve based with the current conditions for the current application. I think it's going to be close, but would tabling to me does in this particular instance is provide a little more context as to how we ended up where we are. You know, I think it's everyone's goal, although it's not directly linked to this application, to close the cement plant. And, you know, I'd like us to get there. And this application is linked to it, you know, whether officially or not. Tabling to me maybe allows the applicant to really reconsider how quickly they can get their work there done so that we can return the site to being compatible with surrounding uses. Another 15 years right now, it just seems, it's a long time to continue something that was supposed to be expiring, you know, in a month. So tabling to me offers that option up to the applicant to think about it with staff and perhaps come up with a revised option. That's what it does. Otherwise, I guess it would move forward, and I'm not sure what our motion would be tonight, but this allows a little bit more time for staff and the applicant to provide a little more information.
It's Commissioner Renee.
Goldfarb again. Is that, and this is a question for staff, is that possible that the applicant can revise their application if we table?
This is Kim Sanchez. I do think there are a number of things that you could do. If you think you need more information in order to make a decision, then I think that's justification to table. If you think you know where you're leaning and have enough info to be able to take a position and make a recommendation, you could act tonight and then have it move forward to the Board of County Commissioners. So that, I think those are some of the framings that I would offer for you. I don't know if that directly answered your question.
So it sounds like, this Commissioner Goldfarb again, it sounds like Commissioner McMillan is wondering whether the applicant would, in the time that we table this, would reconsider their proposal and make some changes to that proposal. And I'm wondering if that's something that can be done procedurally. Is that correct, Gavin? That's what you're looking for?
You know, the information that I need, I don't know what changing their proposal would look like, but if we were to table, the information that I would ask for is an analysis based not on just something that was suggested, like, hey, we need 15 more years, but an analysis of why it's going to take 15 years to complete work there. You know, and that's the information I'm looking for. I actually don't know how it would change. Maybe they'll come back and say, hey, we still need 15 years, and here's why. I don't know what information they'd come back with, but that is what I'm asking for by tabling, or what I would personally be asking for. Just that one analysis. And I think Sam had some other items that were good.
Okay.
Okay. Well.
This is Commissioner Renee. I would be in support of a Commissioner McMillan's idea of tabling for additional time frame review.
Okay, I can support that as well. Sam, what were the highlights of you had 3 things? You're on mute.
Commissioner Fitch, there were 4 items. More information about the legal basis of the separation or non-separation of the plant and the mining. Secondly, reports in the next 2 months, maybe, about air quality and CO2 emissions. Third would be cumulative public health effects of another 15 years of the same effects, same impacts from the mining. And or the 15 years of cumulative effects of continuing the plant operations. Lastly, more information about CEMEX willingness to mitigate the public health impacts. I guess I would also say that I think that if we want to table to a date certain, we probably ought to wait until October, because I don't think the air quality and CO2 audits are going to be available in simply one more, simply tabling till the September date for Planning Commission. So
I hear that. I'm a little loath to wait that long.
okay. Then I would suggest try it for 1 month and we'll see what we get in 1 month.
Okay.
Commissioner McMillan, sorry to interject there. I would be interested in coming back in 2 weeks. I do think the information that at least I'm looking for could be put together that quickly. And, you know, I don't want to have an artificial deadline. There's a real deadline with this permit expiring at the end of September. But I think we should be able to get through it with the county commissioners before then. I think that's a goal of mine, at least. So it may be tougher to get some of the items that you've mentioned, Sam. But I think I don't want to, like you, draw this out any longer than we need to. And I'm also open to, like, if the commission doesn't feel that tabling is going to get any more information, if the rest of the commissioners don't feel that it's going to provide any more information that is going to change your mind, then, you know, let's make that known now and you know, not spend the time collecting more information that's not going to change the outcome, I guess is what I'd like to avoid.
I agree, and I also agree with your support of, or with your proposal of 2 week. See if we can get something in 2 weeks. Kim, what would we be looking at in terms of noticing and coordination of schedules? What's a realistic time frame to get another meeting?
So it's really on the time frame that you're recommending. I mean, we had been looking at what dates might be open, September 12th or 13th or 14th after Labor Day, which is September 5th. But if you'd like to come back earlier, you know, as long as you table to a date certain, we don't have any notice requirements that we need to meet. We would just post on the webpage and on agendas when the next hearing is to be held. And since we're not held to a hearing room and holding the meeting virtually, we're pretty open insofar as time. So I think all we do need to confirm is that the 5 of you that have been participating in this are available. And we also need to check with the applicant to make sure that that date would work for them as well. and I would suggest that you get some applicant, that you provide the applicant with an opportunity to give you some feedback on what you've discussed.
You mean right now?
At some point, I think before we adjourn.
Yeah, well, I meant tonight, yes. Okay, well, I'll propose Wednesday, the 31st.
This is Commissioner Goldfarb. I am not available that day. I'm not available that week. I would be available after September 1st. On September 1st or after, just FYI.
Okay.
September 7th.
You say 7th?
Yeah, I do want to make sure that if we met on the 7th, that that would give, and made a decision, presumably, that would give enough turnaround time to have a county commissioners hearing before the 30th.
And unfortunately, the 7th is the one day that we probably do have a conflict. So that's the Board of Adjustment hearing day. So we do have a hearing on the 7th. So if it's possible to look for an alternative day.
Are other days that week possibility?
I'm pretty open that week. I'll just say that.
Yeah.
Meet at 4.
And would we be looking at a 1:30 meeting then? Or do we anticipate doing it later?
I think it's up to you. We held this one as the last item on the agenda, knowing that there was a lot of public that was interested. And so people may want to attend after work hours. But, you know, you could certainly hold it earlier.
Do we need to, will we need to open public comment again? If we're just, probably will, huh?
So I think it depends on the motion. If you are asking for more information, then it may be that we need to allow the public to respond to that information. You know, so I think it just depends on what motion you end up making for your tabling.
Okay. How does Tuesday the 6th?
It's fine, other than that it's just right after the holiday. So I don't say that just for myself. I think that if we want people to participate, members of the public, a lot of people are extending their.
Okay, Thursday the 8th?
I think Thursday the 8th was where I was headed. I don't know that we need to decide right now, but I think that date could work.
Well, I think we do need to decide right now, don't we?
I don't mean, yes, we need to decide in this meeting. I just mean, I would personally like to hear, as Kim suggested, from the applicant on this path that we're going down.
Okay.
And see where that takes us.
Okay. Do we have any comments from the applicant?
We got disconnected on the Colorado side, and yeah, we'd like to respond, but we'd like to ask for 5 minutes to try to get reconnected. Is there a way we could, I realize it's late,
Sure.
It's even later here in Houston. Is there a
Yeah.
way we could ask for a 5-minute break to solve our technical issue? And
Well, I think we can maybe
reconnect our team?
we can talk about our dates while you reconnect.
Okay,
So just let us know when you're ready.
okay, thanks.
Okay. Any objection to the 8th of September? Or really what I should say is, does that work for everyone? I see a thumbs up from Sam. Gavin said yes. Chris said yes. So, and does that work for
Yeah.
you?
Yeah, yes.
Okay. I need some kind of confirmation from the applicant. Kim, is there anything else we need as far as that goes?
I just am trying to confirm with staff that the 8th works for Pete and our attorneys as well. I will not be available that day, but I think you will be in good hands without me.
Can you tell me what happens with commissioners that are not currently present that are available that day?
Yeah, if they wish to participate, they would need to listen to this whole proceeding. Everyone's been given the staff report, but if they wanted to participate in the deliberation and a decision, they'd need to listen to the public record. There'll be a recording of it available online.
Okay.
Once Commissioner McMillan, one alternative path that I can throw out there is, we could, if I'm interpreting what everyone's saying, we could make a motion tonight to recommend, well, whatever we would like to recommend with kind of an addendum of reasons as to why for consideration by the county commissioners. And I'm just sort of thinking of two different pathways that we can go. One here is we table and say, hey, bring this information back and then we'll reconsider. Or, based on the information that we have here tonight and the proposal, we feel that we can recommend or cannot recommend approval, and for these specific reasons, and move it forward and, really put the recommendation forward to the county commissioners. So I don't feel strongly about either of those paths. I think that, I personally have a hard time recommending approval of what's in front of us this evening. So
I think.
Go ahead.
Sorry again, didn't mean to cut you off.
Go ahead.
This is Commissioner Bloomfield. I think for me to get to a place where I would be comfortable taking a vote would take a lot more discussion. And so I'm comfortable with moving ahead. John, I see your hand up. Are you guys ready to go?
Yeah, sorry about that. Trying to figure out our technical problems. I missed much of what was said. So I guess my question is, where do you stand at the moment? As far as
we're discussing the idea of tabling until September 8th.
Yeah.
And Gavin can probably articulate the request that we would have from you as the applicant. And then we just like your feedback.
Okay. Yeah, I think the 8th can work for us. We appreciate all your time and effort and work and thought. And we understand you need some more information. And I think we understand your ask from us between now and then.
Can you repeat that back just so you said you understand? What's your understanding of our ask?
Okay. That from CEMEX, you're asking us for a willingness to accept some public health mitigation to the extent that can be mitigated. And the answer to the question, why 15 years, or a more, I guess, detailed or sufficient answer to that question. That's what I heard you asking from us. The rest of the questions, I believe, were directed at planning staff.
Is that Sam, Gavin, do you agree with that? Okay. Yes.
Yep. Well, I can make a motion too, but I would also just say that on the 15 years piece, I think it's important that there's some analysis of that that our county staff can review and weigh in on and provide an opinion of. So I think there's some back and forth there that I just want to make sure county staff is aware of. And I see Kim has her hand raised.
Yeah, we're having a little bit of issue. We have several people that are going to be out of the office on the 8th that are on the production side of these meetings, of running the Zoom. So it might be helpful to see if we can look at an alternative date. I'm just not able to confirm that we can get alternative help to run a virtual meeting on the 8th.
Well, do we want to go back to the 6th? Or, Anne, did you say that you were available on September 1st?
Let me just double check here. Yes, I am.
Okay. Does September 1st work for people? I see a thumbs up from Chris. Sam is good. I'm good. I guess I didn't say that. So Gavin, you're good. Kim, how does staff feel about that? Pete, I see you're on the screen. Are you good with the 1st?
I am trying to confirm.
And
looks like part of our team is okay. Pete, did you say it worked for you?
he did.
Yes,
Okay.
it does.
And John and Mark, does that work for you?
It does not work for me personally. I'm going to be celebrating my granddaughter's birthday in Georgia. But I think it works for us collectively.
Okay. Thank you for that.
And I think we're okay on the production and staff attorney side of things as well.
Okay. I just saw Conrad's hand up. Was that just an affirmative?
And just to confirm, are we talking about a 1:30 start time that day? I think that would be preferable.
Yeah, I guess so. Okay, so does somebody have a motion here? Before we do a motion, I just want to give a shout out to the 34 people that are still attending this meeting. Thank you for your community input and your willingness to stick with us on that.
Mark, did I just get a text that you are not available on September 1st?
I'll be available remotely. I won't be available in Colorado.
Oh, okay.
Okay.
Should be good.
Okay. Gavin, did I see you about to make a motion?
Yeah, sorry, I was trying to get to the language. Commissioner Fitch, I do want to make sure that I know what my one particular item is, but I wanted to make sure that I caught yours correctly. So if you prefer to make the motion, because I think you had a little more than I did, I'd be fine with that. Maybe you can state it a little better than I can.
I would, Commissioner Fitch, I would move that we table SU 220003 until further meeting on September 1 at 1:30. For the purpose of additional research and analysis as designed or as stipulated as in the last hour of discussion.
Is that enough for you, Kim?
Yes.
Liana, does that work for our motion?
Hi, this is Leanna James, Assistant County Attorney. I think it works as long as it's clear to staff. And so I think it might be helpful for staff to sort of run through a list of what we think we need. I mean, we have a clear indication from the applicant that they know what we need from them, but I think that it would be good to get a clear indication from staff that we know exactly what you'd like to hear from us.
So I have the explanation as to why restricting the Dowe, we're restricting to the Dowe Flats quarry only for part of the public record. Then the 3 items that were asked of the applicant, are there more things for staff?
I believe there was a request from Sam for county. I think we can flesh that out a little more.
Sorry, you broke up there briefly. This is Commissioner McMillan. Here's a very cursory list of what I heard. Sam, correct me if I'm wrong, but cumulative public health effects of 15 more years, how we can mitigate the public health effects, CO2 emissions and some data on that, air quality effects, and then, yes, Kim, to add to your list of separation of the 2 uses. And then lastly, and this was my request, why 15 more years are necessary to complete the work there, and really some back and forth between staff and the applicant on that determination.
That is my agreement as well.
Okay.
Okay.
With that friendly amendment, I would second the motion.
Okay. So we have a motion and a second. We will do roll call. Mark Bloomfield, aye. Ann Goldfarb.
Aye.
Chris Whitney.
Aye.
Sam. Oh, Sam looks frozen to me.
Sam Fitch, yes.
Okay, and Gavin McMillan.
Aye.
Okay, passes unanimously. With that docket item tabled, we've come to the end of our meeting. Unless staff has any other things that we need to review.
So just to reiterate for the public, the docket has been tabled to September 1st at 1:30. And we will post that on our web pages and in county agendas.
Okay. Do I have a motion to adjourn?
Yes.
This is Commissioner Whitney, motion to adjourn.
All right.
Commissioner McMillan.
Okay. All in favor, say aye.
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 All against? I didn't think so. All right. Thanks, everybody. Thanks to staff.
Thank
for
you so
sticking it
much,
out.
commissioners.
Thank you.
Thanks to the public for staying on as well, the applicant.
Commissioners.
Yeah.
Yeah, thanks, everybody.
Take care.
Good evening.